Good morning, guests. A very top of the morning to you all, and welcome to NIDAR 2025. I am your host, Manu Abhishek. No, not that one. And I will be the entertainment for today, and I will host you and guide you as to how we go on about this event. I hope all of you have had your breakfast, and all of you are ready for a jam-packed day, pun intended. So, please, I welcome all the dignitaries to NIDAR 25. And this year is very special as we celebrate 25 years of the Society of Indian Law Firms, a journey defined by leadership, unity, and a steadfast commitment to strengthening India's legal profession. So please, a huge round of applause for everybody present today with us. Now, I would request you all to please welcome our guest of honor, the Attorney General of India, Mr. R. Venkataramani, to NIDAR 25. I request our guest of honor to proceed towards this area, accompanied by Mr. Alok Kumar, Mr. Sudhir Mishra, Mr. Shadan Mohammad Sai Pillai, and Mr. Sakar S. Yadav to commence the event for the lighting of the lamp. A big round of applause as we commence NIDAR 25.
Surya Koti Samaprabha Nirvignam Kuru Me Deva Sarvakareshu Sarvada
Now I request all the guests to come on the stage and take their respective places according to the placard. I request all the guests to come up on the stage and take their respective places. Thank you so much, the guests. Now I invite the President of SILF, Mr. Lalit Bhasin, on stage to give the opening remarks. A huge round of applause for him, please.
Our worthy guest of honor, Shri R. Venkataramani, the Attorney General of India, my very distinguished colleagues from the bar, and also the academicians who represent, you see, the universities and law schools engaged in the education of law. Early morning on Saturday, I'm glad to see so many of my colleagues, so many of faculty members, so many GCs here, including those who have come from not just out of Delhi, but even from out of India to participate in this event of 25 years of the Society of Indian Law Firms. This was inaugurated in the year 2000 by none other than late Mr. Arun Jaitley, who was the then Minister of Law and Justice, in the distinguished presence of the President of International Bar Association, a lady, Diana Kemp, and also with the undisputed leader, not just of the Indian bar, but global, that is Fali Nariman, who was the President of the Bar Association of India. This decision to form the Society of Indian Law Firms was a result of deliberations and discussions among the top leaders of the law firms, the managing partners, the chairpersons, that there should be a representative body for the law firms. We have, you see, the Bar Council of India, which is the regulator. We have the bar associations spread all over the country, in the districts, in the high courts, in the Supreme Court, and also we have the Bar Association of India. But these are for individual members of the profession who are in the practice of law. There was no such entity to protect, safeguard, promote, and strengthen our law firms so that they could successfully compete with their foreign counterparts overseas. It was with this in view that Society of Indian Law Firms was formed, and then it has grown from strength to strength during the last 25 years, helping not only the legal professionals, not only the law firms, not only the universities and the law faculties, but more importantly, providing legal support for the economic development of the country. Because without legal support, Honorable Attorney General and friends like Mr. Lakshmi Kumaran, they know it. Without legal support, you cannot have protocols, conventions, FTAs, agreements, and all that. That is where the role of the legal profession, and particularly of the law firms, with their expertise. And today one can say with some daring certainty that SILF represents one of the most brilliant think tanks which is existing anywhere you see in the world. It's a unique institution. There is no institution like this in the world, I can say that with you. And now the challenges before the law firms, we have, as Prime Minister Modi said, challenges of how to meet the goals of 2047, Viksit Bharat, and more importantly, Atmanirbhar Bharat, self-reliant Bharat. That is where our responsibility as legal professional also comes in. It is not for the government to do everything. We as professionals also have to contribute significantly. And I'm very happy to say that now with our own building in place, the building which was inaugurated by the Vice President of India and the Office of Society of Indian Law Firms was inaugurated by our Attorney General only 2 months ago, you see, in Deen Dayal Upadhyay Marg, New Delhi. From this office, we hope to start, and that is our plan to put in motion in the new year, to provide pro bono legal services to the needy, the poor, women, children from the premises of our building, and also to provide full support for the activities. Online arbitration has to be encouraged. We have allocated 2 floors, you see, for online dispute resolution center being set up. These are our initiatives. So hopefully, when we celebrate the Golden Jubilee, some of us may not be there. I think SILF would stand as one of the most outstanding institutions, not just in India, but in the world. I welcome all of you to this celebratory conference to celebrate 25 years of SILF. And I thank our Attorney General and all the panelists here and the universities which are here. You see, particularly the Sharda University, who is present here, the University Alliance School of Law, and Jagran University, all who have, including last but not least the MIT University from Pune, who have all contributed significantly, not just in terms of money, but in terms of intellectual inputs for the conference. Thank you very much.
Thank you, Mr. Bhasin. Now, I would request Mr. Bhasin to felicitate the Attorney General of India with a shawl and a memento. Thank you, Mr. Bhasin. Thank you to the AG. Now, I take this time to also acknowledge the presence of Mr. Rishikesh Dave, who is the Vice Chancellor of Sharda University. A big round of applause for him as well. So with this, we will begin the first session. But before that, there are a list of rules that the audience needs to adhere to. First of all, please, I would request everybody to keep your mobile phones on silent, as we do not want to interrupt our panelists. Please do not, I would request everybody to adhere to the time limit given to them to speak when they come on the stage, because we are running on a tight schedule, so I would request you all to respect that. Please do not throw food at each other. This is not the Delhi High Court canteen. Please do not hesitate to network and make connections during leisure periods, because as Mahatma Gandhi once said, in this terrifying world, all we have are the connections that we make. Okay, he did not say that, but it sounds like something that he would say. So please be bold, please be confident, and make connections which might help you in the future. So with this, we start our first session. The session is titled AI, How to Make It User-Friendly. And I welcome all the guest speakers for the session. Mr. Alok Kumar, Mr. Sudhir Mishra, Mr. Shadan Mohammad Sai Pillai, and Mr. Sakar S. Yadav, who will conduct this session. This is a very interesting topic, as I feel that AI has taken over the world and the legal industry with a storm. And honestly, I do not use AI, but I would definitely like to know how to make it user-friendly. And for that, let us just commence with the session, and eventually we will find out that how AI will affect us with the help of the experts. Thank you. And to open the conversation, I would request our keynote speaker, Mr. Alok Kumar.
Good morning, friends. As we are 45 minutes behind schedule, I'll be very brief. And first of all, let me welcome all the distinguished dignitaries, esteemed colleagues, and members of this judiciary and other peoples here. Over the past quarter century, SILF has united India's corporate law firm under one banner. It has advocated for reforms, promoted ethical practice, and ensured that Indian firms are recognized globally. This journey would not have been possible without the visionary leadership of Dr. Bhasin. Obviously, I would be lacking if I don't acknowledge the great stalwarts like Dr. Lakshmi Kumaran, Siddharth, and all the founding members of the SILF. His ability, Dr. Bhasin's ability to bring together diverse voices within the profession to champion reforms and to represent Indian law firm in the global stage has been instrumental in shaping the SILF's legacy. Today, as we celebrate 25 years, we also honor Dr. Bhasin's leadership as the cornerstone of SILF success. Now, coming to the topic of AI, how to make it user-friendly. As we look ahead, one of the most pressing question is how to harness artificial intelligence in law. AI is already transforming industries, but its success depends on usability. For lawyers, clients, regulators, AI must be approachable, transparent, and trustworthy. So I highlighted a couple of key features which any AI ought to have. First is accessibility. Interface must be intuitive, reducing complexities rather than adding to it. It ought to be transparent. User must understand how AI arrives at outcome, ensuring accountability and trust. Customization is also a very important factor in any AI. Tools should be tailored to legal workflow, contract, review, compliance, checks, dispute resolution, and so on and so forth. There ought to be an integration, which I mean is AI should complement human judgment, fitting seamlessly into practice rather than replacing it. Ethics is a basic foundation of any AI tool. User-friendly AI is also responsible AI with safeguards against bias and misuse. Examples are already visible. AI-driven documents review that saves time while keeping lawyers in control, consumer-facing chatbots, guiding individual through complaint process, predictive analytics for litigation, strategy presented in clear dashboard. The challenges is not adoption, but design, making AI a partner that empowers rather than intimidates. Now, I'll just highlight 3-4 issues about usage of AI because this is something which is developing now. I'm sure you would have all read in Times of India, and it was in the Supreme Court, when a petitioner submitted a rejoinder drafted using generative AI tools. The filing contained fabricated precedents and twisted case laws, raising alarm among senior advocates who were present and appearing in that matter, and judiciary. While the Supreme Court chose to hear the matter on its merit, the incident highlighted the risk of unverified AI-generated content entering judicial proceedings. The episode has sparked debate on the need for strict safeguards, professional accountability, and verification mechanism to ensure that technology strengthens rather than undermines the credibility of Indian judicial system. We had the example in UK as well, where it was reported in the Law Society Gazette that the UK High Court in June 2025 issued an urgent directive to lawyers after detecting fake AI-generated citations in legal submissions. The Judge Dame Victoria Sharp stressed that the legal submissions generative AI tool are not capable of reliable legal research and reminded practitioners of their professional duty to verify accuracy. Against authoritative sources, lawyers found misusing AI were referred to regulators, signaling that such negligence could attract serious disciplinary consequences. Insofar as the Indian Supreme Court is concerned, it has introduced its own AI tool, which is called Supreme Court Portal for Assistance in Court Efficiency, and AI Saransh, to help with research, transcription, and analytics. Judges have repeatedly emphasized that these systems are only aids and must be used judiciously and selectively. We had an example whereby the Kerala High Court was the first High Court which issued first formal AI guidelines in July 2025. The Kerala High Court became the first High Court which strictly prohibited the using generative AI tools such as ChatGPT or DeepSeek for rendering legal findings, relief, orders, or judgments. On a personal reflection from my own journey, having practiced in both UK and India, I have learned that integrity, resilience, and adaptability are the cornerstone of legal practice. SILF has provided a platform for collaboration and collective strength, and its Silver Jubilee reminds us of importance and unity and advancing our profession. With this, I open the panel for other speakers to speak. Thank you.
Thank you, Mr. Kumar, for the insightful perspective on AI. And now we will hear from our esteemed speakers. Mr. Sudhir Mishra, please welcome him with a big round of applause.
Good morning, respected Attorney General, Dr. Bhasin, and my dear friends. It's a new territory for me. Dr. Bhasin decided to give me this topic. I have been only speaking about environment, climate change, ESG. But I'll take you through a story format actually, because Alok has broadly covered the concerns and what is the concern of the courts or even challenges we battle on AI. So I'm a lawyer with 27 years of practice who hardly uses computer, never used a computer, never used a laptop. But I have 45,000 followers on LinkedIn. I'm not on Instagram, I'm not on Facebook. And it's a very contradictory thing which I'm saying, that I'm half media savvy, I'm not very media savvy too. But last week I saw an interview of Elon Musk where he said that most of the people in 20 years in the recognized jobs will not be doing any job. Job will be optional. There will be no job. There is no need to do a job. What he meant was, like 100 years back, he said, people used to go to agriculture fields and cultivate their food. Nobody used to buy them on the supermarket or in modern bazaar. They used to go and actually cultivate their own food. There was no concept of buying. He said, same will happen to jobs. And I didn't understand. But then I reflected back in my own law firm's journey that in last 5-7 years, it has happened many times, especially last 3 years. So we write many articles on everything from Mirza Ghalib to any part of litigation for various platforms like Bar and Bench and Live Law, like all the other law firms. And I'll get these beautiful articles and I'll be very amazed at how beautifully they're written by some interns or young law students. I was told by my partners that they are actually all ChatGPT format. And I got corrected. And I used to feel that this is something which is very quick and how it is being done. So there are pitfalls. I think Elon Musk was hinting towards this, that we'll have lawyers, but will outsource their work to somebody else and they will have a good time. So that's fear number one of the fears. You decide that you want to have your critical thinking alive. You want to have your reading matrix alive. You want to have curiosity, or you want to just not develop, especially the younger law students and the younger lawyers who are just entering the profession. I'll ask them that our journey was, I'm quite thankful that I had to read 6 to 7 newspapers when I was preparing for civil services. I still read 7 newspapers every morning, physical newspapers, even today. And that's what gives me idea about virtually everything. And I don't think any AI can replace that. So you have to take a decision, because this has become very fashionable, what courts have reflected, what educational institutions are now saying, that the biggest challenge would be that how dependent you will become on artificial intelligence and how you will stop thinking about anything critical. On a lighter note, I'll tell you the power of AI, which I understood because the mobile is the only thing I know. When BlackBerry stopped, I had a problem to switch over to Apple, but for last 10 years, I'm using Apple. And all my typing, every work I do on phone only. I have never used, I read a lot, so that's what I've consciously stayed away from PowerPoint presentation, anything in most of my conferences. So I was going to my chambers in London where I'm a door tenant, and I go there every 3 months, and it was in October. I had a desire to see Germany because I have never seen Germany properly. I had gone to Dusseldorf 10 years back for a conference. So I thought I will go to Germany. If I'm going to London, I'll maybe go for 4-5 days to Germany. Thoda guilty hua ki maybe I should do some work also there. So I started searching on ChatGPT, is there any conference in Germany? I wanted to see Munich. So I had planned from Copenhagen, where we had some work. From Copenhagen, I was taking a train to Munich. And while going to ChatGPT, I kept on asking, finally told me that there is a ESG conference happening in Berlin. And when I got all the details, which you don't get normally on Google. I got the email IDs, I got the organizer's address, and guess who organized that? Clifford Charles, Herbert Smith, DLA Piper, together were organizing that conference. I participated in that conference, got myself registered. I was the only Asian speaker. And I still am amazed. I know the power of it, but I'm only saying we have to be very cautious. We have to have a mix and match. Also read a newspaper, also read your books. Use judiciously this entire artificial intelligence, and don't be totally dependent. Thank you.
Thank you, sir. Wow, not having jobs in the future sounds like a dream. But now I would request Mr. Shadan Mohammed Saipillai to address the audience. A big round of applause for him as well. Please don't forget that.
Good morning, everyone. At the outset, my warm congratulations to the Society of Indian Law Firms on its Silver Jubilee. 25 years of strengthening the Indian legal profession through collaboration, ethical leadership, and institutional integrity. And it is my honor and privilege to be here today to participate in this milestone event. Now, getting to the topic, which is AI, how to make it user-friendly. Coming from Chennai, I'm going to bring in my perspective from a regional law firm side of things. 2 months ago, I attended the Legal Geek conference in London. It is one of the world's largest gathering of legal colleague of ours, explain them what we want. We should be able to brief AI to say, summarize this particular document, identify the risk from this contract, redline this agreement, draft a first version of a contract. So it is important that the technology adapts to lawyers and not the other way around. If the technology can actually adapt to the lawyers in their workflow, then it becomes easier for adoption. The third aspect is trust. Trust is foundation. We can't compromise. Therefore, the technology must be secure, it must be transparent, it must be auditable, and it must be ethically governed. We cannot compromise on client confidentiality. Also, it is very crucial that the human judgment remains critical. Final opinion, the output, must always remain with the lawyer, and that flexibility is very, very critical. With any technology or any new ideas, training becomes very important. So when you talk of training, as far as AI goes, the emphasis should not be on what AI tools can do, how sophisticated the tool is. Much rather, we should be talking about how it is beneficial to a lawyer. We do not need long manuals on how the AI works. We need clarity on how AI can help us. Can it save us drafting time? Can it improve accuracy? Can it speed up due diligence? So when lawyers can experience visible value, then they would adopt naturally. The next aspect is, when you're talking of AI, it's always best not to talk of large, big transformations at the beginning. Start small and grow organically. Start with drafting assistance, clause comparisons, research summarization, chronology building. So these small wins in the areas that we are currently working will help build confidence and lead to wider usage. Lawyers can do what truly matters, which is strategy, negotiation, advocacy, and complex advisory work. AI should be able to remove repetitive work and free time so that the lawyers can do what truly matters, which is strategy, negotiation, advocacy, and complex advisory work. AI should be able to bring lawyers highest value by eliminating the mechanical tasks. And finally, and this is most critical, as I said, I had visited Legal Gig. Most of the tech solutions that they have catered to the European and the Western markets. But it is very important that the tools actually understand the Indian legal realities, Indian statutes, Indian case laws, Indian regulatory structures, and the drafting conventions. Imported solutions must be adapted and not adopted blindly. And finally, as SILF celebrates 25 years of progress, we can see that every major shift from paper files to the cloud and from computers to AI succeed when technology serves lawyers and clients and not when it attempts to redefine professional values. So in order for AI to be user-friendly, it should be simple, it should be secure, it should be practical, it should be human-centered and empowering. Thank you once again, and congratulations to SILF on its Silver Jubilee. Thank you.
Thank you so much, sir. And now I invite Mr. Sakar S. Yadav to finally give his remarks.
Respected Venkataramani sir, Basheen Saab, distinguished members on the stage, and esteemed guests here. It is a privilege to stand before this gathering of some of the finest legal minds, guardians of justice, interpreters of constitutional spirit, and architects of the rule of law. Today, I speak on a subject that will shape not only the future of our institutions, but the lived experience of every citizen who seeks justice. How we make legal technology truly user-friendly in the age of artificial intelligence. My own journey with legal technology began long before I even knew such a field existed. And as a small child, I remember sitting quietly in my grandfather's study, a lawyer who began his practice in the 1940s, watching him work amidst towering racks of law books and hundreds of handwritten pages, each line inscribed in his impeccably fine English script. Years later, my father, in the civil services and briefly as an appellate authority, he would speak to me often about the profound responsibility of decision making. And he inspired me to imagine something then unthinkable, a search engine for law. This is about 1995. That is when I had dropped out of the National Defense Academy for my passion in technology, and I wrote India's first search engine for legal database. Those early memories, ink on paper, wisdom distilled through years of practice and restless curiosity, became the foundation of my life's work. If we reflect honestly on the past 3 decades, a striking truth emerges. The last transformative shift in the legal technology occurred nearly 30 years ago, when we moved from paper books and magazines to digital databases. At that time, keyword search felt revolutionary. We progressed gradually, searching within paragraphs, then using proximity operators, and eventually experimenting with early semantic techniques, where you could find the meaning of a word that you have in your mind. As for example, you could search for poultry, and even without a proper synonym dictionary, it could give you results for a hatchery or a fish farming, or maybe an emu farming. But despite these incremental refinements, the core reality remained unchanged. We stored information, we searched for information, and we expected humans to adapt to the system. For nearly 30 years, legal technology progressed in speed, but not in character. The way we interacted with law remained fundamentally the same. During this period, we saw improvements: better indexing, faster databases, online access, e-filing, case management, cross-referencing, forward-backward references, etc. But these innovations, remarkable as they were, did not change how human beings engaged with legal reasoning. The burden always remained with the user. They had to know what to search for, how to search for, and how to navigate complexities that were never designed with them in mind. Technology, in essence, expected legal professionals to think like machines. AI, or artificial intelligence, represents the first real leap since digitization. It is not merely a faster search engine, it is a paradigm shift from retrieving information to understanding intent, from keywords to context and reasoning, from systems people learn to systems that learn from people. For the first time, technology is learning to think more like a lawyer, a judge, or a citizen, rather than asking them to think like coders. That is why AI is transformative. It changes the relationship between the humans and the law. User-friendly is a phrase often thrown around very lightly, but in law, it is not profound and has specific meaning. It is not about colorful dashboards or minimalistic designs. True user-friendliness means understanding the user, understanding the context, reducing cognitive and procedural burdens, delivering clarity and not merely data. Traditional tools drown us in information and ask us to interpret it. Summarize instead of stacks, prioritization instead of noise, explanation instead of citations. A judge does not need 200 precedents. She needs the right 5 with transparent reasoning. A prosecutor needs patterns, not pages. A citizen needs plain, compassionate guidance. Technology fails when it begins with itself. We must begin with the use cases. After extensive research and countless hours, and after observing how legal professionals actually work, we realize that every law office, no matter its size, jurisdiction, or area revolves around three fundamental activities. First, the ask, ability to ensure that the research done is proper, to seek clarity on question of law. That is the intellectual side of the legal practice. Second, interact, the ongoing engagement with one owns document, analyzing, annotating, comparing, and interpreting their material that forms the backbone of every case. And third, drafting, the creation of outputs, petitions, briefs, orders, opinions. We call it the legal aid, ask, interact, and draft. And you are welcome to experience it here today. And we are also launching US research soon without hallucination. We in India are the first legal company which has assured that we are giving you outputs without hallucination and with explainable AI. Zia ma'am is not here yet. I remember meeting her in a brief conversation in Mumbai when we had met Jensen Huang, the CEO of NVIDIA. And today I'm pleased to share that with all of that collaboration with NVIDIA, we have now strengthened a core principle that we have long believed in. The future of legal technology must be built on an offline AI, a necessity, not a luxury for any justice system. And what does this future look like? A single secure box. A single secure box, no bigger than this, dedicated solely to inference, or should I say intelligence. That is all. No cloud dependency, no external connectivity, no risk of data leakage. Imagine for a moment a judge drafting a judgment or a lawyer drafting their next day arguments on an online platform, unaware that the content is already visible to a technical operator. Wherever within your premise or technical operators or servers halfway across the world. The sanctity of judicial deliberation, the confidentiality of decision making, the integrity of case materials, all exports. Such scenario is not merely undesirable, it is unthinkable. We have seen what happens when data falls into wrong hands. The Cambridge Analytica episode is not a distant cautionary tale. It is a reminder that vulnerabilities once created will eventually be exploited. In the legal system, the cost of such breach is not privacy, it is trust. To conclude, AI is to reshape every corner of the legal world, from research to drafting, even to the global capability centers that are fast coming to India. But let us be clear, technology alone will not make legal systems better. Solutions built by tech companies may look impressive, but without deep legal experience, they will never be truly usable. In fact, we are already seeing that in today's legal AI landscape, it is easy to get an output, very difficult to get a meaningful and usable output. And when meaning is missing, users quietly disengage, they log out. As Justice Oliver Wendell Holmes Jr. said, the life of law has not been logic, it has been experience. The future of legal AI will be defined by you and not by us or any technology companies. I invite each one of you to not merely be users of this technology, but active participants in shaping the future. This is an opportunity for India, not just to adopt a global shift, but to lead a radical transformation from India to the world. Let us work together with urgency, imagination, so that the next great transformation in legal technology does not wait for another 30 years. Thank you, and Jai Hind.
Thank you, Mr. Yadav. And now, finally, on this topic, I humbly request the Attorney General of India to deliver some remarks for this session. Please welcome him with a big round of applause.
Firstly, it's a great pleasure to be part of a 25-year celebration. I mean, I am here 25 multiplied by 3, and at my age, I think, to think of my 25 years of age, I would have been jumping with joy. And in this profession, every year counts and every minute counts. So SILF deserves this wonderful standing ovation for completing 25 years, and many more 25 years. And as Lalit said, there's no other, comparative institution in any part of the world. And that by itself is a great initiative. And I'm sure every one of you who has chosen to be part of this journey of legal thinking in India. And legal thinking is not merely happening in courts. And with the introduction of the law school idea of a 5-year law course, integrated study of law, came, in a big way, the birth of law firms. And at some point of time, when critics began to say that why is that these law schools are producing people who jump into a law transaction work at not getting litigation, I used to defend the need for the expansion of law work outside the courts. And today it's become all the more important to think that courts are not the only place where legal work need to happen. Courts are the only place legal resolutions need to happen. And certainly courts not the final place where all these things need to happen. So therefore the law firms are the wonderful idea, and I'm sure with more and more initiatives in our legal thinking, and SILF will become like a huge banyan tree, and I'm sure every younger generation of lawyers would like to be in some way or the other part of this wonderful initiative. And it's a good thing to begin a conversation like this in 25 years with artificial intelligence. When I thought this box is thrown open, I thought some genie is going to jump out of this bottle. And but then some genie has already jumped out of the bottle. We have a genie and the bottle story. All of us know that. When the genie comes out of the bottle, then the intelligent person who let the genie out of the bottle would know how to get the genie back into the bottle. So we have, I think, this example is before us. So in a way, I think we're talking about this new technology, which you have described as artificial intelligence, will be like partly like a genie out of the bottle. Maybe sometimes this genie can be good, sometimes genie can be unmanageable. Therefore, we need to talk about those contents of a technology which we can manage within the technology. So that's, I think, the one way of looking at all the discussions about it. After all, a couple of years ago, I read a book, I keep talking about it in conferences, written by a former New York journalist. The title of the book is World Without Mind. He was looking at the history of how the tech giants, the whole idea of a technology giants today, Google, Facebook, so on and so forth. So the initial idea was to have an encyclopedia of all things. So the great encyclopedia of all things across the globe, collect all data, collect all information, and therefore you will be a master of data and information. And they led to a understanding how to bring in technology to be a master of all data and information. Therefore, we are in the age of data science. A data science age is, of course, will have the several facets of data science. So every facet of a data science is important for us, but then as much facets we create in data science, so much problems we also create, so much issues or challenges we create. But I think there's a part of human genius. I think human genius and evolution had not happened without we create something good, and we know where we land in, and we do not know where we probably progress. And that's, I think, human species been able to steer its course of history and look at any part of our history, any part of the world. It's also got a civilizational value. When you talk of intelligence, artificial intelligence, I think three or four things are very important. One, the integrity of anything which human species generate, the integrity of any system we develop. If the system we develop does not have an integrity, I think it's not worth at all. The second is that the core element of any profession is ethics. Because after all, when you talk of ethics, and why is that we need to have ethics? We don't ask that question. There is not beyond an utilitarian value in ethics, there is something called a very intrinsic element or value in ethics itself. Because it makes life meaningful, certain, and worth transaction. So why do we say in the law of contracts, deceit and lying are the most abominable things? So something as old as lying, So the contract law today, look at how it has grown on all these issues. Therefore, the ethical part of any system we develop. Then the other thing is this wonderful thing we have in our mind called the brain, how it has evolved. So between chimpanzee and human brains, it's only a few differences. But then the analytical ability and the thinking ability which we have been able to, nature has bestowed on us. So the analytical ability and thinking, and how much of it can be transferred beyond an agency principle to any artificial system, how much of it we can transfer. And that's a big question. As much as technology can imagine transference of the analytical ability and thinking, I think so much comes, again, the questions as to whether this analysis is open to accountability, transparency, bias, etc. So we have a lot of literature across the globe, both in the context of judicial and legal use of technology, about bias and transparency. Therefore, how much of it can be transferred? Who transfers it? Is it a market force which will govern the transfer, or something beyond the market force? These are very important questions for social policy and social governance. And finally, as I said, technology, as hearing, is supposed to adapt to legal needs which are multiple. So how many multiple legal needs we have, both in the judicial system and in the legal fraternity? And finally, I think everything human beings do, whether in economics, political, or social order, we talk about some ends and purposes. So the ends and purposes are again a product of human thinking and a human social order. And with the ends and purpose, we talk about means. Therefore, the means and ends principle, we always, in philosophy, it's a huge subject. If we look at all of them put together, I think that could be a very interesting way of looking at how we can probably have a framework for thinking, looking at this artificial intelligence issue. And all of you are well informed and probably into using the system much more than me. One of my juniors, when I was to give a speech, a farewell speech for a judge, I asked one of my juniors to give me a short notes about that judge. He gave me a short note, but I said, where did you get it from? He said, ChatGPT. I said, I am not looking at it. Please sit with me for 10 minutes. Let us put our own minds together, look at the data available, and see how we will leave a good team out of that. The products are entirely different. They're entirely different because we are looking at how human mind looks at connectivities. And the connectivity is something which I think intrinsically far more beautiful and wonderful in the human brain than probably any technology can do. I believe in that. Perhaps I can be challenged as a layman. Technology can come and tell me you are ignorant, but I don't mind being ignorant in that sense. But I think it's important for us to say that let whatever we do, if we're not able to build all these value systems into it, then, as I said, we are going to be a world without mind. And as long as we're not going to be a world without mind, our civilizational values and aspirations will be wonderful. And I'm sure that's what you're proposing to do. And SILF will continue to engage on this theme more deeply. And each one of us, of course, with our own academicians are here and heads of institutions are here. And my old friend Lakshmi Kumaran was traveled into this, from one angle to a far more, deeply engaged angles. So all of us will be part of this journey, and it's going to be a journey not for us individually, but collectively for the nation. So with that, I think I would like to congratulate SILF once again for this today's event. And I'm sure we'll end the day with more and more participants coming and the rewards being, handed over. And finally, Lalit, is a Hotel Lalit, Lalit Basin. Lalit in Sanskrit have many things, intellectual, elegant, so many things are there. The word Lalit captures so many things. So I think, and then we have Pallavi in the afternoon. We have so many people who have made the life of law firms go great for our country. And Pallavi in Carnatic music means Ragam, Tadam, and Pallavi. Pallavi is the initial refrain in a Carnatic music. So it opens up themes and ideas. So today we're opening a lot of themes and ideas for the conference. And Lalit must be congratulated for that. And thank you for all your presence today. Wonderful day.
Thank you to the AG for the amazing remarks that he has delivered. And I would now take this moment to bring to your attention that the Society of Indian Law Firms inaugurated their new headquarters at Rouse Avenue, New Delhi. And to commemorate that event, there is a magazine, Global Legal Times, which will be unveiled by the AG as of right now, and Mr. Lalit Bhasin will see to that. Now I invite Mr. Lalit Bhasin to felicitate the Attorney General of India, Mr. R. Venkataramani, with a memento. And now Mr. Bhasin will deliver the mementos, facilitate the other guest speakers, Mr. Sudhir Mishra, Mr. Sadan Mohammad Sai Pillai, and Mr. Sakar S. Yadav for the last session. To Mr. Sudhir Mishra, a round of applause, please. To Mr. Alok Kumar, a round of applause again, please. Thank you. To Mr. Shadan Mohammad Sai Pillai. And finally, to Mr. Sakar S. Yadav. I thank the Attorney General of India, and now I would request all our guests to, and now I would request all our panelists to return to their seats in the audience. Thank you so much. Thank you to all the guests, and that session stimulated my intellectuals very much. And now, hopefully, after watching that sessions, a lot of lawyers will not be quoting fake cases to the judges during court hearings. And now, before we start with the next session, I would like to tell you all what the next session is all about. It's called Charting the Blueprint of Tomorrow's Justice System, and we have very esteemed and distinguished guests
and everybody in the audience here. The blueprint for Indian judicial system, how it is likely to happen, whether you like it or not, it is going to happen. And if we happen to be a catalyst to make it happen, then it's worth it. I am not here to tell about the weight which all the judicial system is having with the number of matters to be disposed of. It is said that if there are no new filings in the Supreme Court and the High Courts, for the existing matters to be disposed of, it will take more than 10 to 12 years, if not less. It is not a happy situation. Every time we meet an investor who wants to come to India, when everything is looking nice presentation made by Invest India, and they ask a question, who is the lawyer here? Then I happen to be the lawyer. He said, sir, if there is a dispute here, how long will it take for it to be finalized and disposed of? I said, I do not know. Can you guess? I can make a guess. About say 15 to 20 years. What happens? The appetite goes. Rather now, we are putting a premium with regard to the delay in justice systems, and therefore the investment becomes costly as far as India is concerned. Now, can we live with this forever? What are the aspirations of the younger generations? What are the aspirations of the new investors globally who are coming over to India? India is inviting all these people to participate in this growth. If you are talking about the GDP growth of 7% annually, it has to maintain its level. One of the important organs is judicial systems. So what I feel is two-pronged attack need to be made, and how the judicial system can look at or look like in the future. I am not using AI tool for this. It is my own tool. First of all, how do we reduce the existing pendency in the courts, right from the district court to the Supreme Court? And the second, how do we reduce the inflow of work into the system? Both are important. As far as the disposal of the existing matters are concerned, I had the privilege of interviewing Attorney General and some judges and the presidents of the tribunals. I have taken various inputs. It is part of the note I am preparing for Niti Aayog. Something drastic has to be done. The two things which probably we could think of is, thanks to COVID, when India started the virtual hearing system, which is almost unknown to other parts of the world, including United States. When I go for negotiations in US or in Europe, I argue cases from there to Supreme Court virtually, finish the hearings and then go to the negotiations. People are surprised. You are able to argue the cases actually in the Supreme Court? Yes, we did. And sitting in your office, we are arguing matters before the Supreme Court, Patna High Court, Hyderabad or Telangana, and also before the tribunal somewhere. You need to have 3 or 4 screens and you have done it. And what has happened in this process? This justice delivery system has opened up the doors. It is not the privilege of only people in Delhi who can argue before the Supreme Court. A person from Nagpur or Mysore or Kollam can equally argue the case effectively. That is the best advantage. It is open up opportunities to everybody. And how the law firms are now modifying themselves or adapting to themselves. We are creating more chat rooms in the office. Soundproof, well lit, small cabins where attorneys can go in, log in to the various courts, argue the cases and come out and do something else. So the law firms are now transforming themselves into mini courtrooms inside the office. And complicated matters, mock courts are being done in the law firms. Invite retired judges to be the present, not invite AI. And cases are being argued by both sides to understand where we are. And the clients understand the vulnerability and they say, hey, if these points are coming up and there are no ready answers for this, etc., let us settle. So these are the things that are happening parallelly. And these virtual courts have also opened up new things. The judges need not necessarily come to the court. They can sit from their home and they hear the matters. Not a problem at all. In the Supreme Court today, very few judges look at the actual papers. They only look at their laptops or their iPads. They deliver the judgments based on that. All the pleadings are digital. They can access the file immediately and the arguments are going on. Our office has become completely paperless. We don't have a single file, physical file in our office. Entire thing is digital. All over the India, all 14 offices, we have only iPads and things, no paper at all. Save so much of paper, save so much of forests. Now, whenever you are going to increase the disposal of the matters, obviously you require more judges and more important, more discipline in the matters to be argued by the lawyers. The luxury of one case being taken 21 days, 25 days before 9 judges and 11 judges, etc., must end. Because the larger number of people are waiting in the queue. And if you look at the way in which the papers are presented before the courts, I am sorry to say, the Attorney General will agree with me, the quality of the drafts, the spelling mistake and grammatical mistakes are galore. It is just dumped on the courts. That is not detected by the defects. And when the arguments are going on, some pages are missing, some spellings are wrong, they understand simply, the lawyer says that please correct it, they also correct it. This is not the way. The time has come to say that this day, these 4 matters will be taken up. The time allowed for these matters is 1.5 hours, 1 hour or 2 hours depending upon the case management systems. And at that point of time, the hearing will take place. If one person is not available, thank you very much, give a substitute lawyer, otherwise it will go, an amicus will argue the case and finish off. By having this, the written submissions filed comprehensively, the quality of the draft which is being filed also will go up. And I must say, congratulate Mr. Venkataramani and Mr. Menon, who thought the idea of these 5 integrated courses. We have got bright young minds coming from the law schools. And they do a fantastic job. They do the legal research for the judges in the Supreme Court and the High Court is commendable. They maintain the confidentiality. They prepare so much materials. And these are the people who are going to improve the quality of the drafting before the courts. When the quality improves and the matters are now placed before them, the time allowed is fixed. Whatever you want to say, you say within the time. Rest of it will be in the written arguments. That is the only way we can matter dispose of. And I must also see that a lot of academicians are sitting here. There are important matters where the courts mention. I think law schools, they should file their own amicus briefs. Apart from the people who are arguing the cases between the parties, it is necessary for the academia to join and use their best brains available in their colleges, prepare their amicus briefs, and then inform the courts. This is what is available. So that the judges are aware what exactly is position. The two people who are arguing before them may not be looking at the larger public interest. And there are many matters coming with the Supreme Court which become final, which require this. So therefore, you need to have that balance, increase the number of judges, and the question will then come about the infrastructure. You don't have so many courtrooms. We don't have to have so many courtrooms. You can have it from your home. Or if necessary, for next 3 years, 4 years, you can have a shift system, morning 7 to 12 and afternoon 1 to 7. No problem. The judges can, the number increases, the infrastructure you don't have to increase, and the matters can be disposed of. Judges can sit at home, the lawyers can also be at home, and then argue the cases. No problem whatsoever. These are the things which you have to think differently to dispose of the existing matters. And the judges not adhering to the earlier law, referring to the larger bench, etc., must also come to an end. There must be a definite. We would rather live with not so good law rather than giving a good law which is after 10 years. It makes no difference. This is the same position as for the district courts or high courts. Same thing. Sir, while we are talking about disposal of the matters before the courts, we must also think of how to reduce the quality of number of inputs, info into the courts. That's also important. For that, the lower courts and the tribunals have to be necessarily strengthened. The functioning of the tribunals has been very well done. Some of the brilliant judgments have been delivered by ITIT and CSTAT, at that time CGAT. Some of the members have gone to the High Court and Supreme Courts also. Best brains were there, good judgments have been delivered. But of late we will find that the quality has been come down, the number of disposals are less. So maybe you have to find a solution whereby the High Court judges can be given a superintendence over some of the tribunals. Instead of a bureaucrat looking at it, the judges can look at it. Just see things are working on well. That somebody is looking at it itself will make it clear. The matters are heard in time, judgment delivered in time, and disposal increases. And this is the only way where we can do this thing. So therefore, when we are talking about the future of blueprint, I am preparing, sorry sir, not a blueprint, the white paper. We'll prepare, and I'll show it to Lalit also before, in all truth to make Venkataramani, before ultimately going to the government. But if these steps are taken, and if there is some, for example, tribunals are now administrative controls of the existing ministries. Change over, everything put together to the law ministry. This is the judgment of the Supreme Court not being followed by the courts, by the government. So therefore, bring them to judicially and form a particular division in the law ministry for monitoring the quasi-judicial processes. Improve the system of settlements. Improve the system of leniency. Frivolous matters not to be disposed of. And matters which are of paramount importance must be coming to the Attorney General before deciding whether matter to be filed appeal or not. So these are the small things which we can do, because the government is the biggest litigant in the country. You need to necessarily do something as far as reducing that particular inflow as far as the courts are concerned. Gentlemen and friends, I have a lot more things to say. I know we are already running late. My friend is already looking at me when I will finish. So I now finish at this point of time, and I hand over the mic to the rest of the people here. And thank you very much, Venkataramani, for staying over. I will again come back to you with all my suggestions, etc. I will take your valuable inputs and then put across a paper, and as early as possible present to Judges of India. Thank you very much.
Thank you, Mr. V. Lakshmi Kumaran, for the remarks and the amazing speech. And to join him on the stage now, I would request all the other speakers of this session, Mr. Ajay Bahl. A big round of applause for him, please. Mr. Nusrat Hassan. Big round of applause, please. Don't forget that. Mr. Rajesh Narayan Gupta. Please join, sir, on the stage so that we can continue with the session. To shed more light on how must our institutions evolve to meet the demands of a rapidly changing society, now I request our distinguished speaker, Mr. Ajay Bahl, to take the podium and continue with the session. Thank you so much.
Thank you. Good morning, sir. Very nice to see you here again. Lalit ji, as always, pleasure. Friends, colleagues, ladies and gentlemen, Lakshmi. When I was listening to Lakshmi, the first thought that came to my mind was the embarrassment that I had in the United States. Some years ago, we were litigating in the United States. A client of ours had been sued, an American client, by an Indian company. And we had moved for forum non-convenience on the basis that the more convenient place to litigate is India because the witnesses are here, the evidence is here. It was all cricket to start with. And I was amazed at the plethora of affidavits that had been filed by retired Supreme Court judges, senior counsel from India, saying that India is not a place where you can actually get expeditious decision-making and a fair place for judgments. And sitting in a room with, there when you're looking at it and the lawyers are looking at it and they're arguing from those affidavits, sitting there as an Indian lawyer, it is so embarrassing that our own people who have been responsible for delivering over the years between the communities, and I include our own community, it's not just the judiciary, are out there basically saying India cannot deliver justice. And I left a impact in my mind that what exactly are we doing? And now, many years later, unfortunately, as Lakshmi pointed out, things haven't changed very much. About just before COVID, I had a meeting with Mr. Amitabh Kant when he was the CEO of Niti Aayog, and I said, I want to make a presentation to you, and what Lakshmi is talking about actually became, when I presented to Amitabh, the whole emphasis was how do we reduce the pipeline of litigation. And I remember after I finished, he said, nobody's ever talked about this. I said, yes, because all along, if you see all our law commission reports, first we'll go back to history of what happened 50 years ago. It'll take, first 100 pages will be devoted to that. But it's all about more judges, more infrastructure, which is all fine. But everything is finite. How many new judges can you get? How many new people can you get? You have to reduce the pipeline of matters that are coming in. And actually, from there, the journey of Jan Vishwas bill actually came in. Before that, we had at the Company Law Committee actually decriminalized the Companies Act. And I'm just comparing, since Lakshmi talked about delays, I'll give you some statistics which I think will shock all of you. The number of criminal cases that are pending at the lower courts today are 3.75 crores. When I first made the presentation to Mr. Amitabh Kant in just before COVID, it was about 2.90 crores. So just think how many more we've added over the years just at the lower court criminal cases. The disposals on all the high courts put together every year is still short of the institutions, no matter how hard they're trying to do this. I don't know how many of you are familiar with the judicial grid, which has been introduced. I wonder if you've actually looked at it. It's a phenomenal grid. But it doesn't show you still the pendencies at tribunals like the Income Tax Tribunal, NCLT. So what you're seeing there, the pendency at Supreme Court, High Court, Lower Court, Civil and Criminal, is just what is in the courts. You're not looking at pendency of matters at the tribunal. Today, frankly, the NCLT has become the most powerful place where corporate disputes are handled, whether it's IBC, operation mismanagement. And those statistics are not even there on the grid. So if we have to really make this happen, there has to be, as Lakshmi said, and this was, we looked at many years ago, you have to first of all think about reducing the amount of litigation that's coming in. And there are various ways you can do. Start with criminal, as we are doing it, Jan Vishwas, start about plea bargaining. There are, many possible initiatives over there. The second is we need to take responsibility. I don't think any system can improve unless there is pressure by the bench on the bar and there is pressure from the bar to the bench. At the end of the day, judicial reforms in the UK didn't happen because some law lord thought about it. It was because Charles Dickens exposed what the debtors' prisons were all about, and societal pressure was there. We represent society. It is our duty to fundamentally ensure that we leave a legacy which is not just great for us as lawyers, but actually is something that the system can work on. I don't want to repeat the problems that investors face. Of course, we all have seen that every day. We are a net exporter of litigation. Today, at most commercial matters, nobody wants to litigate in India. At SIAC, we are the third largest litigant. And Indian law as the forum or the basis for process of arbitration is used in 3% cases. That means that even of the matters that Indian companies are involved, they are actually preferring to use the procedure of Singapore and other places. What is the responsibility we have to the judiciary and to the people of India? I think the responsibility is judicious litigation, honest advice to clients, all what Lakshmi said about improving the quality of what we file, willingness to reduce the number of hours we spend. That is something we have to imbibe among ourselves if we have to make things improve, and we have to encourage judges to be able to impose these limitations. We've spoken to judges. They are also human. They feel the pressure. If they tell somebody that, argue for 1 hour, there'll be 50 people who will protest from our own profession. So unless we basically ourselves decide that we are willing to do this, you cannot expect one part of the judicial system to basically impose this discipline. Perjury is hardly ever used by the courts. I mean, if you see matters that we look at, there is misstatements. I mean, people just say what on earth they want to say. It can be false, it can be misstated. There is never, very rarely will you see a case where a court will say this was a false statement and we are going to impose a serious discipline issue as far as this litigant is concerned. So unless we take a look at our own selves, and we are willing to work with the system and with the government, I don't think anything can change. If we are looking at a blueprint, what should a system of justice deliver? It should be accessible to all, deliver justice in a timely fashion, in a cost-effective fashion, and a system which should impart certainty. Today, none of that actually exists. We have matters being overruled, we have matters which are delayed, and as Lakshmi said, we have no answers when people ask us how long will it take for a matter to be disposed. Lalit is aware that when we were having this discussion about how we should compete with the rest of the world and the firms, he said it's not just about advertising, it's not just about size, it's also about the fact that if you are in the United Kingdom, you don't have to send your litigation outside the United Kingdom. If you're in India, nobody wants to litigate here, so we are sending our litigation outside. So we really need to be introspective. We need to think creatively about how we can contribute to reducing litigation. On the one hand, that is basically the demand side. And on the supply side, obviously, we have to keep adding whatever we can by way of infrastructure. And finally, we have to change our attitude, and I always give this example. In fact, when we released this whole study on for CII on how we should reduce litigation, I gave the example of this particular tendency that somebody sees the red light and jumps it, and a policeman stops him and says, "Didn't you see it was a red light?" He says, "Yeah, I saw it was a red light, but I didn't see you." So basically, that is the tendency that as long as I can break the law and there is nobody who can stop me, let me go ahead with it. So even as people, we have to encourage our litigants that there has to be a limitation on how far you can continue to file cases, frivolous cases. So it's a complex issue. You can't blame one part of the judicial system for it. You can't just make the government the beating, for just beat on the government for the being the litigant or, on the judges. We have to introspect. And I think I agree with Lakshmi that at least he's opened up this dialogue, because I think that we are generally not introspective as people, and I think as lawyers particularly, we tend to always believe there's somebody else who's responsible. And if I can sort of sum it up in one word, introspection is critical for our own self. And if we are all committed to the cause and we all look inwards, I think that's the best chance we have of creating a blueprint for something which I said is accessible, delivers on time, is cost effective, and brings in a certain degree of certainty. Thank you.
Thank you so much, sir. And now I invite Mr. Nusrat Hassan to proceed further with the session.
Learned Advocate General, Mr. Venkataramani, Dr. Lalit Bhasin, esteemed panelists, and dear friends, good afternoon. Congratulations first to everyone who's member of SILF. It's a great achievement, and I'm delighted to be speaking here and much honored. So, of course, we've heard, we all know, we do not have happy statistics when it comes to, when you look at our pending cases right from the district courts up to the Supreme Court. The numbers are, definitely not thrilling. Even our judges ratio, which is 15 to 21 per million, which is should be close to 50, is also a number which calls for great infrastructure change. Now, the question today the topic is charting the blueprint for tomorrow's justice system. So the question which we can pose ourselves, can technology and the new wave of AI can help us deliver justice faster and more efficiently, and to learn what other countries are doing around the world? So maybe we can speak a few minutes about what's happening around the world insofar as how judiciary is adopting AI. So when you look at Brazil, which stands out as a global leader in judicial AI adoption, with over 140 AI systems deployed across its court. At the Supreme Federal Court, they call it the Victor system, uses natural language processing to analyze appeals, filtering only those that meet constitutional thresholds and classifying them by area of law, drastically reducing the time spent on initial review. In lower courts, they have system which assists in case management, legal research, predictive analysis, etc. They have many other systems which they call the 4 program, which is driving the modernization and speed of its judiciary, and they are seeing realistic results. Then when you look at a small country like Estonia, what they have done is taken a bold step with the concept of robot judge. Piloting AI for small claims dispute under Euro 7,000, that's approximately less than Indian 10 lakh rupees. The system analyzes submitted documents and issues a preliminary decision, which can be appealed to a human judge, potentially automating high volume, low value cases and freeing human judges for more complex matters. Then if you look at China, China's internet courts now resolve over 90% of cases entirely online, with an average adjudication time of about 38 days. Leveraging AI for evidence analysis and blockchain for secure digital records, part of a top-level national smart court strategy to modernize justice for the digital era. In 2025, UAE unveiled plans for an AI-powered court of the future. What does this mean? This experience integrates AI-assisted drafting of judgments and case summaries, digital identity, biometric access for case participation, virtual legal support, remote proceeding, blockchain and big data integration to improve transparency and trust. The initiative is linked to the UAE's artificial intelligence strategy for 2021. Very interesting white and case survey which they carried out worldwide. Their result shows that AI adoption is just going to increase in arbitration. Then you have an AI part system like Arbitris.ai, which is transforming the arbitration landscape by providing smart AI arbitrator services that analyze all factual information, evidence, testimony from both parties, and even resolve factual disputes independently. Once a decision is reached, it is reviewed by a human before being finalized, ensuring both accountability and accuracy. So this is the human in the loop, which is basically what is everybody speaks about, where AI is not left on its own, but there is always a human in the loop. But at the same time, you have cases like La Paglia versus Valve Corp in US, which is being challenged, where the petitioner has challenged the award on the basis that the award was award written by the arbitrator had AI assisted, and therefore it has challenged the award on the basis that the award does not have the arbitrator's analysis. While this is all happening, but the fact of the matter is that if you look worldwide, there is a huge adoption of AI to be able to speed the delivery of justice system. I think what would mention should be at a recently last week when the IPDA litigation symposium, our former Chief Justice of India, Dr. D.Y. Chandrachud, outlined a visionary two-track approach to judicial administration, advocating AI-enabled adjudication for routine, high-volume, low-impact disputes, such as check bouncing cases, while reserving sensitive matters involving eviction, etc., for human judges. So today, even we are finding echo amongst even judges, etc., where they find that technology can definitely make this change. Now, when you look at how what would the future look like, I think it definitely is going to feel there is going to be a huge amount of AI, and it quite clearly we can learn from what other countries are doing, that if we apply AI, we can harness AI to be able to work for speedier and accessible justice. In fact, some of the things, of course, there is no magic solution, but there could be a smart, structured one. Some of the things which could be done is you probably need to definitely consider having buckets. Cases have to be segregated. I don't think we have made any attempt to make this into reality. The first bucket could be government litigation, which is substantial. There are countries like Singapore and UAE have demonstrated that centrally integrated AI dashboards can track even government filing, flag delays across departments, and automatically escalate bottlenecks. So therefore, there could be a dashboard, in fact, tracking all the litigation which the government could be filing and etc. And you could probably see through the dashboard how you want to be, where the government can see how they can resolve the disputes. Definitely a second bucket can be created where these are small ticket, high volume cases like check bouncing, traffic challans, where you heard, in fact, also this thought was echoed by our former Chief Justice Chandrachud in one of the conferences. Petty consumer disputes. Now we've seen Estonia resolve small claims through AI judge. China disposes 90% of such cases entirely online. India can apply these solutions to clear millions of repetitive cases, leaving our judges, of course, to do more impactful work. The third bucket we could also consider is medium value civil and commercial matters. The UK and US use predictive coding to handle millions of documents in discovery within days. India, we have our own SUPAC, already reduces research time. Expanding this tool can dramatically speed up civil and commercial litigation. I think the fourth bucket also can look at, of course, the complex cases where, of course, there is a substantial amount of judge time. But you need to be able to come to a point where there could be many more buckets, but there has to be some segregation. Definitely a bucket where a lot of these small cases could free judges' time. Of course, I think I'll probably run out of my time, but we can definitely look at embracing AI, which can create a justice system that is faster, more transparent, more predictable, and truly accessible. I think definitely we have an opportunity here where we can use technology and especially AI to try and see how we can definitely provide a much more speedier and accessible justice. Thank you very much for this opportunity.
Thank you, Mr. Hassan. And now, finally, to conclude this session, we will have remarks from Mr. Rajesh Narayan Gupta. Please welcome him on the stage.
Secretary General, Dr. Bhasin, my panelists, and members of the bar sitting here. Today is a happy day, and I hope, basis this discussion, we are able to have some happy solutions also to the problems we have been discussing since morning. To quote Lord James Bryce, there is perhaps no better measure of a government's quality than the effectiveness of its judicial system. I would like to touch upon few points which are critical. In today's world, speed is the order of the day. Everything we touch has an element of speed which is astounding. So it's given that judicial machinery has to match the speed of the current times. At the same time, courts cannot be the ATM machines. Unlike other professions, judge has to impartially decide on the complex facts with application of mind. Question is how to minimize delay and create a workable justice system which commensurate with the expectation of the litigants and the times we are in today. I recall my father, late Sri S.N. Gupta, as and when any litigant would approach him, he used to say that you get iron boots for yourself and a silver stick to myself, and then I'll take you to the court. I also heard him saying that if you will win, you will lose. If you lose, you will die. So unfortunately, this was in 1960s when I used to hear him, and today we are in 2025, and the problems which have been stated repeatedly by panelists also, I may not repeat, but the problem remains as we all know. In spite of challenges, there is a ray of hope, and nothing is lost so long there is hope. All of us today gathering here are conscious of the elephant in the room, which itself is a positive side. We are discussing the problems, so I'm sure solutions will also come. The E-Code Phase 3, as approved by Cabinet, aims to usher in a regime of maximum ease of justice by moving towards digital, online, and paperless courts through a digitization of the entire court records. Legislative reforms indicate legislative intent to address problems. As many as 29 existing social security laws have been subsumed into 4 codes, as all of us know. Further, the Indian Penal Code, Code of Criminal Procedure, Indian Evidence Act have been revamped. The Insolvency and Bankruptcy Code has replaced a fragmented insolvency system. So lots is being done at the same time while the problems exist. I may conclude after hearing my panelists and session in the morning by highlighting 7 key areas which are critical for tomorrow's justice system in India. First is the political will and also the will of the bar and the bench. India is a welfare state. Unfortunately, substantial part of the litigation is related to the government in various forms. It could be municipal corporation, it could be tax regime, it could be writs, where all the government machinery is involved. If there is a way, by taking a bold step, which could decide all pending government cases in a time-bound manner, the courts could be decongested significantly and substantially. Second is embracing technological transformation, about which much has been said since morning. Technology is a powerful enabler of efficiency and transparency, which can help in integrated case management, digital courts, data-driven governance, and artificial intelligence. Artificial intelligence has also been discussed since morning, so I won't say much. But to my mind, artificial intelligence comes as a knife in the hands of a surgeon or a butcher. It's upon us how we use it. Because if the trained minds are using artificial intelligence as an enabler, as an assistant, it is extremely useful. Whereas if we try to find and use artificial intelligence without understanding the implications and the knowledge of law, then that could be very, very dangerous, which has been highlighted since morning as to how the chat GPT produces certain results which are not right. And if the trained minds are not in a position to pick up what is wrong, it could be very alarming and dangerous. Third is promoting arbitration. Arbitration exists in the present form, which is very useful, but perhaps more can be done to encourage arbitration and also to implement arbitration process and the timelines and the arbitration which is being taken today. Fourth is promoting mediation and conciliation. Mediation and conciliation should be made compulsory in all civil disputes perhaps. Presently, pre-institution mediation is mandatory only in commercial disputes. But in future, if implemented in all civil disputes, it will change the landscape of Indian judicial system. Fifth is doing away with outdated laws. Needs to be done on a very regular basis and as a regular exercise. As we have plethora of legislation and laws, if something could be done to address this problem, that could also be greatly useful. Sixth, which is quite important in my opinion, is the contemporary legal education. I understand we have the participation of universities today, as Dr. Bhasin mentioned. The curriculum needs to include items like ESG, artificial intelligence, cyber laws, technology, data protection laws. We need to have multiple disciplinary courses such as law with biotechnology or psychology. If we are able to revamp the training and the knowledge which the students get today from university and the modern system which requires the modern approach is taken into account, perhaps that could be very, very useful. Lastly, fortifying judicial infrastructure and manpower. A robust justice system requires a strong foundation. It is important that we focus on augmenting judicial strength, modernizing infrastructure, and continuous capacity building, which also have been highlighted by the panelists. The journey to reform our justice system is not the sole responsibility of the judiciary. It requires a collaborative effort from all stakeholders, the legislature, the executive, the bar, the bench, and the judiciary. And I hope in near future we should have some solution to it. The problem is big, but I don't think it is unsolvable. Thank you so much.
Thank you, sir. We all know, as we all know, that NIDAR stands for the National Initiative for Delivery of Accessible Remedies. And for those of us who speak Hindi, we also know that NIDAR also means fearless. And honestly, looking at the schedule today, trying to get a room full of lawyers to agree on a set time limit, we definitely are NIDAR. So please, I would request all the speakers of the next sessions to adhere within 10 limits per speech. For the next 2 sessions, please adhere to the time limit. For now, we close this session, and now I invite Mr. Bhasin on stage again to facilitate all the speakers, starting with our keynote addresser, Mr. V. Lakshmi Kumaran, with the memento. A big round of applause, please. To Mr. Ajay Behel. To Mr. Nusrat Hassan. And finally, to Mr. Rajesh Narayan Gupta. Round of applause, please, as we close the session. Thank you, everybody. Now I request all our panelists to return to their seats in the audience. Now, our next session is very, very, very interesting as it examines a bold question. Thank you to Mr. Attorney General for gracing this event with his presence today. And as he departs, we start with a new session. It is called, Do We Have Too Many Laws? And honestly, I think there might be a typo here because I think we have too many lawyers, but we also have too many laws because I personally believe that. And I would like the attention of the audience to this. I would tell you a few laws and you tell me if these are real laws in India or not. For example, the first one is, you don't need a permit to fly kites in India. Do you think it's true or false? You can shout your answer. I will repeat, you don't need a permit to fly kites in India. No answers? I would tell you that this is a false statement. You actually do need a permit to fly kites in India as per the Aircraft Act 1934, which classifies kites as an aeroplane. Now the second one is, in case of a locust attack, citizens of Delhi are required to play drums. True or false? The law students there, do you have any answers? You're still studying law, right? It is true, yes. In case of a locust attack, citizens of Delhi are required to play drums. And finally, in Andhra Pradesh, you need good and clean teeth to become a traffic police officer. Do you think it's true or do you think it's false? It's true. So the state law in Andhra Pradesh says there's a specific law that you need good and neat teeth to become a traffic police officer. So there goes a career path for me. And now we will start this next session, Do We Have Too Many Laws, with the following speakers. Mr. Amit Nayak. Please, sir. Please come on the stage. A big round of applause for him. Mr. Shanky Agarwal. Mr. Ajesh Kumar Shankar. And Mr. Sachin Mishra. Please come on the stage and a big round of applause for them. Mr. Ajesh Kumar Shankar. Okay. So, without much further ado, we shall begin this session with our keynote speaker who will address the audience, Mr. Amit Nayak. I invite you on the stage to begin this session of Do We Have Too Many Laws?
I can see people diminishing. I think the earlier session was fantastic. So well done, and Rajesh, she was also here. Fellow colleagues, lawyers from the bar, my fellow panelists, and Lalit, of course, I think he's outside. But I must say that curating a topic like this is never so easy. And when I started thinking about what do I say in the keynote, I had to do a little bit of research. And that sort of startled me completely. And like I said, I don't have the eloquence of my earlier speakers, but let us try and see what I can do. You know, the question mark is so apt, but the answer is very simple, and it's an emphatic yes. You must understand that as far as India is concerned, we live in a federal structure. So the context that I want to set for my fellow speakers and a little bit of debate as well, I think ultimately, if you see our constitutional framework, we have a federal structure, we have the union list, we have the state list, and we have the concurrent list. But where are we on numbers? And I think this answers the question. The union list, of course, handles about 100 subjects. The state list handles about totally 61 subjects. And the concurrent list handles about 52 subjects. Now, these are the subjects that they handle. Now, in terms of the latest data that is available as of November 2025, and this is an astounding number, there are as many as 887 statutes at the central level. 887. That's an astounding number. 1. 2. At the state level, let's see the comparison in the width. From a state like Punjab, you have more than 1,406 legislations in play. And in a state like Chhattisgarh, you have about 55 numerically in number. So you can see the disparity. Now, what and the labor laws. See, also today, if you look at the Nyaya Savita and you look at how statutes have sort of evolved, it is very important that most of the statutes are redundant in today's day and time. And I think that's the look and feel that one must, I mean, that's the feeling that I carry, but also you must look at it very, very, it's a bad review. But at the same time, the way to look at all of this is, do we need these laws, which are archaic, which are redundant, and which have no place in today's and time and technology? So my suggestion to my fellow panelists is the following. I think India's federal structure cannot basically be changed, and it will always remain and must remain in terms of the basic framework of the Constitution. But it requires, according to me, legislative hygiene in terms of duplicity of laws. So I think legislative hygiene, to my mind, is the most important thing. As I said earlier and alluded to, there are obsolete laws. We need to do away with old and obsolete laws which have no relevance in today's day and time. If you look at the global scenario, look at UK, look at Canada, according to me, there's a clear harmonization in terms of where they are. So you need what is known as consolidation. And over a period of time, UK and Canada have shown it by way of example that there needs to be consolidation. I think labor laws is a great case in point. The Uniform Civil Code, the GST statute, the taxing statutes. You need that consolidation. And according to me, you need to strengthen cooperative federalism. That's the need of the hour. As I said earlier, we are a federal structure and cooperative federalism is the need of the hour. And I think we need to have boundaries. Clearly, my view is once you really have cooperative federalism, you are able to charter what are the boundaries in terms of state and union. And ultimately, what is legislation for? It's for predictable governance. And therefore, that is the need of the hour. So therefore, my take is very simple, that numerically, the laws are too high. And just look at a state, and this is no criticism for the state of Punjab, but 1,406 pieces of legislation in the state of Punjab. That's a very high number. The question is, what will you apply? What will you not apply? Why is there a necessity? And you look at a state like Chhattisgarh, don't go by the length and breadth of it, 55 legislations. So obviously, in the entire scheme of things, I don't think, because ultimately there's political will at all of this. How do you consolidate? How do you legislate and how do you unify the federal structure? That's really the long and short of it. My suggestions are very clear, that according to me, obsolete laws must go, colonial hangover cannot remain, and you need to really filter out that union supremacy must remain because we are a federal structure. I don't think you can change 887 statutes. That's a large number. And I'm looking at some things like Assam. Assam has 772 statutes. Now look at some like Bihar, 430 statutes. So these are all astounding numbers in terms of numericals. So I would say, what is the consequence of multiplicity of laws? What is the resultant? What's the sequitur? There's complete rising litigation on various legislations. There is no judicial discipline. As a consequence of so many legislations, according to me, there is judicial backlog. One of the reasons for judicial backlog is the multiplicity of legislations. Two, and look at it, I come from the city of Mumbai, the financial capital. Ultimately, excessive compliance is a big burden on the corporate world. And I think that's the bigger issue as a consequence of multiplicity of legislations. And ultimately, there's state fragmentation. So in my view, you cannot have this. The GST reform in 2016 really did away with that. The labor code needs to be done away with that. Now, my view is that the Uniform Civil Code, in terms of personal laws, is a welcome suggestion. And not just a suggestion, it must be implemented in its entirety. And I think Supreme Court has said so. So my takeaway is, let us not have multiplicity, let us not have duplication, let us make governance very easy, and let us have a smooth federal structure without any duplicity. That's my takeaway. To the next speakers, please.
Thank you, Mr. Nayak. Now I invite Mr. Shanky Agarwal on stage to continue further with his remarks on this topic. A round of applause for him as well, please.
Thank you, Amit, for setting the context. And first of all, congratulations to SILF for completing 25 years. While I concur with Amit, and before I go into what are my thoughts on the subject, let me also begin with a trivia. I specialize in the subject of GST, which Amit extensively referred as a reform in 2016 and 17. Now let me give some context to its complexity still. So the original CGST Act has 174 sections, which obviously have subsections and multiple amendments. There are 3 more acts which are supplementary to GST, like IGST Act, State GST Act, and UTGST Act. There are multiple delegated legislations, more than 20 delegated legislations, which is in the form of rules and regulations. There are more than 200 notifications which have been issued by the central government itself. There are hundreds, if not thousands, of notifications which are issued by the state government. Then there are circulars which are issued by the central government. There are circulars issued by the state governments, and there are FAQs which are issued by different stakeholders in the GST implementation. So therefore, that gives a context to the complexity which still exists, not in different laws, but in one single law, which is GST today. And that is why, while I agree that we have too many laws, but I think my personal view is that merely having those many laws does not give rise to the inefficiencies or to the complexity which we see. But while I feel that the complexity or inefficiencies in Indian system is arising because there is a lot of friction amongst all these laws. Again, taking an example of GST, a circular is issued by the state government which does not factor the clarification issued by central government. We have seen how frictions are created amongst different laws, between the tax laws, between FEMA laws, between the guidance which is issued by the SEBI in a regulated space. So therefore, in any M&A transactions that we do, all these frictions do come to the fore, and therefore, while I feel that India does have a problem of multiplicity of legislation, but I think the major complexity is arising because these laws are often at friction with each other, and the federal structure really complicates the things, for India. I sort of concur with Amit, and I would just like to finish it with the same thoughts which Amit had, is that there is a need to really overhaul the legislative process. I was reading a parliamentary report just for preparing this, and as per the parliamentary report, while our legislation making system has been fairly consistent over the last 2 decades, the parliament is passing about 50 to 70 acts every year, which for a country like India is not excessive in my opinion, but the excessive is delegate legislation which is happening. So many rules are getting created, and as per the parliamentary committee, only % of those rules are actually deliberated in an open parliament, and therefore and a lot of laws are also suffering because there is over delegation, and the delegate legislation is not making enough or proper rules which are totally aligned with the statute. So therefore, I feel that we should obviously remove the colonial hangover, we should codify, we should consolidate the law, but also the delegate legislation which is existing in all the laws, not only in tax laws, should be minimized to the extent possible to create the harmonious system. And I will not take much time. I will invite my next speaker.
Thank you, Mr. Agarwal. And now, finally, to conclude the session, I would request Mr. Sachin Mishra to please come on the dais and address the audience. A round of applause for him as well, please.
Good afternoon, everyone. I think from a corporate side, I am the only person in the room full of law firms. So thank you for this opportunity. And really, congratulations to SILF for completing 25 years of the journey, and many more to come. And under the leadership of Dr. Bhasin, I'm sure it will grow further. Thanks, Amit, for setting the context about do India has a many law. And the topic is very clear. Everybody can say that, yes, India has too many law. In fact, our MC also said, do we know the law for kite flying? This was an eye-opener for all of us. So yes, India has so many law, too many law. But before we ask that question, or before we know that, why we have so many law, I would ask 3 things. And if the answer is no to 3 things, then yes, India has too many law. First is the clarity. Law drafting has evolved over the period of time. From the section of people in the ministry who are drafting to the public opinion and gathering information from the industry, It has evolved over the period of time. But do we have a full clarity when the law is being tabled in the parliament that what is the impact of the law as a citizen of the India? Forget about these key stakeholder. I would not say all stakeholder, key stakeholder. Corporates, law firms, ministry, the person who is going to be affected, they know very well. In fact, they are party to the drafting as well. But do the citizen of India has a clarity of the law? That's the first question. Second is a coherence. Law which are being passed and law which are supposed to be passed, how is the coherence between the ministries or between the department before even that is being put before the parliament? Has been thought through it? Somebody has said today, the person who is making a signal, he knows that I will caught because the police is standing. At that I have to be careful. The number of law which my fellow co-panelists just mentioned about the GST and other, if we have so many laws, do we have so many regulator and the execution bodies who can implement these laws? Do they know that what jurisdiction as a regulator I have and what the jurisdiction somebody else have? If the answer is no, then of course we have so many law. Third is a capacity. Since morning we understand the data has been presented, none other than AG himself and many more people. Number of cases, infrastructure, then somebody said about the examples of Singapore and other nations. With a country of 140 crore population and democracy, you will never find such system anywhere in the world. We have to accept that we are complex. We have to also accept with the 16 written languages, we need to make a law which is understood and accepted across the India, everybody. But when the reform comes, I mean, yesterday I got a news that there is a law which is approved by cabinet and it will go to the parliament soon. Shanti. It's a major reform in the energy transition in the India. We are allowing private player in the history of independent India to enter into the nuclear energy domain. It's a major reform. But is it a reform or it's a patchwork reform? Somebody has to ask that question. When the reform, like Shaki said, GST as a one consolidated act, but so many circulars, so many notifications, so many FAQs, it lost the essence. In the end, we have stopped buying the corporate law taxman book now. We don't buy as a corporate because it is every day you see some new circular on the website, so we have stopped doing that. So patchwork reform is dangerous. Regulatory layering. We have heard so many speakers since today morning about Central Act, State Act. There are so many regulators also. And when we have so many regulators, the talking between the regulators are very important, whether it is MCA, whether it is SEBI, whether it is RBI or whether it is IRDA. Now, over and above this, as a law fraternity, we go to the court for a clarity of law or for a clarity of principles. And those clarity many a time has been given by the courts. But what happens over and above that, instead of giving clarity and getting the things easier, things become more complex and procedural when it is gone to the table or to the society. And the last point is the policy ambitions outpacing the institutional capacity. Everybody spoke about number of cases, number of litigations, and we should stop litigation. But institutional capacity is very important. Of course, virtual hearing and all those things is a good thing, but for corporates, and especially the investors who are coming to the India, as we heard in the morning, we have to know that which is the regulator whom we can go and give our way of representations. It cannot be virtually. It has to be meet someone who can understand and open the doors for us. So these are some of the points. And if these points of yes, thus India has so many laws. But if you see from a citizen's lens, there is also some of the area which we need to come out is the source of truth. Earlier, we used to have a source of truth, which is the books which is published or ministry has published so many things. The source of truth has to be one. It cannot be so many. FAQs cannot have the power to overrule what is passed by the parliament, which is happening in some of the regulation cases. Rules cannot overpower or go beyond the jurisdiction of the act itself, which we have seen in some of the regulations are actually happening. So if these things are not being dealt properly, then yes, there is a problem of understanding of the law, and so many circulars, rules or FAQs will of course come in the system. The decriminalization initiatives or some of the initiative which Indian government has taken place is really commendable, like Jan Vishwas Act being passed, labor code codifications, and digitization is a good thing which we have to really appreciate. But still, there are many more to achieve. Consolidation of so many acts, consolidation of the regulations, rules, FAQs, and giving a clear picture to the corporate is one of the most important thing. And if we can achieve that, I think as a corporate citizen, we can say that India is no longer going to be a 5-number economy. We have to very potential to become the 1st-number economy. Thank you very much for that question sharing.
Thank you so much, sir. And with that, this session concludes. And I hope that we now know the answers as to how many laws do we have, and do we have too many laws, and that must be clear in your mind because it's still a little confusing in my mind. However, now to conclude this session, I would invite Mr. Bhasin again to deliver the mementos to the guest speakers. Please, Mr. Bhasin, on the stage. I would request Mr. Bhasin to present the memento to Mr. Amit Nayak. Round of applause, please. To Mr. Shanky Agarwal. No, excuse me. And to Mr. Sachin Mishra. A group photo, please. And now I request our panelists to return to their seats in the audience. And I would like to personally remark that I feel the energy of the room is dipping a little. So if I've not made myself clear, I am Manu Abhishek, not that one. I'm a stand-up comedian, if you guys did not know that. I'm not only an anchor. And with that, I would try to lift your spirits up. So I would request you to laugh when I tell the jokes. This was not a joke. And as for the interns and for the law students who are here, I expect more energy from you because you're young, you're wild, you're free. So please, please, I know you're not allowed in the Delhi High Court canteen, but that does not mean that you cannot exhibit your energies here. And because we have a room full of corporate lawyers today, I have a special joke for corporate lawyers. This one time, a corporate lawyer died and went to heaven, which is highly unlikely, but he went to heaven and he said that there must be some mistake. I am too young to die. I am only 52. So the guard at the heaven's door said, no, there is no mistake, because it says here that you're 85 because we also included your billable hours. And so that was a joke on corporate lawyers, and I'm not sure. Do we have any litigation lawyers here? I'm a litigating lawyer, to be honest. And do we have any more litigating lawyers in the house today? Many litigating lawyers. So I have a message for junior litigating lawyers. and who are, because as we know, junior litigating lawyers are always one impulsive decision away from quitting their practice. And if by the age of 35 you do not have the following, you should quit your practice: a freehold property in your name, 2 bald spots on your head, highly functional alcoholism, a client with at least 18 contempt proceedings against him, a really shady source of side income only your clerk knows about, clinical depression and crippling anxiety, and a loaded gun in your car because just in case. So if you don't have that by the age of 35, you should quit your practice, and that is why I have quit my practice, because my hair are growing long. And while we are setting, there's also a movie screening which is going to happen. I'm sorry to disappoint you. We will not be screening Dhurandhar. That is not the point of the event. And if I wanted to see 5 men speak for 4 hours, I would log into any Supreme Court live proceedings. But we're going to be screening a movie soon. But before that, I have one more joke for you. It's a glimpses. It's a select highlights from an 11-episode series called Legends of Law. It is more, yes, that I have also written it here. It is more interesting and important than Dhurandhar, of course. One last joke before we have finally set up for the movie screening. So I'm sure that I hope all the legal interns, law interns here do research, and everybody in our field, we have to do research at all times, and we use different various tools for it. But I think all the research tools can be described, and every lawyer has 3 different kind of research tools, or 3 different kind of partners in their lives, as I would say. First, SCC Online, which is like a new partner, modern, good looking, has everything that you're looking for. You can show it to anybody, Supreme Court judges or High Court judges, and they'll all be impressed. Not a lot of people can access at the same time. Manu Patra is like your wife or husband, your spouse, your first love, but kind of old now, doesn't look too good, and it's very confusing sometimes. Might have multiple users as well. And finally, Indian Qanoon, that one hookup you keep going back to when everything fails. You are ashamed to show it to anybody, but people still accept it sometimes. So that is what Indian Qanoon is. That's the kind of partners a lawyer always should have in his life, in their life. So with that, I will be back with more jokes. I have work to do. And with that, we'll start with a very important screening of, this is a 11-episode series called Legends of Law, featuring different stalwarts of the legal industry, such as Mr. Fali S. Narman. It's okay, sir. So start the screening movie now. And it is directed by Mr. Aditya Bhasin and produced and by Mr. Aditya Bhasin for SILF.
Future generation of lawyers becomes less commercial minded and more service minded.
I would like to write about why and how, because I have been witness to the collapse of the judiciary, of the independence of the judiciary.
In an education system which is regimented, you can never recognize that strength. So participative education is what is required.
Controversial films came to us like Rajniti, Urta Punjab or something like that, and many films from South India about Indo-Lanka fishermen cases you see, and all how the fishermen were depicted in India and in Sri Lanka, which were all opposed by the government. Government had supported that these films should be banned at all. But we took a view that no, this is absolutely correct. This is the reality of the situation.
Let's assume that a woman consents on marriage to have sex. That is stating the obvious. The question is, does she consent to violent sex? And let me tell you, all force is violence. Does she consent to that? Does she consent to brutal sex? She doesn't.
What is the message we are going to give to future generations? Are we going to give them message of hatred, or we are going to give them a message of love? When history is written, what will be written about us? So I think these are issues on which I am really sad to say that Prime Minister Mr. Modi, who is so popular a leader of the country, is just remaining silent.
કે ચાલો સમયને પૂછીએ અકબરનું શું થયું. Let us ask the great lord of time what happened to Akbar. Akbar was his name. ચાલો સમયને પૂછીએ અકબરનું શું થયું. કબરોમાં ક્યાંય એની કબરનો પતો નથી. In the graveyard, in the cemetery, we see so many kabristan. But we can't find the kabar of Akbar.
But lawyers, more than anybody, any other profession, will have to ensure that they maintain the very highest standards of integrity and rectitude.
Teachers, the teachers, poor chaps, are never treated well.
Right.
And unlike the professors in America and England, where they are looked upon as academics of great quality. In fact, I was very keen that an academic who was not a practicing lawyer should be appointed to the Supreme Court. But somehow, when I told Justice Venkataramani, who was Chief Justice, he disagreed. He says that no, a person who has to practice, and once he practices, only he is fit to be a judge of the court.
It is not the top leaders that misguide people. It is the susceptibility of a human being, his intellectual, neural susceptibility to be swayed away in an unthinking way, swayed away by a hero worship, ideal of hero worship, an ideology for a religion, for a cause, for a slogan, sacrifice his life for that.
I didn't count them, but it's such a crowd of monkeys. The judgment was on a Saturday, especially sad. Sunday night, maybe about 7:30. A lot of monkeys were coming. It's all coincidence. We also attribute the hand of God.
5 out of 5 stars on Letterboxd from me. And now, please subscribe, watch on YouTube and Spotify. And now we're moving towards our final session before lunch, which is called Academia Practice Convergence. And for this, because we are moving on to this session, this is where we bridge the gap between the law school, which has taught us justice, equity, and reform, and what practice actually is: adjournments, high court coffee, and trying to find a PDF which converts Word to PDF. For me, it's ilovepdf.com. But it's time to connect these two worlds, and we begin by inviting the speakers on the stage. I invite Mr. Professor Rishikesh Dave, Dean of Sharda University, on stage right now with Dr. Purnima Imandar, Dr. Mukul Saxena, and Dr. Sachin Rastogi. Please, a huge round of applause for everybody as we begin the final session before lunch and before the Chief Minister arrives. Thank you. And for the keynote address now, I invite Professor Rishikesh onto the dais, and he will take on and address the audience. A round of applause for him.
Thank you. First of all, congratulations to Society of Indian Law Firms for completing 25 years. And I thank Mr. Lalit Bhasin sir for giving us academicians a platform at this particular stage where most of the time it is predominantly dominated by law firms. So I will take this opportunity, I will grab this opportunity to discuss something which is very important, not just for the law schools, but also for the law firms. Let us talk about something we all know but rarely say out loud. You only hire from NLUs. And look, I get it. I really do. The students are smart, competitive, and with a brand name stamp of approval. It's a win-win state for the recruiters still there. However, the game changes drastically ahead. It's a worry that keeps me awake at night. We are losing them. Frankly, it should worry you too. However, here is a paradox I want to explore today. Even your hand-picked NLU graduates need 2 to 3 years of intensive training before they are truly practice ready. They may not know how to draft shareholders' agreement. They have never negotiated what is with an opposing counsel. Many have not encountered a due diligence checklist. And in emerging areas like data privacy, ESG compliance, crypto regulations, they are learning alongside everyone else. Hence, it is important to prepare and orient them to the climate of being practice ready. Let me share an incident with you. Last year, I had a coffee with a managing partner who told me something shocking. His firm recruited 27 NLU graduates, and within 1 year, only 7 remained. Over 50% of the fresh recruits at top law firms leave within 2 years. He looked exhausted just by talking about it. We are spending crores, he said, and they are walking out of the door. This is reality of today and hence the truth of the present. Thinking about what that means, you are investing lakhs per associate, recruitment, training, partner time, associate time, and the whole ecosystem adjusting to them. Then they are gone. You start over. This almost acts as a loop. Here one hopes to find the best asset, but before they turn into valuable resource, they walk out of the door. So here is my cardinal question. If you are investing millions in recruiting and training premium talent, only to watch them walk out of the door, why aren't you investing upstream? Why aren't you at that point where legal minds are being formed? Why not help shape them before they even walk through your door? Why not give them needed sense check for being future ready? Let me share with you a conversation I had last month, something that was an eye-opener. A talented lawyer from Nagpur, 7 years of experience, smart as they come, applied to a Mumbai law firm. They rejected him. The reason? He doesn't know how to structure a cross-border transaction. Here is the thing. He never had a chance to learn. His law school had no connections to practice. His professors, brilliant people, but never set foot in a transaction room. He graduated, started practicing locally, and now he has been told that he is not good enough for the top firms. And that is a harsh reality surfacing the time when actually no one would want to stabilize in professional space. And when I talk about NLU graduates, they are arriving unprepared too. Maybe with better fundamentals, yes, but they don't know how to draft an agreement. They have never negotiated with a client. They burn out because the shock is too severe. It's certainly alarming to see unprepared law professionals at work with apparatus less developed. This is not just your or mine, but everybody's problem. Because when legal education fails, we all pay the price. It becomes a systemic issue. So I can anticipate your inner dialogue over here right now. Why law firm? We are law firms, not educational institutions. We don't have time for this. But hear me out on this business case, because it's compelling. One leading firm runs a residential program with a top law school. Students spend 6 months embedded in the firm before joining full-time. The result, these associates stay. Why? Because they knew what they are signing up for. No cultural shock, no surprises. They arrive practice ready, and they stick around. When you engage with education, you are not being charitable, you are being smart. You reduce the training time, you improve retention, you get people who understand your firm's culture the day before the day one, and you save crores in process. Plus, let's be honest, your clients are getting more sophisticated. They don't just want lawyers who execute, they want thought leaders. When you collaborate with universities on research, when your partners teach, when you are shaping the conversation in the emerging areas like AI regulation and climate finance, there's a brand equity. That's what gets into the room when the next big opportunity comes along. Legal professionals who are familiar with challenges, equipped decision makers and problem solvers, one who do not emerge as legal professional, but rather an effective legal profession. So what can you do? Let me give you 4 practical models. Just 4, not 7, not 10, that you can implement right now. First, send your people to teach. Not just get lectures, actual semester-long courses. Partner with law schools. Have your merger and acquisition partner teach mergers and acquisitions. Your IP specialist teach patent prosecution. The way they train and get trained. It's a 30-40 hours a semester. In return, you get 50 or 60 students who have been exposed to your firm's thinking, your standards, your culture. When they apply, they know what they are getting into. When they join, they stay longer. Second, strategic event sponsorship. Stop writing just checks for moot courts. Actually show up. Send partners to judge. Give real feedback. Offer internship to the winners, not generic one, but targeted one. A student who argued a complex arbitration problem, put them on an actual arbitration matter. That will give them real life acquisition. This works brilliantly at non-NLU institutions. Sponsor a moot at Tier 2 college. You will be the only top law firm there. Every student will remember you. And you will spot talent your competitors never see. Third is faculty internship. This one is radical, but hear me out. Bring law professors into your firm for 4 to 8 weeks. Let them shadow your team. Let them see how deals actually work, how clients actually think, how practice actually happens. When they go back to teach contract law, they're not just teaching theory. They're teaching this is how force majeure gets negotiated in real deals. This is why indemnities matter. This is what happens when drafting is ambiguous. You are essentially shaping the education your future recruits receive, and you are creating faculty allies who understand what you need, hence creating professionals who have better orientation in real workspace dynamics. Fourth, create embedded semesters. This is a gold standard. Partner with a university to create a semester where students work at your law firm for credits. They are in your practice groups, in client meetings, in trainings. You get months-long assessment period. They get real experience. When they join full-time, there is no adjustment period. They've already lived it, and they stay because they chose this path with open eyes. It's an informed choice with voluntary participation that they make, hence a lesser attrition rate. Now, here is where I'm going to challenge you, and I hope you will really hear this. Are you ready to acknowledge the critical importance of developing sustainable systems of legal markets and working for the same? I know, there are excellent institutions, the NLUs, but there are 1,500 other law schools in India. Some are really good. And here is what we are missing. Non-NLU students bring something special. They bring hunger. They bring the need to be seen and heard. They bring the urge to be equal and hence the desire to prove. Let me be really honest with you. When an NLU graduate joins your firm, it's one option among many. They have offers from 3 other top firms. They know if it doesn't work out, their degree will open other doors. There's the comfort in that. Sometimes even complacency. But when a non-NLU student gets an offer from a top law firm, that's a one-in-a-lifetime shot. They know how rare it is. They know their degree doesn't automatically open doors. They will work harder. They will stay longer. They will be more loyal. Not because they are better people, but because they understand the value of opportunity, the value of something they have always desired for, and that they wish to accomplish. I have seen this. Firms that take chances on exceptional non-NLU talent often find these individuals outperform expectations. Why? Because they have everything to prove and nothing to be taken for granted. From a business perspective also, this is gold. High retention, greater loyalty, harder work, more gratitude, this translates to your bottom line. So imagine this. Your office adopts a law school. You sponsor their moot. You offer internships. You send a partner to teach 1 semester. You are the only top firm paying attention to them. Every student, they will remember you. And you will find talent-hungry, dedicated talent that your competitors are completely ignoring. Right now, you are fighting over 2,000 NLU graduates. Half of them would leave within 2 years. Meanwhile, they are brilliant students at non-NLU colleges who would give you everything because you are giving them a chance that they thought it would be impossible. You provide them with opportunities that are intense and easy to perform than ones that are entitled and hence not very sustainable as a part of the system. The choice is before you. I can truly see that your questioning mind, the rope walk for you. I know you're busy. I know you have billable hours and client demands partnership pressures. I know adding one more thing feels overwhelming. But here's the reality. What you are doing isn't working. Hence, change the strategy. You're losing half of the recruits within 2 years. You're spending crores replacing them, and you are stuck into this endless cycle. Recruit, train, lose, repeat. This is not a recruitment problem. That's a system problem, and you are uniquely positioned to fix that. So the question is very simple. Will you be part of transforming Indian legal education, or will you keep on doing what you have always done and hope for different results? Are you ready to do things differently? Are you ready to contribute to cardinal focus of partnering with legal institutions, and to raise your standards high by placing opportunities for non-NLU students. The opportunity is here, the need is urgent, the choice is yours. We are here for you to scaffold at every step. Believe in us, believe in you. Thank you.
Thank you so much, sir. And now I would invite Dr. Purnima Imandar, Associate Dean, MIT, WPU, to address us. Thank you. A round of applause for her, please.
Thank you, Dr. Dave, for setting the context. Vidya dadati vinayam vinayat yati patratam patratvat dhanamapnoti dhanat dharmam tata sukha. Which means knowledge gives humility, humility brings worthiness, worthiness leads to capability and through prosperity flows rightness and lasting fulfillment. This ancient Sanskrit wisdom beautifully reflects why education must be tied to practical ability and ethical purpose. Good afternoon, everyone, distinguished guests and fellow legal luminaries. Today, we come together to celebrate 25 remarkable years of SILF's journey, an extraordinary legacy shaped under the visionary leadership of Dr. Lalit Bhasinji. I am honored to speak on the theme Academia-Practice Convergence, a cornerstone for the future of our legal profession. Bridging the divide between legal academia and professional practice is essential for producing lawyers who can think critically and act effectively. Convergence demands the integration of rigorous theoretical knowledge taught in classroom with the practical skills shaped in courts, law firms, and legal clinics. It's a journey of students from classroom to courtroom. As former Chief Justice of India, Justice Chandrachud observed, law schools must be the crucial where theory meets. Equally, Justice V.R. Krishna here believed that law is not a trade, not briefs, not books, but the spirit of social justice. This spirit can flourish only when academic insights meet practical exposure. Capturing the essence of why practice-grounded learning is indispensable, yet traditional legal education often remains heavily doctrinal, leaving graduates unprepared for real-world challenges such as client counseling, negotiation, drafting, and courtroom strategy. This theory-practice gap affects not only legal education, but the quality of justice itself. Also, academic curricula with practical experience creates well-rounded professionals capable of interpreting the law and applying it meaningfully. Though challenges persist, different priorities, limited time, funding constraints, and institutional inertia, this can be overcome through co-designed curricula, mandatory internship, strengthened legal clinics, moot courts, and continuing legal education programs that unite academics and practitioners. Successful models such as trial advocacy, client counseling, mandatory internships, moot courts, contract drafting, court tribunal visits, novice competitions, workshops on arbitration, mediation, conciliation, legal aid clinics, and the Bar Council of India training initiatives show that such collaborations enrich learning and elevate professional competence. In a sense, academia-practice convergence is not simply desirable, but imperative for shaping lawyers who are both analytically sharp and practically grounded, capable of upholding justice with sensitivity and strength. Let us commit ourselves to building this bridge so that our profession remains robust, relevant, and responsive to the needs of society. In aligning with the above-mentioned thought at MIT World Peace University, we strive to provide holistic educational and clinical exposure to our students through various unique initiatives under the dynamic leadership of Dr. Rahul V. Karar, who is a firm believer that the student should be physically fit, mentally alert, intellectually sharp, and spiritually elevated. Lastly, I would like to conclude with the one couplet in Hindi. जहाँ सिद्धांत और व्यवहार का संगम होता है, वहाँ न्याय अपनी पूरी चमक में दिखता है. जहाँ सिद्धांत और व्यवहार का संगम होता है, वहाँ न्याय अपनी पूरी चमक में दिखता है. वकील वही सफल कहलाता है जो किताबों को जमीन की हकीकत से पाता है. थैंक यू वेरी मच. जय हिंद, जय भारत. थैंक यू.
Thank you so much, ma'am. That was very fierce. And now I invite Dr. Mukul Saxena, Director of Alliance University, to further elaborate on the topic. A round of applause for him as well, please.
A very good afternoon to all of you. And indeed, it's a pleasure to be here and to talk in front of the august gathering. I must admit that the academia industry interface, I make part of it because I won't say, because I was in the armed forces for 20 years before I shifted to academia, but I wouldn't say that will become an industry rather than a service to the nation as much. But let me begin the thing. I mean, whenever you speak of academia industry interface, you know, we speak about the most important caveat that goes is solving real problems. Let me begin with one more context. It's not just solving real problems, but also solving, to be prepared to solve future problems. I mean, it may look emphatically kind of big, but let me explain to you, and we had the first session which says, how can AI be human-centric? And let's put the other way around and say, how can human, mitigate the risk of being AI-centric? It's quite a bold statement, right? But I'll give you two examples. So in January last, Economist comes out with a bot, Scottus US bot. It creates a software which is going to predict Supreme Court decisions. I just give an example of one such judgment on birth citizenship, and the Scottus bot gave the prediction of the judgment 7-2, which was just as close as the actual judgment, right? Now let's take another example, why I say we need to prepare. By the time my graduate student moves out, it will be 5 years from now. So about 2 months back, I was reading an article which came out, which said that Anthropic included a Claude 4 model and did a simulation of a Claude 4 model. And they said that it gave fictitious emails and they simulated the experiment on the Claude 4. And there were two things they found out. One was one of the executives was having an extramarital affair. And the second was that one of the executives had given the instruction for the system to shut down. What happens next? The simulated experiment showed it is the system that goes back to the executive and says, if you shut me down, I'm going to disclose your extramarital affairs, right? Now let's look at the third challenge. I think we need to really prepare for it, right? So January, Economist comes out with a paper and says, climate change is one big business opportunity because the Arctic ice is melting. And the moment you say Arctic ice is melting, which means more amount of traffic and shipping across the Atlantic, but ice is going to melt, and that's going to be a challenge. Now for me, the question is, as all academicians, all of us, is how do we prepare our students, right? That's why I made this caveat in the beginning. It's not about preparing students for real life challenges, but also preparing students. And that's where this interface becomes important. For us, we can go ahead training minds, but until you have the interface with the industry, just way to look at. But I promise we look at these institutions, when you look at our students going back, there is a huge amount of requirement of how we train our children, our students, right? So Alliance University in August presented this concept at the European Conference on Education in London, saying that do we need to depart from the traditional model of education and make it more participative? And the fundamental premise that I know all my law students and everybody will know was we follow the structured Bloom's taxonomy, right? Which has only two kind of variation, two angles to our graph, which is two-dimensional, which is knowledge and cognition. And our university, we first moved on the idea why. If it is about equity and justice, then should social inquiry to the reality of the situation, understanding of the world problems, be integral to this taxonomical structure, and you have social inquiry as the third component. And therefore, when we are trying to prepare, I think the holistic idea of preparing students is the understanding of how to approach the problem. I'll give you this example. I know I'll have less time. I know I'm very conscious of time, but I'll just give you one. When when this AI model came and said, you shut me down and I'm going to get the extramarital affair out, the question was who was accountable. Well, I'm not the great Instagram person, but I know there is a big, there is a kind of a story going on Instagram. They say the son saw how to die, and the chat GPT told that that is the way to tie the knot, and you hang yourself, right? For me, my challenge is to make my students understand how you approach it. Because jurisprudence per se will just take you on law and morality, but is there a context of hybrid jurisprudence now coming into play? So that's the way I will look at it, and I think that is where our education system needs to look, and when you look at how real world challenges and future challenges will come into place. And that's a question of how to approach and make students future ready. So one of the way is academic teaching in subjects are skill integral, or your learning of skills or developing of skills integral or rather intrinsic to your academic teaching. So if the subject of jurisprudence is there, I will understand my student will have the skill knowledge of analytical thinking and critical thinking, or it is time to prepare our students to be aware of how to develop their skills. And therefore, when a university presented in London this idea, we said no, the skills are not necessarily integral to teaching, because I may teach you A, B and C subject, but you will never know the skill. If I am asking you reflexivity or critical thinking, I expect you to know what you know in the 5th semester to be able to even connect with 1st semester. You know, that's what I'm just putting a context of what critical thinking is. And therefore, our premise was true, and I think that's the way the university we propose, and we move ahead to make a better interface of the real world understanding of problems. I said Arctic ice, going from here, going to the Scottish experiment, was that firstly we need to be making our students conscious of the social problems. One, it may look very cliched, but the kind is how do you do it? And that's what, sir, in this beautiful documentary, you give us a glimpse. I think Kapil sir said about participative education, you know. And what is participative education if you ask today from us? Participative education is giving students the autonomy as a subject of study. Make them the subjects and decide. Maybe you may have courses to go across semesters and teach them what to know about problems. So when you look at academic and industry interface, the education sector has a greater, and the owners of a larger responsibility, not only to train students to be prepared for real world problems, but be able to go and contribute effectively to understand what future challenges would come up. How? I know one of my distinguished speakers was speaking on ESG and India's commitment in COP30 and coming up. And we looked at, for example, emissions. We look at scope 1, 2, and 3. Can my student look at the concept of which is the promulgated scope 4 and 29? Can my student actually speak on it and deliberate and give a coherent judgment on what scope 4 would be? I'll just tell you one, and I say there were many laws here, and I was thinking how my students would react to it, right? So the right to education is a fundamental right. And so we did a study at the Center of Excellence to say why girls still drop out of education. And that's the time when we wanted our students in the legal field to understand that there is a very strong influence of laws, of social norms and culture on them. You know, somebody asks you, what will you do? I have to go back and help my mother in class. And they are true problems, and that's how we think the education would grow, thus contribute not just to the industry, but also to the society. Thank you so much.
Thank you, Mr. Saxena. And finally, to end the session, I would like to invite Dr. Sachin Rastogi, Dean, School of Law, Jagran, Lake City University. Please welcome him on the stage.
Thank you so much. At the outset, I would like to congratulate SILF for their 25 years and their contribution towards the legal fraternity. And yes, from here I can see that the majority of the crowd represents the law firms and the litigations and the corporate firms. I believe that you have not been into a habit of being addressed by academicians since you all graduated, but I hope you can still bear with us. The topic which I have been asked to speak upon is of great relevance, especially when we are talking from the perspective of academia. This is something which is the most talked about topic in the academic galleries. Yes, academics and industry convergence. Because ultimately the students who are coming out to us and are looking forward to obtain a law degree are doing this for employability. And if we as institutions could not prepare them for the industry, somewhere or the other they fail and ultimately we fail. Because if my students after getting graduated are not getting what they desired of, then somewhere or the other we need to look back and find out the missing links. So one thing which we often observe, and I believe that all of you when you graduated had the same views in your mind also, how to go ahead. Because when we graduated, we haven't heard of law firms. We only had heard of courts. And the only thing where we were supposed to go was the courts. But today the dynamics of legal industry has changed. We are no more limited to courtrooms. We have moved out to corporate boardrooms. We have converted ourselves into legal firms. And moreover, we are no more national level players. The world has become global. So we need, because somewhere or the other, the burden is on us also as academicians that yes, we need to prepare students who can compete at the global level. I still remember when I was a student, the only thing which I had in mind was, after doing my law, was to go and practice in the court. And at that time, what we really missed was that we had least exposure to the court. I know nothing about the court because I have been strictly following my timetable, attending classes and going back home preparing for exams. So that practical side was missing, and which happens with almost all the students of our time because those were the challenges at that time. But today, with so many things going around in the legal fraternity, our students are also looking for a practical exposure. And as recruiters, you are also looking up to students who are, if not well trained, at least they have the basic training. Now here comes convergence. You have certain expectations from us, we have certain expectations from you as recruiters. Somewhere there is a need to collaborate. We need to come together. Why? Because if we are not able to produce industry-ready students, their employability will affect, and ultimately, you will be providing them the training ground. So if we can do that before they reach out to you, it would be a win-win situation for all three of us. We as academicians, they as the ones looking for an employment, and you as a recruiter. And that is why we need to collaborate. This collaboration between academia and industry is very important, either in the form of internships, which all of you are doing. Thanks to all of you for offering internships to students. But we need to go beyond that. As one of my fellow panelists mentioned about faculty exchange also. Yes, we need to train faculties also. We need to have more guest lectures also, because every day some new topic is coming up. My fellow was talking about AI. I hope that most of the academicians, when we did our graduation, we have never heard of AI. So it is all something new for us also. So we also need some training for that. So this collaboration is very important, because earlier what we used to see was when we go to the court and we used to come back to our professor, sir, what you teach in class appears to be totally different from what is happening in the courtroom. Yes, this actually happens. So the convergence is very important. We have to come together. We need more exchange from both sides. And from this platform, I would request all the people sitting over here that you should extend more collaborations to academic institutions so that we can train the students in a better way and you get a better product, whom you need not to train again. So you know that yes, he has the basic understanding of how things are done, how our contract is drafted, how a plaint is to be filed. Because what we are giving is more of a theoretical side. But yes, I'll applaud the academicians also for this. We have changed our approach a lot. Now the emphasis in academics is a lot on practical training. The academicians are now conducting a lot of workshops, hands-on training. Even the question papers, the assessment pattern has changed a lot. Now the assessment pattern has been shifted from theoretical to hypothetical, situation-based. But there is still more to do in it, for which we need the collaboration of everyone sitting over here. I am here representing the Faculty of Law, Jagran Lake City University, and we have already imbibed this convergence in our vision, because our vision talks about the practical approach. And this word industry ready and future ready is of great relevance. One of the 4 pillars on which JLU stands is the industry centric approach. So we need to focus a lot on how the industry and academia go together. So before I conclude, I would like to end with the following verse. When academia and industry converge in law, knowledge becomes actionable, innovation becomes ethical, and justice becomes more accessible. Thank you.
Thank you so much, sir. And I would now, to conclude this session, I would invite Mr. Lalit Bhasin to speak a few words about the topic. A round of applause for him. Thank you.
It is a privilege to speak in this particular session because the universities, the law schools, they are virtually the creators of our legal profession. Therefore, greater emphasis has to be given so far as the field of legal education is concerned. And I can say with some daring certainty that our universities, our law schools are second to none in terms of quality education. What is required is that we need to give full support. They by themselves can educate someone, but to make them practice ready, I think the responsibility also is on the profession, whether they are litigation lawyers or you see, they are the law firms. We have programs under SILF members. They encourage law students to come and intern and go to the courts if they want to become litigators. They work on the corporate side if they want to do corporate transactions and all that. Therefore, those avenues are available. And SILF has always played a very important role in promoting legal education. But there are certain areas which need to be focused on. For instance, there is less emphasis on legal writing, because someone commented upon the drafting part of our laws and all that. The skill has to come from the law schools. Skill of drafting. In USA, it is compulsory. It's one of the mandatory subjects that you should have something on legal writing. We have abundance of moot court competitions. I think we should have some competition in essay writings, you see, thesis or whatever it is, some to encourage and promote legal writing. Another thing is, which was commented in the earlier sessions, about this huge pendency of the cases that we have. People are talking about litigation, that with 5-6 crore cases. People are talking about arbitration, which has again failed to take off in this country, because if two corporate bodies have a dispute, they would rather go to Singapore to have it arbitrated upon rather than in India, because of essentially two things. Someone asked, what are those two things? I say, judges and judges. They say, what do you mean? I say, because arbitration in India is virtually monopolized by judges. Most of the High Court judges, retired Supreme Court judges, the Chief Justices of India High Court, they have, you see, monopolized this field of arbitration, where we need more experts from diverse fields. We need technocrats. We need chartered accountants, company secretaries, engineers, architects. They should also become arbitrators. Why should it be monopolized, you see, just by judges and lawyers? That is why it has failed to take off. Second reason, judges, is interference by the courts. Although the law says that arbitration award is virtually final and you can't do it, but then you have so many provisions, even appointment of arbitrators, you have to go to the court. If parties don't agree, Section 34, Section 37, Arbitration Act. So interference and execution of the awards. Everywhere you see there is interference by the courts. Therefore, what is the answer? That is where your responsibility comes. Your responsibility is to get the change of mindset of our young students to promote settlements, to promote samjhauta, give and take. That is the only answer to this huge pendency. So it's a big responsibility, you see, on the law schools to inculcate that feeling of settlement of disputes, mediations and all that. Wonderful discussion. We had, I think, a big round of applause to the law teachers.
And for the amazing session, I would request Mr. Bhasin to present the mementos to the speakers, starting with Professor Rishikesh Dave. Dr. Purnima Imandar. Dr. Mukul Saxena. And Dr. Sachin Rastogi. Thank you, everybody. I would request all the panelists to return to their seat after the group photograph. So before we rise for lunch, the first time was so nice so that we have to do it twice. We'll be screening the short series of 11 episodes again, the trailer of it, called Legend of Law, and so that people who missed it, they get the chance to see it again, and people who saw it, they get a chance to appreciate it again. So please, I would request to screen the movie after the chairs are removed from the stage. Thank you so much.
profession of lawyers becomes less commercial-minded and more service-minded.
I would like to write about why and how, because I have been witness to the collapse of the judiciary, of the independence of the judiciary.
In an education system which is regimented, you can never recognize that strength. So participative education is what is required.
Controversial films came to us like Rajniti, Udta Punjab or something like that, and many films from South India about Indo-Lanka fishermen cases you see, and all how the fishermen were depicted in India and in Sri Lanka, which were all opposed by the government. Government had supported that these films should be banned at all. But we took a view that no, this is absolutely correct. This is the reality of the situation.
Let's assume that a woman consents on marriage to have sex. That is stating the obvious. The question is, does she consent to violent sex? And let me tell you, all force is violence. Does she consent to that? Does she consent to brutal sex? She doesn't.
What is the message we are going to give to future generations? Are we going to give them a message of hatred, or we are going to give them a message of love? When history is written, what will be written about us? So I think these are issues on which I am really sad to say that Prime Minister Mr. Modi, who is so popular a leader of the country, is just remaining silent.
કે ચાલો સમયને પૂછીએ અકબરનું શું થયું. Let us ask the great lord of time what happened to Akbar. Akbar was his name. ચાલો સમયને પૂછીએ અકબરનું શું થયું. કબરોમાં ક્યાંય એની કબરનો પતો નથી. In the graveyard, in the cemetery, we see so many kabristan. But we can't find the kabar of Akbar.
But lawyers, more than any other profession, will have to ensure that they maintain the very highest standards of integrity and rectitude.
Teachers, the teachers, poor chaps, are never treated well.
Right.
And unlike the professors in America and England, where they are looked upon as academics of great quality. In fact, I was very keen that an academic who was not a practicing lawyer should be appointed to the Supreme Court. But somehow, when I told Justice Venkataramani, who was Chief Justice, he disagreed. He says that no, the person who has to practice, and once he practices only, he is fit to be a judge of the court.
It is not the top leaders that misguide people. It is the susceptibility of a human being, his intellectual, neural susceptibility to be swayed away in an unthinking way, swayed away by a hero worship, ideal of hero worship, an ideology for a religion, for a cause, for a slogan, sacrifice his life for that.
I didn't count them, but it's such a crowd of monkeys. The judgment was on a Saturday, especially sad. Sunday night, maybe about 7:30. Lot of monkeys were coming. It's sort of coincidence. We also attributed the hand of God.
Five out of five again. And with that, we come to the break. Lunch is now served. And please proceed to your left. And please leave some space in your tummy for the jokes. And don't forget to network, connect, and make friends with the people around you be bold, be confident, and most important of all, be NIDAR. And for everybody, there's a PSA that by the end of this event, there'll be a small quiz conducted by me, and I'll be giving giveaways, and the main person, the person winner of the quiz, will get sponsored a trip to Goa. The only catch is that the flight ticket will be from Indigo. But apart from that, there will be a quiz, and that last part was a joke, but there will be giveaways, so please stay for that. And Ms. Rekha Gupta, the Chief Minister of Delhi, will be coming after lunch, so let's just proceed for lunch and gather here around 2:30 p.m., 2:15 p.m. We will be back here at 2:15 p.m. sharp. Thank you so much. Attention, please. Attention, please. There's a public service announcement. I would request everybody to be seated and to maintain silence. I would expect it to be pin drop silence for our Chief Minister. So if we can follow that, I'm really grateful to you all. And please, if anybody who is outside, please come inside and take your seats, be seated. Thank you very much. I'm pleased to announce that the Chief Minister is in the building with us right now. But she's having a quick bite, so we'll have to wait for her for the next 15 minutes. We will accommodate and we will wait for our Chief Minister, Mrs. Rekha Gupta, very gratefully and very gladly. So in 15 minutes, she will be on the stage. Thank you. And in the meanwhile, the first time was not enough, the second time was not enough, so we have to do it thrice because third time's the charm. We will screen the movie again, the movie which some of you must have missed, which will be screened right now, which is a trailer of this 11-episode series with stalwarts of the legal industry. You'll see for yourself. Please.
Future generation of lawyers becomes less commercial minded and more service minded.
I would like to write about why and how, because I have been witness to the collapse of the judiciary, of the independence of the judiciary.
In an education system which is regimented, you can never recognize that strength. So participative education is what is required.
Controversial films came to us like Rajniti, Udta Punjab or something like that, and many films from South India about Indo-Lanka fishermen cases you see, and all how the fishermen were depicted in India and in Sri Lanka, which were all opposed by the government. Government had supported that these films should be banned at all. But we took a view that no, this is absolutely correct. This is the reality of the situation.
Let's assume that a woman consents on marriage to have sex. That is stating the obvious. The question is, does she consent to violent sex? And let me tell you, all force is violence. Does she consent to that? Does she consent to brutal sex? She doesn't.
What is the message we are going to give to future generations? Are we going to give them message of hatred, or we are going to give them a message of love? When history is written, what will be written about us? So I think these are issues on which I am really sad to say that Prime Minister Mr. Modi, who is so popular a leader of the country, is just remaining silent.
કે ચાલો સમયને પૂછીએ અકબરનું શું થયું. Let us ask the great lord of time what happened to Akbar. Akbar was his name. ચાલો સમયને પૂછીએ અકબરનું શું થયું. કબરોમાં ક્યાંય એની કબરનો પતો નથી. In the graveyard, in the cemetery, We see so many kabristan. But we can't find the kabar of Akbar.
But lawyers, more than anybody, any other profession, will have to ensure that they maintain the very highest standards of integrity and rectitude.
Teachers, the teachers, poor chaps, are never treated well.
Right.
And unlike the professors in America and England, where they are looked upon as academics of great quality. In fact, I was very keen that an academic who was not a practicing lawyer should be appointed to the Supreme Court. But somehow, when I told Justice Venkataramani was Chief Justice, he disagreed. He says that no, the person who has to practice, and once he practices, only he is fit to be a judge of the court.
It is not the top leaders that misguide people. It is the susceptibility of a human being, his intellectual, neural susceptibility to be swayed away in an unthinking way, swayed away by a hero worship, ideal of hero worship, an ideology for a religion, for a cause, for a slogan, sacrifice his life for that.
I didn't count them,
Okay.
but it's such a crowd of monkeys. The judgment was on a Saturday, especially Saturday. Sunday eve, night maybe about 7:30. A lot of monkeys were coming. It's all coincidence. We also attribute it to the hand of God.
I've been informed that within 2 minutes, Mrs. Rekha Gupta will be gracing this event with her presence. So are we ready for her? How's the Josh, everybody? Do we have the energy? How's the temperature of the room? So as soon as she comes, we have to welcome, we have to give her a really, really, really big welcome as she deserves it. And she'll be here within the next 2 minutes. So please be ready with your joyful excitement and with zeal in your eyes. Thank you. I've just received a message anytime now in the next 1 minute. I may have lied before, but not this time. Trust me. This one is the truth. The moment of truth is upon us right now. false alarm. I've been informed by the security that this room is safe. They have given me a thumbs up, so I would assume that we all are safe right now, and soon we'll be graced by the presence of the Chief Minister. And sorry for the lies before, I'm a lawyer by profession and a stand-up comedian, so it's my job to keep you engaged and lie to you at the same time. I've never been stood up like this before, but again, I'm a stand-up comedian, so it's my job to do this. So till the time she arrives, I will have to keep speaking. That is what I get paid for. So please, please be engaged. Please, please, please be with me as we welcome our chief guest very, very soon. So do you guys like jokes? I have one. Why did the Chief Minister cross the road? She crossed the road to arrive on time, which is not right now. In all honesty, I was told that while the Chief Minister is in the building, I am not supposed to make any jokes because these days stand-up comedians are not the best breed to be. So that's why I have to make the silliest of the jokes and not anything else because I don't want to go to jail. And please, 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 now the moment of truth is upon us. The chief guest, the Chief Minister of Delhi, Mrs. Rekha Gupta, is in the building, in the room with us. Please, a round of applause for the chief guest and the Chief Minister of Delhi, Mrs. Rekha Gupta. Welcome, ma'am. So now we finally move to the inaugural session of NIDAR 2025. The platform has been created with a single purpose, to reimagine justice for every citizen. And now I request everybody, the others to move to the stage. Mrs. Neena Gupta, Mrs. Pallavi Shroff, Mr. Manoj Singh, please grace us with your presence on the stage. Please meet the Chief Minister of Delhi, the chief guest of NIDAR. Today marks the beginning of that journey and that start of conversations that will shape the future of our legal ecosystem. This inaugural moment also holds special significance as we celebrate 25 years, that is the Silver Jubilee of the Society of Indian Law Firms, SILF, a milestone built on dedication, vision, and collective strength of its members. And now comes the moment that we have all been waiting for, eagerly waiting for. We have with us our chief guest, the bold, the relentless, the one-woman army, the most important person in the room and probably in Delhi. Please welcome the person of the moment, our chief guest, Mrs. Rekha Gupta, Honorable Chief Minister of the National Capital Territory of Delhi. Her presence adds immense grace to this inaugural moment and lights up the room as we celebrate this vision and values that define NIDAR and the 25-year journey of SILF. And now I request Ms. Neena Gupta and Ms. Pallavi Shroff, ma'am, to welcome the chief guest with a memento. With a token of gratitude, please. A big round of applause, everybody. Please show us some energy. Rise up the temperature of the room, please. And now, I would please welcome Mr. Manoj Singh, Senior Vice President of SILF, to deliver this opening address. Thank you, sir. A round of applause again, please. Keep the temperature high.
Thank you very much, my friend. First of all, it's an honor to be here and speak among the honorable judge, legal scholars, and the policymaker. So, we are celebrating today 25 years of SILF. I would say SILF was never an association. It was a movement started by or under the leadership of Dr. Bhasin and other eminent friends like Dr. Jyoti Sagar, and we have reached here. Today is a very important day. Kindly see the meaning of NIDAR, National Initiative for Delivery of Accessible Remedies. What it signifies for, what it's telling. We have reached to the stage where we need to think that if the legal system, justice delivery system is only accessible to affluent, is it really a justice delivery system or it is a privilege? Accessibility is in the core of making it privilege or making it a right to reach to the judicial system, legal system. We must ask question to ourselves whether we have reached to the stage where accessible judicial system can be categorized in the term of basic need. Can anything be enforced without accessible judicial system? Question number one. Question number two, that whether justice system is really accessible to the people who really needs it, whether any of the affected party once think of going to the court, taking a legal recourse, think about complexity, whether complexity pops up in the mind or not, whether you feel free to assess the system which exists to protect your own right. I mean, definitely this accessibility needs to be somehow we go to the policymakers, somehow we need to increase the courtroom system, and our Honorable Chief Minister is already in the forefront of it. I'm personally aware of that. She is looking into the increasing the courtroom, increasing how the more judges can be there. But the point is, we have reached to the point where really we need to implement it. Really we need to come out of that clogged courtroom. We need to use the technology. We need to use the artificial intelligence. We need to have the clear-cut legislation, clear-cut path. And perhaps that is the meaning of National Initiative for Delivery of Accessible Remedies. If remedies are not accessible, there are no remedies, trust me. And I must thanks to our leader, Dr. Bhasin, that he thought of it. And the movement is spearheaded by SILF, under the leadership of Dr. Lalit Bhasin. I'm very fond of saying this, and I'm saying it again today. For Lalit Bhasin, I feel like that Guru Govind do khade kaake lagu paye, Guru Bali Hari aapki Govind diyo bataye. What a wonderful, give a big round of applause to Dr. Bhasin. So, if you see the Maslow hierarchy, there are two kinds of hierarchy in the basic need. One is a physiological hierarchy, and one is a food and safety hierarchy. And we can keep on going on the basic need definition till Dr. Upendra Bakshi. But the point is how this basic need have to be enforced by the accessible legal system.
accessibility has to be technologically advanced, reachable. Professional development has to keep on going. And then, in the modern world, you have to be globally aligned. We need to think on, I mean, we can say that we are globally aligned, but we should think of it more clearly, more aggressively, openly, inward looking, apart from outside looking. We should compare honestly. We are in new era. We are in new era where there are competing rights, competing remedies. Every right has a corresponding duty. So the guy who is having a duty, he is also having some legal remedy, and the guy who is having a right is also having a legal remedy. But think of the practical situation. Really somebody want to assess the court without having a lump in the throat, that how complex it is going to be. So the immediate remedy is strengthen our ADR, strengthen our mediation processes. And again, thanks to Dr. Bhasin, that mediation drive, the way he is driving in the country, is tremendous. And so thank you again. Again, a big round of applause for Dr. Bhasin for the kind of the mediation movement he has launched. And we are on the right path. I will not take much time, but only call today I'm making is, think of the accessibility of the legal remedies. Let it not to be a privilege of the affluent. Let it reach to the every walk of the society, every corner of the country. And I'm sure our dear Chief Minister is already conscious of it, as by education and profession, she is also primarily an advocate. So thank you, ma'am. Thank you very much for coming today. Thank you, gentlemen.
Thank you so much, Mr. Singh. And on this momentous occasion, we are proud to confer the SILF 25-year award in recognition of exceptional service and enduring impact. Now, I invite you to join me in a warm and generous round of applause as we celebrate these remarkable individuals and their contributions to the Society of Indian Law Firms and to the legal profession at large. And now these awards, award of distinction, will be felicitated by the chief guest to the following people. To Mr. Jyoti Sagar, Chairman of J. Sagar Associates, one of the topmost law firms of India and Associate President of SILF. A round of applause, please. Award of Distinction for Outstanding and Distinguished Services to the SILF, Society of Indian Law Firms and the Legal Profession, presented to Mr. Shardul Suresh Shroff, Chairman of one of the largest law firms in Asia Pacific, who has contributed significantly in providing support in international business transactions. Please, sir. More energy, please. A big round of applause again. Thank you so much. And now, the Award of Distinction for Outstanding and Distinguished Services, presented to Mr. V. Lakshmi Kumaran, head of India's topmost law firm specializing in taxation and advising the government of India regarding free trade agreements, including the one recently signed with the United Kingdom. Please, sir. Award of Distinction for Outstanding and Distinguished Service to the Legal Profession, presented to Honorable Justice Tejas Karia, who was Distinguished Senior Partner of Shardul Amarchand Mangaldas and was elevated to Delhi High Court earlier this year. He helped SILF in promoting arbitration and mediation in this country. Please, sir. Posthumous award presented to Mr. Rajiv Luthra, and I invite Mrs. Gayatri Luthra on the stage, and for outstanding and distinguished service to the Society of Indian Law Firms and the legal profession. He was the head of Luthra and Luthra Associates, which specialized in joint ventures with foreign companies and played a significant role in setting up of SILF, building on Deel Dayal Upadhyay Marg. Always in our memories and always in our hearts, Mr. Rajiv Luthra, through his wife, Mrs. Gayatri Luthra. Award of Distinction for Outstanding and Distinguished Service to the Society of Indian Law Firms and the legal profession. Joining us virtually, presented to Ms. Zia Modi, who is the head of one of the most outstanding law firms in India and abroad. They advise the corporations of the world for international transactions, including investments in India and from India. This award will be received by Ms. Modi virtually today. And finally, the award of Gupta Bhasin, Vice President, SILF, to kindly introduce the Honorable Chief Minister, the Honorable Chief Guest of the event today. Please, ma'am.
No, it's okay. Yeah, it's okay. Good afternoon, dignitaries on the dais and off the dais. It is indeed my honor to introduce you Delhi's Chief Minister, Honorable Mrs. Rekha Gupta. Although she is known to one and all, and in the real sense needs no introduction, yet I will briefly run through some of her achievements. Rekha ji's journey to this moment is remarkable. She is a born leader. She began her public life as a student leader at the university, where she introduced the common admission form and established committees against sexual harassment. Later, she served for 3 terms as a municipal councillor and even as a mayor of South Delhi Municipal Corporation. In these roles, she worked on local infrastructure like parks, underground parking, street lights, etc., and introduced social welfare schemes like the Sumedha Yojana for financially weaker female students. In the 2025 Delhi Assembly elections, she contested from the Shalimar Bagh constituency and won with a strong mandate, defeating her opponent by a large margin. As the 7th Chief Minister of Delhi and only the 4th woman to hold this post, her appointment marks a new chapter for our capital. Rekha ji has pledged to lead Delhi with honesty, integrity, and dedication towards the welfare and development of all its citizens. Her government released a 100-day report card in May 2025, highlighting key initiatives and achievements in field of healthcare, environment, infrastructure, education, governance, and welfare. She has deep commitment to women's empowerment through better employment and safety initiatives. We look forward with hope to a future where under her leadership, the city flourishes socially, economically, and in every way. Please join me in welcoming Chief Minister, Honorable Rekha Gupta ji, with a big round of applause.
थैंक यू सो मच। मंच पे यहाँ पे उपस्थित SILF के प्रेसिडेंट डॉक्टर ललित भसीन जी, वाइस प्रेसिडेंट मिस्टर मनोज सिंह जी, मिसेस पल्लवी श्रॉफ जी, मिस नीना गुप्ता जी, और मेरे सामने बैठे हुए आप सभी बहुत ही मुअज़्ज़िज़ व्यक्ति जो लगातार इस देश में लाखों करोड़ों लोगों को लीगल हेल्प देने के लिए काम कर रहे हैं। मैं चाहूँगी कि एक बार जोरदार तालियां आप सभी के लिए हो। जब अपने लिए ताली बजाई जाए तो जोरदार ही बजानी चाहिए, कम में मज़ा नहीं आया। और मेरी रिक्वेस्ट है आप कैमरामैन से कि प्लीज़ आप लोग अगर कैमरा यहाँ छोड़ के थोड़ा साइड हो जाएंगे तो आई कैन कंटेक्ट विद द लास्ट पर्सन हु इज सिटिंग ओवर हियर। थैंक यू सो मच। आज का ये प्रोग्राम आपकी संस्था, सोसाइटी ऑफ लॉ फर्म्स और एक बहुत सुंदर विज़न निदार, नेशनल इनिशिएटिव फॉर डिलीवरी ऑफ एक्सेसिबल रेमेडीज। मुझे ध्यान है देश के प्रधानमंत्री नरेंद्र मोदी जी ने हमेशा इसी बात का जिक्र किया कि ईज़ ऑफ लिविंग तब तक पूरी नहीं होती जब तक ईज़ ऑफ जस्टिस नहीं होता। आप कैसे ऐसे समाज में जी सकते हैं या देश में जी सकते हैं जहां आपको न्याय ना मिल पाए, आप अपनी किसी भी परेशानी को या तकलीफ़ को उसके लिए जस्टिस ना ले पाएँ, न्याय आपको ना मिल पाए। और लगातार इसी कारण से देश में मोदी जी की सरकार आने के बाद सैकड़ों कानून जो कि आज के वक्त में बिल्कुल बेबुनियाद थे, जिनका कोई आज के समय से लेना देना नहीं था, उन्हें डिलीट किया गया, उन्हें ख़त्म किया गया। 1500 के करीब वो कानून जो कि आज हम पढ़े तो हमें हंसी आए कि ये किस समय बनाए गए थे। और इसी तरीके से जिस तरीके से उन्होंने हमारे इस न्याय के तंत्र को मजबूत किया, दंड संहिता होती थी, उसे न्याय संहिता का नाम देकर के अंग्रेजों के ज़माने से चल रहा था। उनके सामने तो भारतीय लोग दंड के अधिकारी थे, इसलिए पिनल कोड बना था कि इन्हें सज़ा मिलनी चाहिए, इनके लिए ऐसे कानून बनाने हैं। वो सब तरीके थे हमें सज़ा देने के, पर आज उसकी परिभाषाएं अलग हो गई हैं। आज दंड नहीं, न्याय की बात होती है। न्याय मिले ये ज़रूरी है, और इसीलिए सरकार ने जो आमूलचूल परिवर्तन आज के कानूनों में किया वो काबिले तारीफ़ है। और इसी तरीके से आप सब की फर्म्स, बहुत बड़ी बड़ी फर्म्स जिनको हमने यहाँ से अवार्ड दिया, लगातार इसी दिशा में काम कर रहे हैं कि कैसे लोगों तक इस न्याय को, इस कानून को पहुँचाया जा सके। और इसीलिए आप समाज में काम कर रहे हैं, सरकारें काम कर रही हैं, तभी जिस सपने को हम देखते हैं, जिस विज़न के साथ हम काम करते हैं कि हर एक तक ये जस्टिस पहुँचे, हर व्यक्ति कानून का अपने अधिकारों के लिए उपयोग कर सके। और इसी दिशा में काम करते करते लगातार आपकी ये सोसाइटी 25 वर्ष पूरे कर रही है। इसके लिए दिल की गहराई से आप सभी को ढेर सारी बधाई, शुभकामनाएं। मुझे भसीन साहब ने बताया कि इस संस्था की नींव आदरणीय अरुण जेटली साहब ने रखी थी। अरुण जेटली साहब हम सबके बहुत ही प्रिय थे, मुझसे तो विशेष रूप से उनका स्नेह था। मैं यूनिवर्सिटी की प्रेसिडेंट थी, दिल्ली यूनिवर्सिटी की, और वो भी दिल्ली यूनिवर्सिटी के प्रेसिडेंट रहे, तो उनका बहुत लगाव रहता है दिल्ली यूनिवर्सिटी से। जब कोई स्टूडेंट उभरता है, नेता बनता है और समाज में काम करता है, और इसीलिए हमेशा उनका गाइडेंस मुझे मिला। आज उनकी कमी हम महसूस करते हैं, पर उन्होंने जो पौधा लगाया आपकी संस्था के माध्यम से, SILF के माध्यम से, वो आज एक बड़ा वृक्ष बन करके पूरे देश में छांव दे रहा है, लोगों के लिए सेवा कर रहा है। बहुत सारी इंडस्ट्रीज को आप लोग लीगल हेल्प जो करते हैं, वो उन्हें आगे बढ़ने के लिए, देश की इकोनॉमी मजबूत करने के लिए बहुत बहुत मददगार होता है। कानून एक बड़ा शब्द है। पहले कहते थे कानून अंधा होता है, मुझे लगता है कि नहीं, कानून देख भी सकता है, समझ भी सकता है को भी, और कहीं पे अगर गैप हो तो उसे पूरा करने का काम हम सबका है कि ये गैप कहीं रहे ना, कोई ऐसा ना हो किसी के साथ न्याय हो। और इसीलिए आप सब फर्म्स का होना बहुत बहुत इम्पॉर्टेंट है। ये 150 फर्म्स जो आपकी संस्था से एसोसिएटेड हैं, और वो 20,000 से ज़्यादा एडवोकेट्स जो इसमें काम कर रहे हैं। विशेष रूप से मैं देख रही हूँ कि महिलाएं बहुत बड़ी मात्रा में इस एसोसिएशन के साथ जुड़ी है। मैं आप सबको भी बहुत बधाई देती हूँ और ये कहना चाहूँगी कि हमारे देश में एक नया सवेरा देखने का लोग इंतज़ार कर रहे हैं। उस नए सवेरे को जल्द लेके आने का काम शायद हमारी ये सोसाइटी कर सकती है। वो देश जहाँ, जिसके बारे में वो गीत गाया जाता कि जहाँ डाल डाल पे सोने की चिड़िया करती हो बसेरा, वो भारत देश है मेरा। वो देश जहाँ न्याय को लेकर के राजा महाराजा, शासक प्रशासक, हर व्यक्ति काम करता था। न्याय कोई आज की मांग नहीं है, न्याय हमारे देश की इस मिट्टी में सालों से, सदियों से है, और उसी परंपरा को आप लोग आज की लेटेस्ट भूमिका में निभा रहे हैं। आपने कहा, मनोज जी ने, कि दिल्ली सरकार इसके लिए बहुत काम कर रही है। यस, वी आर डूइंग आवर बेस्ट। हमने सभी जितने हमारे कोर्ट्स हैं उसमें एक्स्ट्रा ब्लॉक, एक्स्ट्रा रूम, हाइब्रिड कोर्ट्स, इसको बनाने के लिए लगातार काम कर रहे हैं। हम चाहते हैं कि इतनी पेंडेंसी जो हमारे कोर्टों की है उसे बहुत जल्द ख़त्म किया जाए, और इसीलिए हमने अपनी ओर से भी फास्ट ट्रैक सेशन कोर्ट्स बनाए ताकि लोगों को, खास करके महिलाओं के उत्पीड़न से जुड़े हुए जितने भी केसेस हैं उन्हें न्याय मिल पाए। हमने कोशिश की कि जितने हमारे एडवोकेट्स हैं जो प्रेमिसेस में वहाँ काम करते हैं, अदालतों में काम करते हैं, उन्हें फ्री वाईफाई और अच्छी क्वालिटी का वाईफाई मिल पाए। हमने कोशिश की कि हमारे जितने जजेस हैं उन्हें जिस भी तरीके से हम सुविधाएं दे पाए ताकि जो वर्कलोड उनके ऊपर है वो कम हो पाए और वो ज़्यादा मात्रा में केसेस का समाधान कर सके। हमने नए कोर्ट बिल्डिंग बनाने की दिशा में भी आगे काम कर रहे हैं, और यहाँ तक कि जो वर्षों पुरानी हमारे इस दिल्ली शहर में जेल परिसर है, तिहाड़ जेल, जो कि शहर के बीचों बीच है, उसे भी दिल्ली के आउटस्कर्ट्स में ले जाने का दिल्ली सरकार का प्लान है, जिस पे बहुत जल्द हम इम्प्लीमेंटेशन करेंगे। हम चाहते हैं कि दिल्ली के लोग पूरी तरीके से हमारी कानून व्यवस्था में अपना विश्वास भी रखें और उसका लाभ भी ले पाएं जीवन जीने के लिए। और आप सब ने यहाँ दिल्ली आकर के आज का इस सेलिब्रेशन को किया और मुझे इस कार्यक्रम में बुलाया। मैं दिल की गहराई से आप सभी का बहुत बहुत धन्यवाद देती हूँ। और आदरणीय मोदी जी तो कहते ही हैं, और उन्होंने जो काम किया कि लीगल एंड डिफेंस काउंसलिंग सिस्टम जो बनाया, वो वही विज़न है और वही मोटिव है जो आप लोग अपना इस संस्था के माध्यम से कर रहे हैं और करना चाहते हैं। मिल करके जब आपकी संस्था, सरकारें चलेंगी तो हर व्यक्ति तक, समाज के हर आखिरी पंक्ति में खड़े हुए व्यक्ति तक ये कानून पहुंच पाएगा, वो उसके कारण से न्याय ले पाएगा। मुझे विश्वास है कि कि आप सब लोग बहुत ही ईमानदारी के साथ में इस फील्ड में काम करेंगे ताकि ना कोई गरीब, ना कोई पीड़ित, ना कोई शोषित व्यक्ति इससे महरूम रहे। और एक सामाजिक दायित्व के नाते भी एक कमर्शियल एस्पेक्ट अलग है कि ठीक है हम लोग, मैं अभी पीछे जब एडवोकेट डे था तो गई 30,000 में, तो बहुत सारे एडवोकेट्स थे, तो वो लोग बातें कर रहे थे कि एक वकील का कैरियर कैसे शुरू होता है। तो उन्होंने कहा भी वकील का कैरियर तो ऐसे शुरू होता है कि पहले तो वकील काम के लिए घूमता है, तो काम करता है तो भी दाम नहीं मिलता है, फिर थोड़ा और आगे बढ़ता है तो काम करता है तो थोड़ा दाम मिलता है, नाम थोड़ा और बड़ा हो जाए तो काम कम भी करे तो दाम पूरा मिलता है, और जब लॉ फर्म बना ले तो काम करे ना करे दाम पूरा मिलता है। मतलब सबऑर्डिनेट्स का इतना बड़ा टीम होता है हेड के पास कि वो इशारा करे तो सबऑर्डिनेट पूरा केस हिस्ट्री बना के लाता है और बताता है कि सर आपने बस अपना एडवाइस देना है। तो मैं पूरी तरह एग्री नहीं करती इससे, आप ये मत सोचिए कि मैंने कहा है, मैंने सुना उस कार्यक्रम में। तो मैं ये समझती हूँ कि हमारी ये लीगल फर्म्स जो हैं बहुत काम कर रही हैं, बेहतर काम कर रही हैं और अधिक आने वाले समय में अपनी सोशल रिस्पॉन्सिबिलिटी समझते हुए काम करेंगी। मैं अक्सर एक बात ज़रूर कहती हूँ, हर मंच पे कहती हूँ, और मुझे लगता है कि ये बार बार दोहराने से, क्योंकि 140 करोड़ भारतीयों तक तो मैं नहीं पहुँच सकती, पर शायद ये बात लोगों के दिलों तक पहुँच पाए। जब सरहद पे खड़े हुए सैनिकों को हम देखते हैं तो ये मन में महसूस होता है कि भाई देशभक्ति इसे कहते हैं, पर मैं ये मानती हूँ कि हम में हर एक व्यक्ति में देशभक्ति है। हम भी अपने देश के लिए जीना मरना चाहते हैं और कुछ करना चाहते हैं। जब पहलगांव जैसे आतंकी हमले होते हैं तो हमारा भी दिल करता है कि हमें मौका मिले तो हम सरहद पे चले जाएं, पर विश्वास कीजिए कि हम में से किसी एक को भी ये मौका मिलने वाला नहीं है। ना हमें सरहद पे जाने का मौका मिलेगा, ना बंदूक उठाने का मौका मिलेगा, ना दुश्मन को गोली मारने का मौका मिलेगा, ना सीने पे गोली खाने का मौका मिलेगा। हमें देश के लिए मरने का मौका नहीं मिलने वाला, पर हाँ देश के लिए जीने का मौका हम सबके पास है, आज भी है, अभी भी है, और हम सब अपने देश के लिए जीना शुरू करेंगे, कुछ कुछ थोड़ा थोड़ा भी करना शुरू करेंगे तो आपका ये छोटा प्रयास देश के लिए बड़ा विकास बन सकता है। इस बात का मैं आप सबको विश्वास दिलाती हूँ। ढेर सारी बधाई, शुभकामनाएं आप सभी को, और 25 साल पूरे होने पे SILF को आप और तरक्की करें, आगे बढ़ें, और ऐसे जैसे आज सम्मान दिया है आप वरिष्ठ जनों को, ऐसे ही बहुत सारे हमारी फर्म्स को, हमारे सभी साथियों को आप सम्मानित करें और मोटिवेट करें। थैंक यू सो मच।
Thank you so much, ma'am. And this event has been commemorated in the history of any event ever. And Dr. Bhasin.
ऑनरेबल चीफ मिनिस्टर ने दो बातें कही, तो उसके ऊपर मैं थोड़ा सा बोलना चाहता हूँ। आपने बताया पहलगाम का जिक्र किया। हमारी सोसाइटी ऑफ इंडियन लॉ फर्म्स एक ही इंस्टीट्यूट थी जिसने अगस्त में जाके पहलगाम के अंदर अपनी पूरी मीटिंग की थी जिसमें हमारे कई मेंबर जो प्रेजेंट हैं इस वक्त, श्वेता भारती जी हैं, ये भी गई थी, और बहुत सारे लोग हमारे साथ गए थे। वहीं पे हमने ये मैसेज छोड़ा था कि ये टेररिज्म की फाइट जो है ये हम सब के अगेंस्ट में है। इसमें जो सरकार ने करना है वो तो करेगी, सरकार अपनी पूरी रिस्पॉन्सिबिलिटी कर रही है, पर उसके साथ हम लोगों की भी रिस्पॉन्सिबिलिटी होती है। दूसरा आपने जिक्र किया जो हमारी सोशल रिस्पॉन्सिबिलिटी है, तो हमने एक फ्रेज चुनी है PSR। CSR तो लोगों ने सुना है, PSR प्रोफेशनल सोशल रिस्पॉन्सिबिलिटी, और उसके ऊपर हम पूरा अमल कर रहे हैं। उसमें आपकी मदद भी चाहिए कि हम किस तरीके से फ्री लीगल एड की इंस्टीट्यूशन बना सकें। हमने अपनी बिल्डिंग में सिल्फ की बिल्डिंग जो अभी दीनदयाल उपाध्याय मार्ग में बनी है, उसमें हम एक सेंटर खोल रहे हैं जिसमें फ्री लीगल एड एंड एडवाइस जो है वो दी जाएगी। तो मैं 2 बातों का जिक्र करना चाहता था, माफ़ी चाहता हूँ।
Thank you so much, sir. And now I invite Dr. Lalit Bhasin to felicitate the chief guest with a memento right now. Please. I welcome Mr. Praveen Anand on the stage. And now, finally, I invite Ms. Pallavi Shroff, Vice President of SILF and Managing Partner at Shardul Amachand Mangaldas, to deliver the concluding address. Please welcome her.
Honorable Chief Minister of New Delhi, Srimati Rekha Gupta, Mr. Lalit Bhasin, President, Society of Indian Law Firms or SILF, distinguished awardees, ladies and gentlemen. Indeed an honor for me to be here today to give these concluding remarks on the joyous occasion of the Silver Jubilee celebration. Ma'am, we are truly grateful to you for accepting SILF's invitation to be here today in spite of your busy schedule. Your presence is a source of great inspiration to all of us, and in particular to women lawyers. Your dedication and focus to public service and social causes are truly inspirational. Your continued service for decades before accepting any position is a matter that all of us in the legal profession need to keep in mind, because till we work for decades, there is no rise in sights, as you just said. We have to work for years and years before you make a name. And I think that is what comes out so truly. SILF, or the Society of Indian Law Firms, is an apex body of the law firms in India. It was established in the year 2000 with the aim of protecting, safeguarding, and promoting the interest of law firms in India. The Bar Association of India, which are attached to different high courts in India, the Bar Council of India, all represent the individual members of the legal profession. There was no association which typically recognized the law firms in India, and therefore a need was felt to have such an association that takes up the voice, or it becomes the voice of the law firms in India. The practicing of law by individual lawyers and that by law firms is a little different from each other. The law firms, when 2 or more people combine to form a law firm, has its own issues, its own challenges, and we had no voice either before the legislatures or before our regulator, and so this association came into existence. Since its inauguration in the year 2000 by late Shri Arun Jaitley, a friend to so many of us, a mentor to so many of us, and our senior, who was the then Minister of Law and Justice, Government of India, in the august presence of Senior Counsel, late Mr. F.S. Nariman, who was then the President of the Bar Association of India, SILF has achieved significant milestones. SILF strives to create an atmosphere that will enable Indian law firms, big and small, to match technology, manpower, develop skills and infrastructure to match those of the Western world. Amongst the various activities that SILF undertakes, it is a forum for interacting with the government, judiciary, and the bureaucracy on various issues impacting the laws, the law firms, and the legal profession. It is an active participant in the Prime Minister Modi's great initiative for ease of doing business. Ultimately, law is the bedrock of any society, whether it's social causes or the public causes, and even doing business in India. Unless we have a strong legal framework and it is implemented in the right way, getting more investments into India or encouraging Indian businesses to invest more in India would not be possible. Therefore, the legal fraternity and how law is implemented and developed is very, very key to doing business in India and the ease of doing business in India. SILF facilitates business and provides the legal support for the economic development of the country. It advises and works very closely with chambers of commerce and industry on corporate activities and compliances so as to make India truly Viksit Bharat and Atmanirbhar Bharat. SILF has been actively working towards achieving its goals and helping its member firms, numbering today more than 150 with 20,000 lawyers, as the Honorable Chief Minister mentioned. Its members are both big and small law firms. Varun here represents some of the smaller and the newer firms. It tries to create an atmosphere that will enable these law firms to work together, to grow together, and deal with all challenges that are thrown at the legal profession. SILF is also focused on several ongoing programs on legal education for young lawyers to improve their skills. SILF has recently completed its own building on Deen Dayal Upadhyay Marg in New Delhi, and the building was inaugurated by the Honorable Vice President of India. In this building, as Dr. Bhasin just mentioned, SILF has set up its center, which would focus on legal research, legal education, and an online arbitration facilities, which it will be doing with CII. It also proposes to set up a pro bono mediation center for settlement of disputes in the same spirit of Samjhauta. We humbly request the Delhi government to partner with us and for running this mediation center for the weaker sections of society. Together we can achieve what several others cannot do it alone. My concluding remarks would not be complete without a special shout out to the distinguished lawyers who've been the first awardees today. Each one of them have not only stalwarts in their respective legal fields, but also contributed extensively to development of public policy and growth of the legal profession in India. Each one of them has participated very actively in various activities of SILF and contributed immensely to the growth of SILF and in helping SILF achieve its goals and objectives. They all believe that the legal profession, and particularly the law firms, have a responsibility to not only enable business and contribute to the growth of the country, but also create ease of providing justice, and SILF recognizes their contribution and salutes them today. Once again, ma'am, we thank you for being here today. Thank you.
Thank you so much, ma'am. And now, unfortunately, the CM has to depart from the event, and we thank her so much. We thank her so much for gracing this event with her presence. Thank you, ma'am. But please do not think that the event is over now. We continue with our sessions. And thank you. Thank you so much, ma'am. And now I request everybody to take their seats for the next session. I request the following people to please come on the stage for the next session. Next session is called Future of Law Practice, Pathways Ahead. And I welcome our keynote speaker, Mr. Praveen Anand. I invite our keynote speaker, Mr. Praveen Anand, on the stage with Ms. Ankit Khushu, Ms. Nandini Sharma, Mr. George Thomas, and Ms. Manisha Chaudhary. Please come on the stage. Ms. Ankit Khushu, Ms. Nandini Sharma, Mr. George Thomas, and Ms. Manisha Chaudhary. I request you all to be on the stage, please, for the next session. I request everybody to be please seated. We will commence our next session very shortly, so please be seated. Please clear the area in front of the stage. Please be seated, everybody. जाके बोल दो photographer. I request everybody to clear the area in front of the stage, please. We are beginning the next session, please, sir. Thank you so much. And for this session, which is Future of Law Practice, the Pathways Ahead, I invite our keynote speaker, Mr. Praveen Anand, to commence this session with his speech and with his remarks. Please welcome Mr. Praveen Anand on the stage right now with a big round of applause. Thank you, sir.
Typically, a session after lunch is known as the graveyard spot, where everybody goes to sleep, but we've got a very vibrant audience here and a great panel, and I hope we can keep your interest alive. The topic that for today is the future of law practice, and I have just a few introductory remarks, and I'll then leave it to the panel to discuss this further. First, let me congratulate SILF on this fantastic ceremony and on achieving 25 years, and also congratulate all the great winners who have contributed hugely to the development of legal jurisprudence in this country. Now, on the future of law practice, just a few points. One, that there's a growing legal market, which is, the figures appear to be staggering. For example, in 2020, they were projected by surveys at 713 billion US dollars, but are projected to be in 2030 to cross 1.35 trillion US dollars. So the figures don't mean much to us, except that it's a colossal market. Let's just keep that in mind. Second, there is an increasing cross-border need for advisory services. For example, I just take the intellectual property field. We have the Patent Cooperation Treaty, the Madrid Protocol, and the Madrid Convention, and certain other, about 25 other international treaties which link up the countries of the world, the Paris Convention, which link up more than 150 countries of the world in a way that filing an application in one country gives a priority to a kind of a position in the line to file in other countries within a certain period of time. And then it enters the national phase in another country. And with that, the attorneys have to cooperate with each other to make sure that the filing in the other country is done on time, and all the objections taken by the national office are met consistently, and so on. There's a lot of cross-border work there. And then you have M&A and international arbitration, licensing, tax issues, trade restrictions, export controls, all very international. In the regulatory practice, a simple thing like what is the health requirement for milk food could involve many law firms all across many jurisdictions talking to each other in order to give consistent advice to the client. So that's the second point. Third, multiple law firms work together with multiple disciplines. So for example, you take a case of a standard essential patent. Now, you might have lawsuits in 5 countries, and the lawyers in each country would need to go down on con calls on a regular basis to make sure that what's happening in one jurisdiction is conveyed to the others, so that their courts don't say that you concealed something or there's an inconsistent stand being taken in another jurisdiction. So constantly there is this interaction going on between different law firms, and covering what? Covering law, covering technology, and also covering economics. Because, for example, you have to figure out what is a fair and reasonable non-discriminatory license fee. For that, for FRAND fee, you have to have economic experts as well. So law, economy, economics, technology, all converge. And lawyers have to work with all those other people. Fourth, traditional law firm models are changing to a Hollywood-style model, which means you put together a team for a specific project. And lawyers then start to become coordinators of legal intelligence across countries, across jurisdictions. I won't dwell much on that point, but as a fifth point, the transition is taking place from a technology-assisted firm to a technology-led firm. And what I mean by that is that lawyers are now using technology to come up with new models, such as, for example, to develop their own cost estimator. Clients want to know how much will this case cost, so a cost estimator, a budget planner, or a time estimator to come up with an idea about how long will this litigation last. Or in coming back to intellectual property, which is my field, to come up with a confusion model which can objectively work out what is the likelihood of confusion between two competing trademarks. Those are the kind of models which are being developed by law firms or will be developed by law firms. Predictive analysis is very, very important as an area to realistically predict how a particular judge will react given his past performance in cases. How is he on interim injunctions? How is he on other kinds of orders? Does he like English case law or not? How long does he take on an average to decide a case? Does he like evidence of this kind or that kind? All these are kind of questions that can now be answered by technology, not fully, but can narrow down, technology can narrow down the area of dispute to the bare minimum and therefore increase objectivity. As a sixth point, new practice areas are developing, right from data privacy and gaming, cybersecurity, blockchain, and a host lot of others which I won't develop. But what is very important is just to give you these figures, in the 1895 to 1925, most of the patent filing was in the field of engines and transport. Then from 1930 to 1960 in biopharma, the 1965 to 2000 in ICT, information technology, and 2000 to 2020 digital technologies. And so the whole shift has taken place from even ICT to the internet and to digital technologies. So that shift is very important for noticing, for the law firms to develop those kind of skill sets. Then budgeting. A lot of us don't understand that clients don't just look for discounts or shift work from outside counsel to in-house people. They also want billing portals to be mastered by their law firms. Billing portals like Anaqua, Serendipity, Serengeti, etc. And if law firms are not good at managing those billing portals, they'll find it difficult to keep up with the pace of the client. And of course, they look for things like blended rates if many people are working together. Then as an eighth point, there's competition from alternate legal service providers. Alternate legal service providers could be accounting firms, legal research firms, even investigators. In our field, even piracy actions are now being taken by investigators. And that's why law firms themselves have to increase their skill sets to things like domain name service providers and development of software and so on. Ninth point, building swarm intelligence. And swarm intelligence would be aligning various partners and departments with a common objective. For example, you may have investigators who are tracking supply chains, payment gateways, manufacturing hubs, then getting the IP team to get orders in court, and then data analysis teams who will use artificial intelligence to map the infringement and to predict future areas of emergence where infringement could be forthcoming. Customs, and then licensing teams to legitimize the the legitimate market. All these will have to work together, and that would be swarm intelligence. And that's going to grow. So now the biggest challenges, as the 10th point, are threefold. First, empowering professionals with new skills. And that's not easy. Professionals who've kind of worked all their life on a particular field, to empower them with new skills is a big challenge. The second, ADR, non-confrontational approaches and the development of a mediation or arbitration culture. And finally, the biggest challenge of all is to manage egos. That's the human aspect that comes in a law firm. If you can manage as the managing partner, if you can manage the egos of your people, you've managed to run the firm successfully. Thank you very much.
Thank you so much, sir, for the insightful speech. I'm also an IPR lawyer. I'm inspired, and on the topic of the future of IPR, I will try to apply for your firm, and hopefully you'll give me a job. But however, I now request we move on, and now request Mr. Ravi Nath to come on the stage. Is Mr. Ravi Nath with us right now? Never mind. Then we'll carry on with our speakers of this session, Ms. Ankit Khushu. I invite her to give her speech on this topic and continue our session. Please welcome her.
Good afternoon, fellow panelists, distinguished guests. First and foremost, I would like to thank Dr. Bhasin for inviting me to speak today and address you all, and congratulate him and all of us here on this momentous occasion of SILF completing 25 years. So it's a fantastic occasion and a great opportunity to be in front of you. My topic today is the future of law practice pathways ahead. We were told that we are supposed to give a presentation running into 7 to 8 minutes. So I've tried my level best to keep it short, simple, and based on my personal experiences. So while we talk about the future, we also need to go back and look at the past and the present to fully appreciate what the future may hold for us. So I have tried to structure my speech or my talk in 3 themes: the past, the present, and the future. Theme 1 is all about law practice in the past. And this is what I have heard from my seniors at the bar, all the distinguished panelists. I was just talking to Mr. Anand of about his initial days and how practice has been in the past. The profession has come a long way from what I heard. Probably 40, 30 years odd, the profession was more court-centric. The lawyers were more litigating lawyers, and everything was either within the Supreme Court, High Court, or the Tis Hazari. And there were few lawyers. Every lawyer knew the judge. The bar was more cohesive, and it was a more friendly atmosphere, a unique, friendly culture. There were hardly any law firms of what I'm told. The leading and the most prominent law firm was the J.B. Dada Chandji firm, which had a total of 3 partners. And there was a ceiling of 20 partners in any law firm, which probably we never reached in those times, probably 30 years back. From my personal experience, when I joined the bar, I remember about 17, 18 years back, I remember entering the High Court. It was just one building with 24 courts, and you could stand on the 3rd floor and monitor all your courts at that point of time. Something like this you can definitely not do today. So this is how our practices were in the past. Now moving on to the second theme, which is how we practice the law now. how do we practice the law now between you and I? The practice has definitely diversified. What has substantially changed is that while litigation plays a prominent role, the non-contentious matters, cross-border work has substantially increased and probably to some extent occupies an even more prominent role. They might sound similar, contentious, non-contentious, but we all know that they operate in completely different spheres, requiring completely different skill sets and dealing with a completely different clientele. Let's talk about contentious first. A lot of us who are contentious lawyers here understand that now there are many district courts. Previously there would be just one, now we have multiple district courts, specialized tribunals, the High Court has so many wings, the Supreme Court has expanded into more buildings, and the practice has just spread over the past 20 years. The bar has expanded, it has become so large, there are younger lawyers, older colleagues, senior lawyers, and even if you want, you cannot know everyone at the bar because it has become so huge. Moving to non-contentious work, it's mostly driven by the client's commercials. There are hundreds of law firms with hundreds of lawyers in those law firms, and the practice now is that while you are working in that law firm, and if, example, there are 150 lawyers in the law firm, you may not be interacting with all the 150 lawyers. You have your own team, you have your own team of 20, 30 lawyers, you're developing your own skill set, you have a reporting partner, a senior partner. So while you are there in the law firm, but you're working with your own team. So that is why at that stage, platforms like SILF played a very important and prominent role because 25 years back, they developed a platform for getting all these law firms together, providing them a platform, discussing the legal issues, the commercial issues, and giving them a stage and a platform and a sense of cohesiveness, which was probably not there previously. To conclude this theme of the present, I must say that the profession today offers many opportunities, but with it come many challenges as well. There are multiple opportunities for younger lawyers, but because the competition is so fierce, you need to place yourself at the right time, at the right position at the right time. You need to be aware of where you want to go and position yourself in that skill set, in that law firm, whether you want to go in-house, join a counsel, a junior counsel, position yourself and then follow the path. Because as they say, as long as you're on the right path, no matter how slow you go, you will eventually reach the path. But the point is that you need to be on the right path. Moving on to theme 3, which is the topic, is about the future of law practice. Where are we going from the past, the present, to the future? I read somewhere, and it was a thought which stuck with me, that the way forward is not how the practice will change, it is how the lawyers will shape the change, which I think is actually is true and has a deep meaning, because the future is going to change, is going to develop the way we want it to change. And in my view, there are 2 aspects which are going to drive the future of law practice: technology and sectoral specialization. We've all talked about technology, the role of AI, ODRs, online hearings, code digitalization. It's a topic which has been probably part of every conference for the past 3 years. Every conference has a panel discussion on AI, and there was one in the morning also. So we all know that technology is going to drive the future. So to be a good lawyer, you don't only need to know the law, you need to know the technology and how to use the technology. And the fact that it is a moving target. You cannot sit and say, fine, I've understood, I know. It's a constant upgrade. And as a lawyer, you need to develop this skill set. And unless one has mastered this skill set, you're not a complete lawyer. I'm told I have to finish quickly, so I will move on to my second topic of sectorial specialization. The figures Mr. Anand gave of how wide and how the legal market has exploded and is going to explode more, that makes it very important for lawyers to have sectoral specialization, because today the client comes to you not only because you're a good lawyer, but also because you can provide them with the sectorial expertise. For example, when we do construction matters, the client comes to me and asks me, Ankit, do you know how to do the delay analysis, claim analysis, how to study the EPC contracts, the disputes? I cannot tell him I don't know. I need to know those things because that is my specialization. So that is what is going to be at the forefront. And this is what young lawyers need to keep in mind. Be apt, be adept with the technology, and also know that what sectoral specialization they are going to take and work on that. So to conclude, the future of legal practice is not merely about adapting to change. It is about creating the change. And I have seen a lot of young lawyers, interns who work with us generally. I see very bright and brilliant and young, amazing people. So we all know that the change which is going to be created by them, whether of the use of technology or specialization, is going to build an efficient, inclusive, and a globally competitive Indian market. Thank you.
Thank you so much, ma'am. I'm sorry for interrupting you. It's not in my hands. Hate the game, not the player. So, but I would request all the speakers to stick to the timeline. We have a very strict timeline now since the arrival of the Chief Minister. Now, I invite Mr. George Thomas to continue with the session. Please, sir. A round of applause for him as well. Thank you so much.
Hi. Good evening, everyone. So this is the topic for the day is Future of Law, Pathways Ahead. So I'll keep it short. I mean, I have two topics to discuss about. I mean, like Ankit said, I mean, we have to make the change. So I think for litigating lawyers, a significant change that can be implemented or encouraged would be mediation. So mediation as a method of dispute resolution is not encouraged, in my opinion, it's not encouraged as much. And these days the Supreme Court also is encouraging mediation. And mediation as a method of dispute resolution has been used primarily for family law related matters, be it matrimonial, succession, etc. But the same can be used for complex commercial transactions as well. The benefit of mediation, I mean, apart from it being cost efficient, etc., is also that the mediator is not there to adjudicate. The mediator is simply guiding the parties to arrive at a settlement. Both sides might have to sacrifice, both sides might gain, but mediation gives room for creative solutions, and it's not really bound by strict interpretation of law. And unlike litigation, which is adversarial in nature, mediation ensures that long-term relations, commercial relations, are also maintained by different parties, and it should be encouraged, in my opinion. The other aspect of the pathway ahead is the use of AI. Everybody is adopting AI into their law firms. They all have their case management systems, research portals, etc., which they are developing on their own. But however, one must be conscious of the data that is retained by AI and the risks associated with the same. The other aspect is about the large number of law students who are graduating from college every year. Like Mr. Anand said, the market is huge and there's a place for everybody. But the education system in our country should also bring about a change in the way legal education is imparted so that students are ready to face the real world once they come out of college. I feel a large number of students who come out of college these days, they are not ready or they're not equipped, and they have to undergo a crash course in a law firm or with a counsel's chamber to understand the realities of this profession. So legal education that way would need a significant sea change by the institutions. The other aspect of another method of dispute resolution is arbitration, which has been going on for decades. But now with the advent of technology, etc., you have an option of having online arbitrations. And more institutions should probably be encouraged to have more and more online arbitrations because they're cost efficient, everything, it's convenient, all documents, pleadings, etc. are on one portal, easily accessible. It also saves a lot of time, money for the clients, and it's also extremely time efficient. And being time efficient, I'm just going to cut my speech a little short, so that since we're all a little behind, and these are the pathways ahead in my opinion. Thank you.
Thank you so much, sir, for making my job easier. And now I invite Ms. Nandini Sharma on stage to conclude this session. Please welcome Ms. Nandini Sharma on the stage with a big round of applause, everybody. Thank you so much.
Nothing is static. Change is inevitable. As lawyers, we are not strangers to this truth. In the moment of change, we can either move forward into growth or step back to safety. But here's a pertinent question I ask. Does the future of law practice offer any safety space? I doubt it. A very good afternoon, esteemed guests. SILF President, Dr. Lalit Bhasin, I believe he is outside. Senior members of the bar, SILF members, my co-panelists, ladies and gentlemen. Laws are like sand, constantly shifting, adapting, and evolving. The inherent nature of law makes us lawyers agile, but the pace of change we're witnessing today is unprecedented. Technology, especially adoption of AI, in every possible spectrum of life, seems to be rewriting the rules, pushing us to adapt at a speed we've never seen before. Legal profession, in fact, is on a cusp of revolution, and we cannot become just spectators. We have to be architects of future. We can't just watch the future unfold. We have to build it. We have to shape a future that's inclusive, innovative, and empowering the next generation of lawyers. Of course, the future of law practice in India will be shaped by technology law, data privacy, and cyber security. The increasing adoption of artificial intelligence, blockchain technology will require lawyers to develop specialized skills in these areas. Additionally, the growing focus on sustainability and ESG issues will create new opportunities for lawyers to advise on green financing, climate change, and corporate social responsibility. For example, global green bond market is projected to reach over $1 trillion by 2030. Green financing in India itself is projected to grow at a rapid scale. To thrive in this new landscape, Indian lawyers will need to stay responsive, innovative, and committed to lifelong learning. As India continues to emerge a major player on the global stage, the legal profession is poised to play a critical role in shaping country's economic and geopolitical landscape. With India's growing influence, cross-border transactions and international trade is likely to increase, leading to rise in multi-jurisdictional disputes. With some countries becoming protectionist, new trade opportunities will emerge, necessitating collaboration with lawyers in these evolving jurisdictions. Moving to what drives us every day. Serving our clients and the evolving needs is what always takes center stage. Clients today are demanding more value, multidisciplinary, and even business advice, expecting lawyers to be their strategic partners, not just legal advisors. Lawyers will need to super prioritize client needs, offering innovative solutions and flexible fee structures.
By harnessing AI tools and embracing technologies, we'll be able to enhance efficiency, accuracy, and time management. Another aspect is the growing demand from clients to manage litigation costs effectively. A new breed of clients, unlike their corporate predecessors, no longer relies on a battery of lawyers to defend them in courts. Instead, they seek effective, innovative, and quick resolution of disputes with efficient cost management. In fact, the growing preference for debt collection agency over lawyers stems from the rising cost of litigation and corporates' reluctance to fund their litigation. This trend may also catalyze the growth of institutional mediation, offering a cost-effective alternative to traditional arbitration. For clients in multiple jurisdictions, developing expertise in international law, trade, cross-border regulations, and emerging areas will be essential. This, coupled with cultural competence, language proficiency, and the ability to collaborate globally, supported by real-time translation tools, will be vital. The future will demand not just specialization, but a multidisciplinary and possibly a multilingual approach. To sum it all, adopting technology, upskilling, and becoming multidisciplinary will hold keys to bright future. But at the same time, driving innovation in lawmaking will be equally important to stay ahead of the curve. Take cryptocurrency. It brought cross-border issues to the forefront, catching many of us off guard. The same applies to data protection and AI. The AU law on data protection and AI may seem game changers, but as AI disrupts industries, new questions emerge. Who's liable for AI-driven decisions? AI is only as good as the data they are trained on. What if the data they are trained on was not accurate, they were biased, or they infringe copyrights? Can the law just play catch up? No, I think as lawyers, it's imperative that we shape the narrative, lead the transformation in law to anticipate and address the challenges. India has long adopted a wait-and-watch approach to regulating emerging technologies and framing laws. But with emerging technologies transforming industries, we are bound to see chaos and disruption. It's time to move beyond this approach. India needs a comprehensive AI policy, a regulatory framework, and laws to handle the legal issues that are already cropping up. It's time to be proactive, not reactive. Last but not the least, the future of law is just not about us. It's about the lawyers who will inherit the profession. As we navigate through this new landscape, we must not forget the responsibility to the next generation of lawyers. The sense of belonging to a larger community and our duty towards it is a vital aspect of our profession. I recall my first mentor, Mr. Atul Desai, who embodied this spirit. He often proudly introduced me to the other lawyers he had mentored, who even after many years held him in high esteem, having built flourishing practices of their own. His message was clear. As lawyers, we are duty-bound to mentor and train the younger generation, empowering them to become good lawyers, if not great ones. Somehow, in our drive to build practices and generate revenue for our law firms, we forget the crucial mentorship is to our profession. We cannot forget the importance of giving back and paving way for the next generation of lawyers. We need to create a culture where experience and knowledge is shared, where young lawyers feel valued, and where they grow without the fear of exploitation. The mental health of young lawyers is again a pressing concern. The pressure to perform, long hours, and high expectation can take a toll. As senior lawyers, it's our duty to ensure that younger colleagues work in a healthy, supportive environment. Let's work together to create a profession that's inclusive and a future where old and young lawyers alike can thrive, innovate, and make meaningful impact. The pathways ahead are clear. By adapting and embracing change, leveraging technology, prioritizing client needs, formulating the laws which are the need of the hour, and nurturing the next generation, we can build a future that is exciting, challenging and full of opportunities. Quoting Austrian author and consultant Peter Drucker once said, "The best way to predict the future is to create it." So it's time to seize the moment, adapt, and stay ahead. Thank you all.
Thank you so much, ma'am. And this concludes this session. And now I would invite Ms. Neena Gupta on the stage to felicitate all the speakers. A big round of applause for Ms. Neena Gupta. The first memento to Mr. Praveen Anand, obviously. So I request Ms. Neena Gupta to give the memento to Mr. Praveen Anand. Please, ma'am.
I'm representing Dr. Bhasin, actually. He's busy with some interview.
You are a force of your own, ma'am, so I'm sure. To Ms. Ankit Khushu. To Ms. Ankit Khushu. A round of applause, please. To Ms. Nandini Sharma. And finally to Mr. George Thomas. A big round of applause, please. I can clap with one hand, sir. Thank you so much, ma'am. Now I would request all the panelists to return to their seats in the audience so that we can proceed with the next session. Before that, I feel the energy of the room is a little dull since the CM left, but no love lost. I am here. So I'll tell you a joke to keep the energies high before we start the next session. In 2006, the Bar Council of India had passed a resolution deciding that no advocate will address judges as my lords or your lordship, but as we all know, it is not usually followed in the practice. A few months ago, an honorable judge of the Supreme Court said that if you stop saying my lords, I will give you half of my salary. And for that, to which a senior lawyer standing in the courtroom replied, probably Mr. Praveen Anand, he replied that for half of your salary, I apologize, my lord, but I made much more than that this morning itself. Meanwhile, a junior lawyer intervened and said, for half of your salary, I'll call you anything you want, daddy. So with that, we start with the next session, which is law and economy. I invite on the stage Mr. Neeraj Sharma, Ms. Sharmila Upadhyay, Mr. Samar Singh Kachwaha, Ms. Mamta Ranija. Please come to the stage for this session. It will be an interactive session and it will be like a conversation if you've heard of a podcast. It will be something like a podcast on a stage. We'll provide you with the mics and so that you can conduct this session on the special request of Ms. Mamta Rani. Please come on the stage. A big round of applause for everybody. Thank you. Mics. I welcome the panel for the discussion on law and economy. And these two things are very intertwined, and I'm not good at any of those. So please, I hope after this session, I'll be able to pick up some pointers. And I request everybody to, because it's not an individual session, it's more of a discussion. So you can start discussing. Anybody can take the lead, and I would request Mr. Neeraj Sharma to take the lead because his name is written on the list first. Thank you so much.
Thank you so much.
all the distinguished guests here, Mr. Bhasin, thank you for organizing and share one anecdote that 25 years ago, I was witness to Mr. Bhasin writing the Constitution Society with his own hands, and I also had the privilege of typing it out for him. I learned his handwriting better because of that experience more than most people. But it's been an honor and a privilege to be a part and a member here. The topic that we have now here today for this panel, and just by way of introduction, it has a large canvas, and having studied law and having studied economics, at that time, I don't recall making this connection which seems so obvious today, that possibly one would not exist without the other. There would be, areas and branches of law which would not exist but for economics, and possibly vice versa as well. And in the course of this evolution, what I found was that there have been many instances where law and economy have intertwined, have contributed to each other, and in fact, except for those core constitutional principles of human dignity and equality and so on and so forth, possibly most of the laws that we all deal with today have some economic implication or are relatable to what we call the corporate law practice. These are all, in that sense, rooted in some economic activity, and the regulation of those economic activities is what probably is leading to the fastest growth of various branches of law. But looking back, possibly from Arthashastra in India to maybe Hammurabi and his code of the past, one finds that laws have always been to subserve, protect, and to propagate some economic activity, without which there would be no order. So social order and economic order have been the reasons for most laws that we deal with. So, for instance, the earliest laws probably we all imbibed was maybe the corporate law principles dealing with contracts or with specific relief. And these are all issues which deal with commerce and economic activities. Given that background, I think, Mamta, if I can start with you, because I think you have a specific focus on intellectual property. And that has become a very vital part of economic activity, because there is no economic activity without a brand, right?
Thank you, Neeraj, and thank you for introducing the subject. Thank you, Dr. Bhasin, and congratulations to all of us for this 25th year celebration. Yes, you're absolutely right that intellectual property right play a very significant role in the national economy. We all know the creativity by a writer or anybody else, even the scientist, brings a lot of economic value to any commodity or any services which we use in our day-to-day life. We can see, for example, the infrastructure, the electronics, the Wi-Fi system, phone, anything. This is all a culmination of innovation which is happening every moment around us. So therefore, intellectual property, which is again a very important kind of property, plays a very significant role in the national economy and growth of the country. Now in this digital era, when we are trying to do a business, any business only flourishes when there is a trust in the system, a trust with the consumers, and trust that if you invest money, it will multiply, it will give you some profit. Now, how do you build that system? And from the, ancient time, there was legal system where you will be rewarded for the investment you have made, and your money will multiply, nobody will take it away. If somebody is taking it away, that person will be pulled down to compensate for you. And this is what we call now the legal system. Now, the legal system has really grown multifold because we have two kinds of law, static law and the dynamic law. Static law is what is conventionally we all have, all the legal system which we have, the contract law, the competition law, the all other evidence act, and all of that. But dynamic law is what is made the difference in this current digital world. And the dynamic law is in the nature of what is happening right now, you can protect it immediately. And I will talk it later, but just to give you a flavor, that India is the third country in the world after Singapore and Milan, which has passed dynamic injunction to prevent counterfeit online, any kind of online counterfeit can be stopped, any kind of unauthorized live streaming can be stopped immediately. In fact, we have gone even ahead by passing orders, the court have passed the orders of dynamic plus injunctions where the future copyrighted work can also be protected by not copying by unauthorized persons and meant money thereof. So intellectual property has really created an ecosystem, and courts have really tried to emerge and give a dynamic solution to these issues. But I'll talk little later till I think my colleague Samar will like to comment upon how other practice areas are contributing to the economy.
Thank you so much, ma'am. And thank you to the SILF for inviting me here today and really coming up with this very interesting topic, two fascinating subjects, law and economy, and how deeply intertwined they are. As Neeraj sir rightly said, without economic progress, without society progressing to the level that it has, we would not have required half the laws that we have today. And at the same time, without the laws that we have to protect ourselves, without law, economics would probably not have progressed beyond the stage of us being hunter-gatherers, because you need law to protect the fruits of economic incentives, to protect the fruits of your investment. You need intellectual property laws to protect your innovation, to incentivize innovation. And when I first saw this topic, my mind immediately went to Adam Smith, his 1776 book, so aptly titled, An Inquiry into the Nature and Cause of Wealth in Nations. And it took him 17 years of working on that treatise. And what that shows us is that there is so much beyond the availability of natural resources that leads to the wealth of a nation. And we have examples of countries like Venezuela, Brazil, who are blessed with such good economic natural resources, but having such stark poverty. And on the other hand, countries like Singapore, which may not have the most fertile lands, which may not have great landmass or significant natural resources, but attracting foreign investment, which is much more than a lot of developed nations combined. So Adam Smith used a very interesting phrase in his book. He said there's an invisible hand. So when we talk about the growth of nations, when we talk about wealth, economic wealth, we imagine buildings, skyscrapers, metros, airports, but behind all of this visible infrastructure, there is an invisible hand. And that invisible hand is a strong, predictable legal framework. Without a strong, predictable legal framework, there will be no credibility, no trust, and no incentive for businesses, whether domestic or foreign, to come and invest. And I think that our Prime Minister has set out an ambition of us being a $10 trillion economy in the coming decades. And I think that is truly our potential. Our people have the energy, we have the talent, we have the capabilities. But to really achieve that, we need judicial reforms, we need legal reforms. We've had a lot of legal reforms in the last few decades. The amendments to the Arbitration Act, the amendments to the Code of Civil Procedure, the Commercial Courts Act, decriminalization of many minor economic offenses, the Insolvency and Bankruptcy Code. So, but these legislative innovations and initiatives, at times they're not able to achieve their objective because everything gets stuck at our courts. When a client comes to us, having practiced in the courts for over a decade, now 15 years, we are not able to predict how long it will take to enforce your contractual rights. As per the World Bank report, in India it can take about 4.5 years to enforce contractual rights. Many of us who have been practicing in the courts know that that is a very optimistic number. We cannot guarantee to our client that we will be able to enforce your contractual rights in 4.5 years, because a Section 34 challenge to an arbitral award can last a decade, and a Section 37 appeal therefrom can last equally long. So I will come back to this in the second round when I deal with what more we can do, but that's, I think, enough for an introduction for now.
Thank you, Samar. Just added, the Commercial Code Act was enacted with the purpose that all the commercial litigation, the time frame is reduced from 4 years to 18 months. And once I was arguing before Justice Endlaw, and he said, justice delayed is economy reduced. You know, this was the words. And I was just thinking right now that this was so aptly described. Yes.
Sir, Dr. Bhasin, Madam Bhasin, everyone who's present here, thank you so much for giving me this opportunity. Very good start has been made by my friends, my fellow panelists. I want to add just 2 more perspectives so that we can talk about little later. One is that law is the backbone of economic growth. That is absolutely right. But then at the same time, I want to say that law firms are catalysts across all the sectors. And law firms have a great role to play when it comes to law and economic progress of any country. So I would request sir and ma'am to kindly touch upon these fields also, how law firms and law of any country are not separable. They work hand in hand, they progress hand in hand, and that is the reason we have so many new laws, and lot of obsolete laws have been deleted also. So madam, kindly talk about the role of law firms also, because we owe our existence to these law firms, and we also help and support in economic growth.
Sure. Thank you for raising this very important question of law firm practice area. As we know, law firm practice area is different from the individual practice. It is a collective practice. And the word itself explained, collective practice is far more stronger than individual practice. When you are practicing collectively, you are more inclusive. Your profit is shared. Your practice is shared. Your objective is shared and result is shared. So it's a collective celebration, and it contributes a huge amount of money and revenue to the government as well. I can tell you that most of the law firms are filing big tax amount, which is going to the revenue of the country and enhancing that, apart from bringing lot of legal remedies to the international client in India. We are able to provide world-class services, and therefore also bringing the Indian legal system at the forefront at the global level. So of course, the contribution of a law firm is phenomenal in the entire economy of this ecosystem.
Yes, madam, that is absolutely correct. And so far as our own Supreme Court is concerned, I want to mention Justice Sikri's judgment, where Justice Sikri has said that Shiv Shakti Sugar Mill's judgment, where Justice Sikri said that courts and judges must be aware of the economic implications of their judgments in with regard to economies as a whole and to various sectors where it applies. So I think this is my personal view, because I had prepared my speech with regard to a different perspective, and it's a very lengthy speech. But the topic which is running here is very, very crisp and relevant. And I think with each passing day, law's importance and role is becoming bigger when it comes to the economic growth or economic development of our country. With each passing day, the role of a lawyer as a person who contributes to the economic growth of country is increasing. We are becoming more relevant. Lawyers as a person becoming more relevant, because when it comes to FDI, when it comes to foreign investment in any form, setting up of a new company, it starts from a lawyer and it ends with the lawyer also. At any stage, at every step, legal knowledge is required. And lawyer plays a very, very important role. We are becoming indispensable. We are becoming relevant, more important. And I think as a lawyer, as a 100% litigation lawyer, I know things have changed over the years. I've spent 25 years in the profession, and I know how things are changing. Changes are rapid, and every 3-4 years we see a different phase of legal practice. And with each passing phase, with each new phase, with each new law, with new governments, and opening up of economy, we are becoming relevant, we are becoming important. And law as a catalyst, as a tool to economic growth is something which has come up as a new important thing, which has come up as a very, very relevant thing. And I think this must go on, this pattern must grow, and as a lawyer, as litigators, as persons who are associated with law firms, we have great role to play and a very bright future. Madam, want to say something?
Samar, you touched upon something I think which is very relevant and, yes, please. So Samar touched upon something in his opening remarks, which I think is, an area of focus that we all need to delve on. We all, as I said, as members of the society, we deal with corporate law, we deal with the economic activity related laws. And one of the issues that has arisen time and again is the assessment of the economic impact of both legislated law, but perhaps more importantly, the interpretation of that legislative law by courts. So, for instance, say in 2012 or thereabouts, when we had the 2G judgment, it had a huge economic impact on a very vital sector. Reviews were filed, they were dismissed. Even as late, I think, as in 2024, more than a decade, there was another attempt for some clarifications to be taken in respect of those judgments, but nothing came of it. On the other hand, in contrast, now we have a more recent judgment of a revival of a steel company, where the Supreme Court, having passed a certain judgment, then reviewed the judgment in a more pragmatic manner. And rather than overturning and understanding the economic analysis which was put forth in the arguments and submissions, appreciated the fact that, you cannot really have a U-turn in processes like the IBC. Now, that is a pragmatism that we've witnessed in the judicial process, but what Samar, you touched upon it, so if you wish to please elaborate a bit, that what exactly can be done in the process when we address ourselves to these issues, whether in litigation or whether as corporate practitioners. How do we introduce the economic impact and its analysis into our submissions, into our advice to clients maybe as lawyers and as law firms? How exactly do you think that we can expedite this?
Yes, sir. Thank you so much. I think that's a very, very vital point, because unpredictability is the enemy of investment. In investment, economic growth needs a predictable framework where we as lawyers can advise our clients what shall happen. How long it will take is perhaps a little too ambitious for us to aim at immediately, but it's very important from the client's perspective, because they want to know how long will it take, and you can't say it depends. But unfortunately, we are in that position. But going more to what you touched upon, the instances which you mentioned, the Bhushan Steel's case, that was, I think, a very, very important move by the Supreme Court, albeit an exercise of review jurisdiction, because it signaled that even at the stage of review jurisdiction, the Supreme Court will set aside its own judgment, will review its own judgment to bring back what the statute mandated, what a person who invested his money was looking at from a pragmatic and practical point of view. Somebody who, the successful resolution applicant, were not looking at what the pre-reviewed judgment said. At the same time, we had a recent instance where in curative jurisdiction, the Honorable Supreme Court set aside an award. Now, I do know that it's a 7,000 crore award, and reading the curative judgment, yes, the Supreme Court definitely had a point. There was one clause which had been ignored by the arbitral tribunal. But the very fulcrum of arbitral jurisprudence is that even if an award is wrong, the courts will interfere with it in only very limited and specified circumstances. So if an award has crossed the section 34 threshold, it has crossed the section 37 threshold, it has been affirmed by the Supreme Court, it has been affirmed in review, if it can be set aside even at the curative stage, no matter how wrong it may be, or what the financial implications it may have, it sends shivers down the spines of people who hold arbitral awards, who are counting on arbitral awards, and who have invested or who have participated in arbitrations in this country with the good faith belief that awards will not be interfered with until and unless those very specific circumstances are made out. So I think we need to have a very, very predictable structure where we can, as lawyers, be in a position to at least advise our clients what will happen, what is likely to happen. You can never predict the outcome of a litigation, but at least you can give us to a certain degree of predictability or a certain degree of certainty what are the likely outcomes.
Yeah, one of the eminent speakers said that lawyers and law firms are the backbone of our economy and economic activity. I think this is a basic overstatement. That should not be the role of lawyers. Why does economy or development of our economic condition depend upon role of lawyers? Lawyers' role is limited to drafting, you see, at the initial stage. Drafting of the agreements, joint ventures, M&As, transfer of technologies. They transfer, they you see, apply their legal expertise in drafting that. After that, why should the parties look at the agreement? The onus shifts on the businessmen to carry on with the activities. Lawyers' role is minimal. It arises because your differences become disputes. And why should differences become disputes, particularly so far as the economic development is concerned? Therefore, role of legal profession and particularly role of lawyers, the law firms, should be limited to, you see, advisory work. Of course, if litigation is forced on you, you have to, you see, defend your client, whatever the cause may be. But to say that we are the backbone, I think law and economy should be a disconnect. Economy should not need law. Law is not a substantive thing in operation of economy. Law can be used as a regulatory measure. Okay, you have to apply, if you have more than 20 employees, you should apply for this provident fund, this and all that regulatory things are there. But law will not govern the economies. That basic factor has to be kept in. Our constitution does not use the word law. It only uses the word justice. In the preamble, justice, economic, social activity. Although this topic was chosen by me, but what I meant was that what will be the views of the eminent panelists if we were to substitute the word law with justice.
So, sir, as I started with that, the innovation and creativity, because they become part of the goods or services, which is like value addition to whatever you are providing, and that's where the protection of that and enforcement of that adds value to the economy. So it is an indirect role and not a direct role, as rightly being suggested by you, sir. That's very, very correct. I agree with you.
Sorry, one more comment I wanted to make about that Supreme Court judgment, Justice Sikri's judgment you mentioned, Shiv Shakti or something like that, yeah. That judgment, Justice Oak's judgment differed from that judgment. subsequent 3-4 judgments, Justice Oak differed from those judgments. But unfortunately, again, to add to the judicial uncertainty, a judgment by 2-1, it overturned Justice Oak's judgment, you see, and brought back Justice Sikri's judgment. So this sort of what Attorney General this morning said, there has to be a certainty, which is very vital. People should know what is the law. But not every 2 years or 3 years you keep on changing.
That's correct. So this is what Mr. Sharma had pointed out, that Bhushan Steel matter. This is happening. Fortunately, unfortunately, I'm not the one to comment upon, but since law is a living entity, it has to change with changing times. And that is what Supreme Court has been doing, because some of the judgment in mining matters have been overturned, keeping into the mind the changing nature of the society, of the state governments. I have been party to those judgments. So that happens.
Say, if I may just involve you in one thing that I was bringing up with the panelists, and of course we'll also have the benefit of your views. One way that I see that this is being balanced is, this trend of tribunalization, and I think the Supreme Court has just heard and reserved judgment on those issues, is to balance the judicial approach by having technical experts as a part of tribunals, so that there is an even balance. There may be certain aspects where the technicalities may prevail. In certain scenarios, the law or the judicial view may prevail. But is it something, sir, that you think that then can be replicated not just in tribunals, but in, say, the commercial court divisions? Because commercial courts are principally dealing with precisely this issue. And there is a statutory mandate that, for instance, infrastructure products, you will not interfere. There will be no injunctions, for instance. But is this an experiment which needs to go beyond tribunals and possibly start with something like the commercial divisions?
You see, there again the question of uncertainty comes in. Today the Supreme Court may lay down some law that yes, expert opinions are required. Particularly we have seen in the medical negligence cases, you see where Supreme Court says that the decision of the National Commission or state this is bad because they did not have the expertise to decide that. But when the matter comes to the Supreme Court itself, they decide those complicated medical negligence cases themselves without, you see, referring the matter to. While in the same judgment, they would say that we are not experts, but still we will pronounce on, if some expert opinion is there, they will set aside that expert opinion and substitute it with their own opinion. Therefore, that sort of uncertainty must go in order to give, you see, a semblance of reasonableness to the approach. And this approach has not been consistent so far as the Supreme Court is concerned. And tribunalization of justice, it is not the correct step. You see, tribunals, whether in the labor courts or industrial tribunals, 100,000 cases are pending. As I was telling my wife, Nina, that, rather she was telling me, I was not telling her, that she went to the courts, State Commission once, to the labor courts. There is no space for lawyers to sit because it is all occupied by files. Piles of files are lying there undisposed. So what is this tribunalization? You go to consumer fora, district forum, state commission, national commission. They can't decide the cases. You go to the High Court. It is my personal experience that case is listed at item 80, 90. So post-lunch, dates are given by the court master. Oh, honorable judge has no time. One can appreciate how many cases he can handle. But this is the system. You see what is happening, particularly in tribunals. Therefore, what is required is infrastructure has to be in place. Numbers have to be there. Some people said if you increase the number of judges, that will not solve the problem. I don't agree. If you have more If Delhi High Court needs 90 judges, then you must have 90 judges, you must have the infrastructure for 90 judges, and do away with this tribunalization. Tribunals are not meant to render justice. Justice can only by the courts of justice. And commercial courts and all, these are no exception. So one has to put back the emphasis on justice delivery, not you see just cases being dealt with.
But sir, there are many progressive changes and I can vouch for it. At least in Delhi High Court, I have done cross-examination where using the AI, the cross-examination is recorded then and there. The witnesses are not required to travel from abroad. There is a video conferencing. Now, I know that hybrid system of attending the court cases is also so relevant. We have achieved so much. Internationally, I don't know that there is any other country which is really allowing this hybrid system where your client can also attend sitting in any part of the world and can see. So that kind of transparency and technical revolution which we have brought in the judicial system, that needs to be celebrated. And coming back to Neeraj, your point that economic impact, I can tell you for the standard essential patent cases where the judicial system has now devised a pro tem order, which means a protective temporary order, that if you are using the technology of an innovator or a patent right holder, no matter how long the matter is going on, you first deposit a certain amount in court so that the rights are secured, even before the preliminary injunction issue is decided. So pro tem is before the PI hearing. So there are ways and means which the judiciary or the legal system is trying to put in place. They are trying to kind of match with the speed and meet the international standards. So we can't defy that. Of course, there is a lot to be done, which Dr. Bhasin is rightly saying. But these are welcoming steps. It's not that we are not progressing. We are progressing, but maybe we need to be a little faster. Thank you.
Just to add to that, I think, sir, a very, very valid point that we definitely need more judges and we definitely need to have the infrastructure to have those judges. And if I could just add 2 more points to that, other than more judges, I think case management and discipline, especially in the tribunals. We so often see in tribunals, in certain tribunals, I would not name them, judges are supposed to sit at 10:30, but till 11:30 there is no sign of them. Then you know that at 1 p.m. they will rise. 3/4 of the list is not even taken up. So I think that should just not be on. And I think there's great discipline at the district court level, also at the Supreme Court level. When it comes to the High Court, I think one thing that I've noticed is that, as you said, you may have item 80 and it will not reach, and post-lunch just a date will be given. I think we should have a system where they have to run through their list once, because your item 80 may have more urgency than somebody's item 13. But just because the registry has kept it as that, it should not be that before running through the list, a judge just starts hearing. And that matter goes on for 2-3 hours, and then the rest of the board doesn't even get a chance to say what their urgency is. Yes.
They run through the list once.
Yes. And as to the cost impact, I think there's been a recent study by Vidhi which says that our GDP can grow by 2 to 3% if we bring about better and more efficient contractual enforcements.
No, that's something that vexes all of us. 80 items or 100 items. I've even seen 150 items recently. And while the district court runs through the list these days, at least in Delhi it does. They call out all matters. If something is not to be heard, it's over, and you pass that, and then you actually concentrate on stuff that needs to be worked upon. But somehow the High Court in particular does not seem to follow that procedure. To my understanding, the advance list and the supplementary list was that the supplementary list will be matters which do not require detailed arguments and submissions. So you finish them off, and then you come to the main list, the advanced list, where matters have progressed to a stage where arguments and time is required to be devoted. But I think what's happened now is exactly the opposite, that your supplementary list takes you till lunch, and then you have a backlog of 50, 60, 70 advanced list matters, which they never reach. And I really don't know whether the High Court rules or the Chief Justice concerned can take the initiative, but I really don't see a reform except something which is coming from within, within the high courts.
You see, if at all some justice is being administered, that happens at the lower court levels. In the district courts, I have seen and I've experienced during 63 years of my law practice that a judge sitting in district court, whether it is Tisazari, Karkaduma, anywhere, he will dispose of and deal with 3-4 matters at a time. His Elmat, someone is recording the evidence, someone is giving the dates for where parties need, he is also hearing the arguments. 3-4 matters simultaneously being dealt with, and they are able to dispose of their list, you see, within the time frame. And Neeraj is right, you see, when he says this does not happen in the high courts. But high court, then you can't dictate to them. They are constitutional courts. They have to lay down their own procedure, their own rules. And Supreme Court ones need not talk about, because they are supreme, see, yeah.
But the Supreme Court has the highest disposal rate. 97% on every Monday and Friday. That you can't ignore. We have a Nyaya Ghadi outside Supreme Court these days, which shows how many matters are listed and age of those matters. And every Tuesday we have a special list of after notice matters, and most of the judges try to finish off those small, short matters. It's a good disposal rate these days. But otherwise, Monday, Friday, they have a very good disposal rate.
So another, another area actually of, public frustration is also that maybe a lack of empathy that an adjournment given by a court also has an economic impact. In several cases, when you have only 3 or 4 hearings and you have to wait for another 3 months or 4 months just to be heard on an issue, notices are issued or adjournments are given. Again, the commercial division actually is not behaving very different from what the old, civil suit procedure used to be. So the same civil procedure is being used, and the amendments to the CPC are being largely ignored. And this was one area of frustration. But another area also where I feel is that, the award of, say, costs, the award of damages is sadly lacking. I mean, one knows that what it costs a litigant to attend a hearing in court. But even if at all we come to a stage where the court sympathizes and says, yes, you are entitled to costs, the economic impact is completely lost. 5,000 costs, and that also maybe to the, to some committee somewhere. And but say, is there a way around eventually? Can the Society of Law Firms or lawyers as practitioners, can we do something? Because unfortunately, there's always one side to the litigation which does not mind protraction.
That is an area where the bar associations have to take the lead. That is the responsibility, because litigation lawyers are all part of the bar associations. So law firms have a very limited role to play, because they also then depend upon counsel to appear and all. And so many times cases are adjourned because of lawyers. Essentially, particularly if it is on per hearing basis, the fee, then the cases are adjourned. And so many times, judges are also not inclined to hear that. So they encourage lawyers to seek adjournment on one plea or the other. This is what is happening today also. Where is the system of justice?
In fact, if I'm not mistaken, I remember when I started my career, Mr. Nariman, Mr. Venugopal, they would prohibit you from saying that we seek an adjournment because Mr. Nariman or Mr. Venugopal are not available. Today, I think not only has that stopped, but I think, that plea is made by counsels themselves sometimes. So,
I have another perspective to this, because like in Supreme Court Bar Association, there was big uproar when Supreme Court registry stopped the letter of adjournment circulation system. So the bar had to press upon this issue and convince the court, the Supreme Court, that this system should be back. So it's all related. We can't say that it's about the court, it's about us also. Anyway.
Thank you so much. I think we
Sorry to end your party now because we are short on time, but that was
ahead
a very
of time, actually.
no, that was a very insightful discussion. As a practitioner in the Supreme Court myself, I always see that every day, and now I'm glad that this circular is back. Anyway, now I would like to invite Dr. Bhasin to give the mementos to all our speakers on the stage. And we start with Mr. Neeraj Sharma. A round of applause, please. Please show some energy towards. Ms. Sharmila Upadhyay. Mr. Samar Singh Kashwaha. And finally, Ms. Mamta Rani Jha. And with that, I request all the speakers to return to their seats in the audience. And finally, we come towards the last session of the day, which is, after the group photo, I'll announce the last session of the day. Thank you, all the speakers. Please return to the seats in the audience. Now, the last session of the day is titled, We Also Matter, the voice of emerging law firms. And for that, this is our final session, and it celebrates the voice of emerging law firms, the innovators, the risk takers, the future of India's legal ecosystem. I would welcome Mr. Mridul Chakravarti, Mr. Mukesh Kumar, Ms. Anku Khanna, and Mr. Sanchit Mathur on the stage, please. Mr. Mridul Chakravarti, Mr. Mukesh Kumar, Ms. Anku Khanna, and Mr. Sachin Mathur on the stage, please. I would request you to join us on the stage. Please, sir. Take a seat. Dr. Bhasin, I would like to invite you on the stage to join the panel as well. Yeah. Mr. Mridul Chakravarti is here. Ms. So now we will start with the session, We Also Matter, and Dr. Bhasin, please.
Excuse me. This is virtually like an open session. Open session, anyone who wants to say anything about this event, about the role of law firms, or what they feel about our system of administration of justice, they are most welcome. After our two eminent panelists here, they finish with their observation, then I would invite those of you who want to say or express some views, they are most welcome to do so, even if they don't belong to the young and emerging law firms.
Hello.
So I would request Mr. Midul Chakravarti to take the lead and start the session.
Good evening, everybody. Distinguished guests and Dr. Bhasin over here. So, when I learned about this topic to speak on, emerging law firms, and we are a voice who should carry some value or weightage within the industry. So, I would say this is something that was a raging talking point at one point of time for me when I had decided to go independent and then join hands with my very good friend, with whom now I have a wonderful boutique and a niche law firm. And yes, I see that the industry is growing every day. I see that the industry gives chance to even emerging lawyers, individual lawyers, group of lawyers who like to join hands and take the profession ahead. It's only up to us with our sincerity and with the hard work and whatever knowledge we can garner through our processes that we make space for ourselves. So please give me the opportunity to introduce myself. I am Ridul Chakravarti. I'm a senior partner in a law firm called Charter Law Chambers, which is based out of New Delhi. And we also have offices in Mumbai and Lucknow. And we are also joining hands with certain other people in some other states. So we practice, mainly our practice areas include the energy and the power sector. And on that topic that, we are emerging and we have some way to go. So I was having a discussion with my very good friend Hemant as to, the kind of milestones that we have been able to achieve over our course of 6 to 7 years of being together in the profession, and where we have been able to successfully litigate onto a host of issues, including issues where for a certain entity in Mumbai, we were able to secure a 7,500 crore project, which did not come through a bidding process under the Electricity Act, etc. So there are, host of issues, and I can say very small victories which mean a lot to us. And yeah, it's a learning process, and it's not a struggle, but it's a curve that we have to swerve on every day to make ourselves visible, stay afloat, and of course being relevant. I'd like to start with that.
I must also share with you that apart from their legal skills, they have excellent skills in playing cricket also. They have one of the best teams playing in the SILF cricket tournament, and they have been participating. So that is another thing, that apart from the law practice, you have to do something for your team and then to establish contact with the other law firms. It is like a camaraderie, you see, that you develop a relationship which goes beyond your own law firm. So, credit to you. Thank you.
Good evening, everybody. My name is Anku Khanna, and I am the managing partner of the firm, The Attorneys, Corporate Law Consultants, LLP. We started our journey it's now been 12 to 13 years, and in the year 2012, and we started with a small office, and then now today we have grown to 3-4 offices. Like we have an office in Delhi, Mumbai, Bangalore, Hyderabad, and a small office in London also. So that's our journey. I started my career with a corporate, which was Nestle, and from there I somehow, destiny threw me on the practice side, and I joined law firms, various law firms, and that was the journey. And one fine day, around 2011, I thought it's better to work for myself rather than, working for others. So that's how Attorneys came into existence. And we are a full-service firm, corporate. We do corporate litigation and IPR, and also tax structuring for our overseas clients. And today, sir, thank you so much for recognizing us as an emerging law firm, I would say. And yes, we have done some really good work in all the areas. I myself specialize in M&A, and I am really proud to say that my firm this year also did an SME IPO. So we entered into the capital market also, and all this while we were doing all kinds of M&A acquisition deals, merger deals. So this was my long time target to enter into capital market, which we were able to do so. So over to you, Mridul, again.
Thank you, thank you. I think I see some other young law firms represented here. Varun or Shivarti, would you like to say something?
I will take
Check.
Briefly.
So, Shivarti and me are the founders for RSD Bajaj Global. We recently got the Emerging Law Firm of the Year. Voice is audible? 1, 2, 3. So, Shivarti and me are the founders for RSD Bajaj Global, which is an emerging law firm, and we have grown a lot through the new economy. So, I would first of all want to thank Lalit sir, because I think SILF truly has been opened up to emerging law firms because of his vision. And I think that has helped a lot of young lawyers to contribute. One of the few, I think, for emerging law firms as a block, I just have one statement that is said, there is no idea, there is no force in the world which can stop an idea whose time has arrived. And I think the time has arrived for emerging law firms. And there are multiple factors for that. From the discussion on foreign law firms, to artificial intelligence, to, I would say, due to Lalit sir, the SILF committee on the foreign law firms interacted directly with the Cyril Shroff committee formed by Bar Council. There was a recommendation which I got an opportunity to speak on to permit investments in for law firms in India. For emerging law firms, capital block was the biggest resistance because a non-lawyer cannot be on the cap table today. But Cyril Shroff committee, as we speak, has recommended to Bar Council to allow private equity investments in law firm. The only roadblock was capital. I think that also has come together now. So I think what जो 70 साल में नहीं हुआ, वो अब हुआ है. And I think entrepreneurs in law, this is the opportunity to maximize it. Because with foreign law firms, M&A is a huge market, which we are already seeing. A lot of mergers, people will earn building assets. If you don't want to sell, you want to get private equity capital and grow it, that also is an option. And I think Sir's presidency in next 3 years is going to be crucial to define this. Because these are policy initiatives which he has enabled, but to convert them into law is going to happen in next 24 to 36 months. So sir, we'll require your leadership for the same is my submission.
I think yours is also a comparatively new, younger, emerging law firm.
Hi, I'm Nandini. I'm managing partner of MSS Law Office. We probably are the youngest member of SILF. We've just joined SILF around 2 months back. And of course, I started out with one of the oldest firms of India with Kanga. And then moving on to Delhi, I was with some mid-sized firms. Then I had an individual practice before I again joined a partnership. And recently, you know, probably co-founded my firm with my husband. He's the founding partner, Mr. Mudit Sharma. And yes, I would agree with my friend there that yes, capital is one of the biggest challenge for young entrepreneurs like us, because even when we were starting out, we were thinking whether we'll be able to get those clients. And there's a lot of issues with bigger corporates, the big firms who've already made it big, being the largest firms, the prominent firms, they can quote any fees and still get away. And I have had this my own experience One of our corporate rejected us because we gave a very lesser fee quote. I thought it's okay. Of course, we were trying to get into their league. We wanted to show that, yes, we are equally good and we'll perform better than your big league firms, and you'll know who's the partner involved. Sometimes you don't even know. You might approach a firm, it's given it to some partner in big firm, and you don't know how your case is being handled. Despite, giving enough, they were like, oh, they're quoting much lesser than the larger firm we've approached. So probably they not be good enough, or, but how do you make them understand that we're just trying to be competitive? Probably I'll be not be ending up making profits, but the thing is getting that work, being able to show in the market, yes, we are capable of doing it and we can perform. That's major one issue is, of course, I agree, is the capital, because that actually stops a lot of young professionals to taking the plunge and, having your own practices. Of course, you build it brick by brick. You cannot become from 2 persons to like 10 or 20 or maybe 100 in a day. It's a thing, and I'm experiencing that. But I'll say, abhi, I'm enjoying it. I feel good. Sitting across with major managing partners of major big law firms, you get to learn with them. You understand, and probably someday we'll even become one of the emerging firms of India. And all thanks to Mr. Bhasin to give us this opportunity to be part of the SILF and our opportunity to speak here today. Yeah. Thank you.
Sir, with your permission, I would like to add one thing.
Definitely. How can we stop GMR from speaking?
Thank you, sir. Thank you for this opportunity. And I think one of the... Okay, thank you. So, one of the point I wanted to mention is that while it's really good that young lawyers, they bring new perspective, they really add value because they are learn new things and they are part of the new ecosystem. The younger generation of lawyers have got a better training during their law college. That also adds up to their culture, and therefore it really helps. But one of the point which ma'am just mentioned, that the capital requirement, right? The working capital is one of the bottleneck for any enterprise to start with. So here I think we need to make up our representation to the Ministry of Finance that the banks and the financial institutions also support law firms and lawyers, which currently there is no such room for the young enterprises, law firms, etc. So I think this is one of the points which we need to take up with the Ministry of Finance. Yeah, I'm talking on behalf of all these emerging law firms.
Thank you. Thank you. I see some people from Newman. Anyone wants to say something? Come forward. Young people. Okay, after Shivarti.
Good evening, everyone. Thank you, Dr. Bhasin. Thank you, Neena ma'am. You build SILF with such consistency and perseverance that as an emerging law firm, it's a journey to witness within itself. And thank you for taking the decision of getting the emerging law firms under your wings, because it gives us the opportunity of a very supreme trickle-down effect to learn at the right time from the right people. And I think this is and we are in the profession of knowledge. And if we get a trickle-down effect for knowledge, I think nothing better than that. Thank you, sir. Thank you, ma'am. But from a perspective of a legal emerging law firms aspect, as a founder for RSD Bajaj Global, my 2 learnings, I'll keep it short because sir said to keep it short, is that we are in an era where capacity building has taken over relationship building in a big way, and emerging law firms being more agile and tech enabled is no more a leverage, but it's more than a leverage for a firm to grow in terms of aspects and client delivery. That is something which I think helps us as emerging law firm to cover the aspects of growing. And in terms of SILF's role in this, I think to be at the cusp of policy for not only the legal journey for all the 25 years that we are standing here for, but also being a very, very important part of opening the policy doors, including emerging law firms in the policy. And sir, your policies are really affecting directly the emerging aspects of the mushrooming of the new law firms in India, is something I'd like to say. Thank you so much. Thank you.
You want to say something?
Hi everyone, my name is Gurdev. So I'm an associate of Mr. Arush Khanna. We are Newman Law Offices. My partner had to rush, so I'll speak a few words on his behalf. So firstly, thank you to Bhasin sir and thank you to SILF for organizing this amazing event. And we as Newman, we are also an emerging law firm. And I believe there's nothing wrong with being an emerging law firm. You don't need to be at the top of the peak and sort of look down on someone. What matters is how, from where you make change, to make change in the first place. And obviously, emerging law firms matter. And I think SILF has given an amazing platform to all of the emerging law firms to make that change. So I think I'll keep it short. Like, I think I'm the most underqualified person to make a statement here, but yeah, obviously, ma'am. I'll get to that point at one time, but so thank you, sir. Thank you, everyone.
Thank you so much.
Now, I have one question from the two panelists here and Varun and yourself, Mrs. Sharma. One question. Have you developed that confidence that you will also one day become a fully recognized law firm and not just an emerging law firm in your own right? Have you got that confidence, will you, keeping in view your experience, which you have got now for a couple of years or several years? Have you developed that confidence? To me, that is very important to know. Or you feel that no, there is no way, all the big firms will always stand in your way, you can't progress. So I want your comments on that.
That's a question which will not have an answer one way, but yes, of course, this is an aspect where I personally can vouch for my law firm that yes, we are today competing and at several or in certain areas at par with the top law firms in the sector that we primarily practice in. And I am proud of that. It has taken a lot of hard work for us. And it's a thing that we strive for every day. So like some of my friends over here have talked about the capital. So I would also say one of the aspects or one of the assets that we develop is the intellectual capital. And that is something which is not restrictive. That is something which is very dynamic in nature and keeps developing. So it's all about the hard work. It's all about the hours that we put in, and also it's all about the repetitive learning that we do. So definitely, sir, yes, we are on the process. We are taking the steps, and we should be there in absolutely.
Yes, sir. To answer your question in one word, of course, I would say I am very confident, and what I feel is that this, categorization of large firm, medium firm, and small firm is very theoretical, because see, in our world, it's the client who is the god. We are all assessed by the client, by the work we do and the kind of response that we get from the client. the work speaks for itself, and if the client is satisfied, it means you are at par with the topmost lawyer. So what I feel in every work that I do, in every transaction that I do, I feel that I get that high when my strategies, my advice is accepted by the client, and they're happy that they have come to the attorneys and we are able to cater to their legal needs and we have provided them the best of the services. So that gives me a high, and so that gives me the confidence to move on. And I feel that I would inculcate that culture in my team. I do that kind of mentorship where every lawyer, every junior, every senior associate also believes in giving this kind of service, believes in giving, real value addition, unique value proposition to the clients who come to us. So that will, I think, of course, take the firm to the next level.
So, sir, if you give me the liberty, एक उर्दू कोट से मैं इसका जवाब देना चाहूँगा. समुंदर की शांति को देखकर ये ना समझना कि समुंदर में रवानी नहीं है. समुंदर की शांति को देखकर ये ना समझना कि समुंदर में रवानी नहीं है. उठेंगे तूफान बनके, अभी तक हमने उठने की ठानी नहीं है. So I think to now give it a corporatized answer or a proper answer, I would say, if you are a young founder of a firm, you are an entrepreneur. You are not only a lawyer. जो entrepreneur होता है, I feel he has passion. He has to be delusional. He has to believe he can capture the mountain. Otherwise, he's not the best entrepreneur. So challenge is, I've seen a lot of law firm founders still consider themselves as lawyers. You are not in a pure lawyer role when you are managing a firm. You are in a blended role of business and finance and law. Till the time you do not capture that, and an entrepreneur has to be aspirational, high-end. So we have to be at the cost of being delusional, believe that we can beat the best. Otherwise, yes, you can't, because we are running a very tough P&L. We are putting money behind our vision. So if we do not have that belief, we will never do it. We'll be employed somewhere or we'll merge with somebody. अगर वो confidence नहीं होएगा तो वो survival ही नहीं है sir. So वो at the cost of delusional मैं कह रहा हूँ, that confidence is there, and I feel today there are data points to support it, because I can get artificial intelligence to replace the talent cost. I can get capital courtesy 10% to a financial investor to build it. So because of the policy shift, the real market is there. And plus, the most important, I would always say, a law firm is as good as its client. So हमें client कहाँ से मिलेगा? I would say we are a 4 trillion economy, out of which 1 trillion is already the new economy. New economy is run by young entrepreneurs like us. They are not hell-bent to get the best firms. They want people, young people whom they can relate to. And we are winning because of that, because the client is ready to back us also.
I would agree with all of my panelists, young law firm entrepreneurs. There's no alternative to hard work, one, and of course the market is huge. And even in my speech in the previous session, I talked about there are going to be new emerging areas. So there's a lot to learn, and a lot to give back to the society, in the sense that you have to create this niche. I mean, the AI is, there's no law yet. I am actually striving that we need to actually start framing an AI law for India. I happened to meet at another event the secretary, one of the secretaries in the law ministry, and they were like, we are in the wait and watch game. I said, I think that's not the right thing. So, as young lawyers, young emerging firms, we can drive a lot of things if we could, help, kind of push the government somewhere to get in some new laws and become, develop a practice in those laws. So this is one thing, the emerging firms or the new entrepreneurs should look at. acquiring knowledge, reading, of course you have to read about these. How does AI work? What are the issues which are going to think? You have to start imagining things, how it will affect sectors. I think, for example, the clinical trials, it's going to affect the most, AI is going to affect the most. You will never know whether the clinical trial data is authentic or not, because the AI tool used might be biased or inaccurate. I actually wrote a paper by reading about it. So this is how it is. So we have to develop these skills, and probably as an entrepreneur, I think of probably capturing that kind of a market. If I can't get into something which I'm already doing, probably even create a market for myself, because I can be a front runner in some kind of area. So that's how I'm thinking of building up my confidence, or probably even expanding my area of work, just not what I've been doing since long, dispute resolution, and that's move ahead beyond that.
Hi, I'm Hemant Singh, Managing Partner of Charter Law Chambers, and my colleague and senior partner on the dais there. I would just like to add that, as my learned friend had said, the basic thing is hard work. So what emerging lawyers and emerging law firms have done is that they have worked so much, and that is how we are able to create an organization. And the clients know us. It's a small field. So I'll just tell one anecdote. It's a very big renewable house. So they asked me only one question. I know about you, but I only want one commitment from you, that each and everything will be seen by you only, because that access I have lost in the big law firms, because obviously they have grown bigger. They can't now then invest that much of time. So that is how they have the confidence, and the confidence builds. And now with small ticket matters, we are getting big ticket matters, because then they see that, these people have confidence, and they can do it. So that is how that is how we emerge, and we become bigger. And I am from the chamber of Mr. Sanjay Sen, senior advocate. He told me one thing when I was starting my own. He said, don't run after money. Run after work, money will follow. So that should be the motto. That's what I believe.
Anyone else wants to add something briefly? Okay, Hemantji, you are charter law, na? So you have already chartered your way now to becoming, a good law firm. But my suggestion to the young and emerging law firms is that try to go along with the already established law firms. I wouldn't call them big law firms, already those which are established law firms. Go hand in hand with them. They may not be claiming expertise in so many areas, because now this is an age of specialization. Therefore, you can supplement, what they are lacking, and they would welcome that thing. So this is what SILF can do, of promoting that sort of bonhomie, and camaraderie, and also supplementing, complementing each other's work. You will get some flow of work from them, because they can't handle. You will feel some big thing has come to you, which you can't handle. Therefore, you will approach someone. So go hand in hand with them without having any adversarial approach. It is co-opetition, cooperation and competition. That is the spirit which has to be developed. And Varun, cited Urdu, share and all that. So I will also end this session in the spirit of going together. Tera haath haath mein aa gaya, ke chirag raah mein jal gaye. हमें सहल हो गई मंजिलें कि हवा के रुख भी बदल गए. Thank you.
Thank you so much, sir. That was beautiful. And with this session ends. And I would like to invite Dr. Bhasin to now give the mementos to the speakers. To Mr. Midul Chakravarti first. A round of applause for that, please. to Ms. Anku Khanna. It is now my privilege at the end of this session, and which was the last session, it is now my privilege to invite a star icon of the legal fraternity, a face you've seen throughout the day. Ladies and gentlemen, please welcome Dr. Lalit Bhasin, sir, for the closing address of the ceremony. So, final closing note of NIDAR 2025 by Dr. Bhasin.
No, I thought we are not closing. The program still goes on. No. So I'm very, very grateful to all of you for having this intellectual exercise right from 9:30 a.m. this morning till now. It is time to also have some source of entertainment which will follow in due course. And of course, over drinks, although I don't drink, but some people may like to, you see, have their respective drinks. I will have a Diet Coke, which is my favorite drink. That is what my son Aditya also always recommends to me, that Papa, have a Diet Coke if you don't want. Okay. So all of you have been here. I thank particularly the universities, the academia. Professor Dave, grateful thanks to you. You have been here since morning, participating in all these sessions with your team. And so has been, you see, the Alliance School of Law and the Jagran Lake City University, besides one of the most important universities in India, the MIT Pune here, Purnima Inamdar professor, she is there sitting since morning, has come all the way from Pune. People have come from Bhopal, from all over, and not just come to participate, but just they have come here to show their strengths and weaknesses in their education systems. When I go to the law schools, at least 2 law schools every month I go all over the country. They invite me, nice of them to invite me. I do feel rejuvenated because new ideas come to me. I share my experience with them. They share their innovation with them. So it is like a two-way traffic. I do feel learned, more learned than you see when I go to the law schools. Sharda University invited me. MIT Pune, I've been going regularly. Gujarat Law School, MIT, Symbiosis, everywhere I go. SGT, that Professor Richa was here. So it was celebration of 25 years, which would not be possible without the help of the academia. So my very special thanks to all the law schools who have participated here. My gratitude is also to the very eminent panelists here. In the morning session, saw the learned Attorney General gave a speech where he appealed for introspection. A brilliant address by one of the most learned lawyers who's not just a lawyer, he's a jurist, you see, par excellence. He shared his views for the benefit of everyone. We had panels on artificial intelligence and 4 or 5 other packed program, and all were very, very successful in terms of quality and in terms of numbers of those who participated. That is a very, very satisfying experience for at least a person like me who has been heading this organization for the last 25 years, ever since its inception. I have told my members, now relieve me, you see, They say, no sir, you have to continue. Earlier they used to say, you must continue till the building is complete. So I told them, okay, now the building is complete, now I can retire from this position. They said, no, 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 sir, you have to make it functional and then you go to it. Now they say, we will go to it when we set up a mediation center for the benefit of the people here. I say, okay, we'll do it, whatever way we can contribute. So I thank particularly the Honorable Chief Minister, who gave a very elaborate, very intense, address, spelling out what Delhi should stand for. The commitment she made of giving us a clean Delhi, a prosperous Delhi, where every activity should flourish, including what she said was the role of the legal profession, the social responsibilities that our profession has, which we have been advocating as members of SILF. So all those who have not spoken, I thank them also for being a very captive audience. I hope you have enjoyed. You have taken home something from the inputs given in this meeting. So gratitude to you and to the organizer, that is the global legal time. Where is the Bharti? So our special thanks to Bharti of this Global Legal Times for wonderfully curating and putting all the arrangements in place to make this one of the most successful events in the history of SILF. That is our celebration of 25 years. So a lot of credit goes to this lady and her team. Yes, thank you. Like to say a few words? You can't speak? She held a very successful event recently in Dubai also. After that, she came to me that we want to host this. I said, wonderful. So thanks to you, Bharti, for all that. Thank you. Thank you. Thank you. Thank you.
Thank you so much, sir, and for sharing a message that brings both wisdom and purpose to the close of NIDAR 25. Your words remind us why this initiative matters and why our collective effort must continue long after today. Ladies and gentlemen, as we bring this remarkable day to an end, I would like to extend our deepest gratitude to every speaker who shared their insight, to every partner who supported this vision, and to each one of you who contributed to this event. Your time, attention, and enthusiasm, and whatever ChatGPT says. On behalf of the Global Legal Times team and the entire organizing team, thank you so much for being an essential part of this journey. We've had a long day of intellectual heavy weightlifting, but now we move to the final item on the agenda, which is closing reflections and cocktails. I have a feeling that this is the only session today where there will be no objections at all by the lawyers, by the bench or the bar, as you join me on the bar. So the formal proceedings now conclude, yet the evening continues because we're going to have a music session. We invite you to join us for cocktails and entertainment, which will start at 6:30, where you can unwind, connect, and celebrate the spirit of collaboration that defined this day. The reception area is now open, and we look forward to sharing a memorable close to NIDAR 25 with all of you. Thank you again for your support and your belief in our mission of NIDAR. We wish you a wonderful evening. I am Manu Abhishek Bhardwaj, signing off. Thank you so much. I have told all the jokes. That's all, folks. But maybe next time if you have a special comedy event, then I'll do a set for 30 minutes, non-stop. But I've told all my jokes before, so. The CM made a better joke than me, so I got a little insecure. So So I'll have to work on my comedy then, and maybe I'll be the CM Monday as well. Thank you so much. Thank you, everybody. Have a good night. Thank you. Thank you.
लाइट डिम कर दो
Hey, 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 hey. Chick. Chick, 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 chick. Hey, 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 hey. Chick, 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 chick.